I acknowledge the Ngunnawal and Ngambri peoples, who are the traditional custodians of the Canberra area, and pay my respects to the elders, past and present, of all Australia's Indigenous peoples. Almighty God, we humbly beseech Thee to vouchsafe Thy blessing upon this Parliament. Direct and prosper our deliberations to the advancement of Thy glory and the true welfare of the people of Australia. Our Father, which art in heaven, hallowed be Thy name. Thy kingdom come, Thy will be done in earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For Thine is the kingdom and the power and the glory for ever and ever. Amen. And I call the clerk.
Government business. Notice number 1. High Speed Rail Authority Bill 2022.
Call the Minister.
Thank you. I present the High Speed Rail Authority Bill 2022 and its explanatory memorandum.
I call the clerk.
First reading, a bill for an act to establish the High Speed Rail Authority and for related purposes.
I give the call to the Minister.
Thank you. I move that this bill now be read a second time. And I rise in introducing this bill to establish a High Speed Rail Authority as an independent body to advise on, plan and develop the high speed rail system in Australia. There has been very little action to progress high speed rail in Australia until now. The government is absolutely committed to establishing this authority to oversee the construction and operation of a high-speed rail network along Australia's eastern seaboard. The High Speed Rail Authority will reinvigorate work on this very important nation-building project, and Australians will no longer miss out on high-speed rail. The benefits identified in the former Labor government's comprehensive two-stage rail study were significant, not just in substantially reducing travel times, but also unlocking regional economies, providing significant employment opportunities and supplying a remarkable economic boost in the medium and long term. The study found that for every dollar of costs, there would be a return of $2.30 in benefits to society. The evidence has shown that without high-speed rail, Australia is missing out on significant opportunities, which is why the authority is being established. The authority will provide expert independent advice and work with the Victorian, the New South Wales and Australian Capital Territory and Queensland governments, local government and the private sector to drive this change. A high-speed rail network will revolutionise interstate travel in Australia, significantly reducing travel time to move between capital cities compared to other modes of travel. Imagine a high-speed train connecting capital cities from Melbourne to Canberra to Sydney to Brisbane, all across our regional centres through our semi-urban populations straight to our international hubs, with trips taking as little as 3 hours. We will no longer be behind the rest of the developed world when it comes to land infrastructure and technology. Japan introduced its first bullet train in 1964, France in 1981 and China introduced in 2003. Those countries have since grown their high-speed rail networks, increased their top train speeds and now celebrate annual patronage in the hundreds of millions on their high-speed rail networks. Let's get on board and give the Australian public a modern, efficient and high-speed rail network. A well-patronised high-speed rail service will assist us to meet our net zero commitment by providing lower ongoing energy and greenhouse gas emissions than interstate travel by air, and has an added benefit of reducing road traffic. Settlement patterns across Australia's east coast will be transformed, alleviating pressure on outer suburban areas and growth corridors in major cities. The construction of high-speed rail will secure significant jobs for the economy, impacting all Australians. Through Labor's National Rail Manufacturing Plan, administered by the Minister for Industry here in the chamber today, the Australian government will ensure that more trains are built here in Australia by local manufacturing, local workers, and that every dollar of federal funding spent on rail projects will go towards creating local jobs and providing a sustainable industry and a sustainable manufacturing industry in particular. This bill will ensure that high-speed rail is progressed in Australia, with the immediate priority of updated analysis and commencing work on an initial connection between Sydney and Newcastle. Once established, we'll begin work on planning and overseeing the construction of a reliable, safe, efficient and cost-effective high-speed rail network. As a statutory agency, the authority will provide independent and impartial advice on the policy and standards, develop business cases and secure corridors. Specific measures will be taken to prevent and reduce the environmental impact on surrounding land, and the authority will coordinate and consult with state and territory governments, industry, business and communities to enhance Australia's long-term trail investment. Faster Rail will continue under the authority. Whilst the National Faster Rail Agency will be ceased, its functions will be absorbed into the authority and the Department of Infrastructure, Transport, Regional Development, Communications and Arts to retain the existing capability and expertise and ensure that both faster rail and high-speed rail are delivered. High-speed rail and faster rail will help all Australians to secure jobs and to build a better future for our regions and to reinvigorate manufacturing in Australia. We know there is a very strong interest internationally and from the private sector with experience in high-speed rail. The authority will work with consortiums collaboratively and with transparency to investigate alternate funding and financing opportunities, including value uplift. The authority will also commence work to secure corridors now and not waste any opportunity. We have already, as a government, committed $500 million to commence early works and secure corridors for the rail connection between Sydney, the Central Coast and Newcastle. The government will continue negotiations with the New South Wales government on the allocation and other investment options to be identified between the Australian government and New South Wales government further down the line. As a government, it's expected that we serve the Australian community and that we improve the lives of Australian people. Establishing the High-Speed Rail Authority and investing in high-speed rail will improve the lives of all Australians and transform this country. The time is now. We need to stop procrastinating and start taking action to actually deliver high-speed rail. This is a long-term project with significant benefits, and it's not just about a political cycle, but rather a focus on Australia's future, and particularly the focus on our regions. A high-speed rail network along the east coast of Australia will truly be a transformational project that has the ability to touch the lives of all Australians. It's a project that has the support of the regions and cities of businesses and industries. Now is the time to complete transformational infrastructure projects that not only sets Australia up for the future, but also provides jobs and opportunities immediately. High-speed rail will be an economic game changer for the country and will improve growth, access and sustainability. It will provide countless social benefits long into the future and create broad economic benefits for our regional centres. The bill I'm introducing today will allow all of these things to finally happen in this parliament. We must not delay the Australian public any longer. Let's give our fellow Australians the bipartisan support to pass this bill to let the authority commence its work to make high-speed rail an authority and invest in our country's future.
The debate must now be adjourned. I'll give the call to the member for Page to move that the debate be adjourned.
I move that the debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. All of those of opinion say aye. Against no. I think the ayes have it. I call the clerk.
Government business, notice number 2, Counter-Terrorism Legislation Amendment, AFP Powers and Other Matters Bill 2022.
I call the Attorney-General.
Thank you very much, Mr Speaker. I present the Counter-Terrorism Legislation Amendment, AFP Powers and Other Matters Bill 2022 and the explanatory memorandum.
I call the clerk.
First reading, a bill for an act to amend the law relating to counter-terrorism and for related purposes.
I give the call to the Attorney-General.
Thank you, Mr Speaker. I move that this bill be now read a second time. Terrorism remains a real and enduring challenge for Australia, for our social cohesion and for the safety of individuals. We must protect Australia against immediate and developing threats and continue to build a more resilient and cohesive nation. To this end, this bill provides for the continuation of key counter-terrorism powers that ensure the safety and security of all Australians. The Emergency Stop, Search and Seizure powers in the Crimes Act, the Control Order regime and the Preventative Detention Order regime. The powers are currently due to sunset on the 7th of December 2022. The Parliamentary Joint Committee on Intelligence and Security conducted a statutory review of these powers during the term of the last Parliament and presented its report in October 2021. The committee unanimously supported the extension of the powers subject to certain amendments, including the introduction of additional safeguards. Due to the complexity of a number of the committee's proposed amendments and the need to consult with states and territories in relation to any proposed amendments to Part 5.3 of the Criminal Code Act 1995, there is not enough time before the end of the year to finalise the government's response to the committee's report and each of its detailed recommendations, draft legislation to implement the government's response, consult with and obtain the agreement of state and territory governments to draft legislation and introduce and secure passage of the legislation through the Parliament. This bill would extend the relevant sunset dates by 12 months so that there is sufficient time to consult on and then implement the government's response to the committee's bipartisan recommendations over the coming months. Such an approach strikes an appropriate balance between ensuring that agencies continue to have access to powers that are a critical part of Australia's existing counter-terrorism framework, on the one hand, and responding in a considered and appropriate fashion to unanimous and bipartisan recommendations of the Parliamentary Joint Committee on Intelligence and Security for more robust safeguards on the other. The government is committed to protecting the safety and security of all Australians by ensuring that law enforcement and security agencies have the powers they need to carry out their essential work. At the same time, the government is also committed to ensuring that all coercive and intrusive powers are subject to appropriate safeguards and oversight as befits a country committed to upholding and promoting the rule of law. The Emergency Stop, Search and Seizure powers in the Crimes Act ensure that people are able to respond consistently and effectively to a terrorist incident or threat. The powers allow police to request a person's name, address and other details. They allow police to conduct a search for a terrorism-related item and to seize such an item, and they allow police to enter premises without a warrant to prevent a serious and imminent threat to a person's life, health or safety. Control orders under Division 104 of the Criminal Code allow federal courts to impose an order that places certain obligations, prohibitions and restrictions on an individual reasonably suspected of involvement in terrorism activity. The conditions must be reasonably necessary and reasonably appropriate and adapted to protect the public from a terrorist act. Preventative detention orders under Division 105 of the Criminal Code allow a person to be detained without charge. These extraordinary powers can only be used where the AFP reasonably suspects an attack could occur within 14 days or in the aftermath of a terrorist attack to preserve vital evidence. Collectively, these AFP powers have been used sparingly since they were enacted. As at the 25th of August 2022, 23 control orders have been made since September 2014, when the national terrorism threat level was raised, including only one control order against a person under 18 years of age. no preventative detention orders have been made and no incidents have required the use of the emergency stop, search and seizure powers. Although these powers have not been used to date, this demonstrates that the AFP have been appropriately judicious in exercising these exceptional powers. I acknowledge and appreciate the ongoing and valuable role of the PJCIS in reviewing intelligence and security powers. The government looks forward to providing a comprehensive response to all 19 recommendations of the AFP Powers Review in due course. I also value the continuing partnership with states and territories in our shared efforts to protect the Australian community. The amendments to Part 5.3 of the Criminal Code have been approved by a majority of states and territories as required by the Intergovernmental Agreement on Counter-Terrorism Laws. This bill provides for the continuation of important counter-terrorism powers that ensure the safety and security of all Australians. They ensure that Australia's law enforcement agencies continue to be able to manage the evolving national security and threat environment while protecting individual rights through strong and effective oversight and safeguards.
The debate must now be adjourned. I'll give the call to the member for Page.
The debate be adjourned.
The question is that the resumption of the debate be made an order for the next sitting. I'll put the question. All those opinions say aye. Aye. Against no. I think the ayes have it. The call to the clerk.
Government business, notice number 3. Atomic Energy Amendment, Mine Rehabilitation and Closure Bill 2022.
Give the call to the Minister for Resources.
Thank you, Mr Speaker. I present the Atomic Energy Amendment, Mine Rehabilitation and Closure Bill 2022 and the explanatory memorandum.
And I call the clerk.
First reading, a bill for an act to amend the Atomic Energy Act 1953 and for related purposes.
I give the call to the Minister.
Thank you, Mr Speaker. I move that this bill be now read a second time. It is a long-standing legislative requirement that the Ranger uranium mine must be restored to a condition similar to the surrounding Kakadu National Park in the Northern Territory. For such an environmentally, culturally and historically important region, only the highest standard of rehabilitation will do. Today I introduce the Atomic Energy Amendment, Mine Rehabilitation and Closure Bill. This bill is the first step toward ensuring the unique environmental requirements prescribed at Ranger remain legal obligations until Ranger's rehabilitation is complete. Excuse me. When Ranger was established 40 years ago, it was envisaged a rehabilitation would take 5 years and be completed by January 2026, when current regulatory arrangements lapse. However, based on the best environmental science of today, it is apparent that Ranger's rehabilitation will take longer. Accordingly, the government is acting to extend Ranger's regulatory framework until the job is complete. The bill enacts a number of measures for securing Ranger's full rehabilitation and eventual closure. Firstly, the bill allows the mine's operator, Energy Resources of Australia, to transition to a new authority that permits its rehabilitation to be continued at Ranger beyond January 2026. This in no way reflects ERA's performance at Ranger. ERA has long been progressively rehabilitating Ranger and is well advanced with the task. For instance, one of the mined-out pits is now fully backfilled, with Mirarr traditional owners participating in the first revegetation planting. The reason for allowing a new authority is simply because more time is needed to complete rehabilitation. ERA acknowledges this, Mirarr traditional owners acknowledge this, environment groups acknowledge this. But the current Atomic Energy Act simply does not allow the government to extend ERA's authority. The bill will also enable progressive closing out of the site. This means that discrete parcels of land at the Ranger mine, some of which are relatively undisturbed, can transition back to underlying Aboriginal land tenure when ERA is deemed to have rehabilitated those areas. The Northern Land Council have asked that Ranger be progressively closed out so that Ranger's Mirarr traditional owners can get on country as soon as it is safe to do so. Recognising that the Ranger mine was established under controversial circumstances, it is equally important Parliament is clear about what this bill does not do. This bill does not permit the recommencement of mining at Ranger. It is entirely focused on rehabilitation and closure. The bill does not allow the standard or quality of rehabilitation that ERA must achieve at Ranger to be increased or decreased. The long-standing environmental requirements will remain in place. The bill does not reduce the long-standing liability that the Australian Government has accepted for Ranger's rehabilitation. The bill does not reduce or diminish the role of the Northern Land Council or the supervising scientist, both of which will continue to play critical roles in Ranger's rehabilitation, monitoring and closure. And also, the bill does not pose any regulatory implications for the broader uranium industry. The bill concerns only the Ranger site, since it is the only mine subject to an authority under the Atomic Energy Act. Many people today who were not around in the 1970s will not remember the history of the Ranger uranium mine. To say that Ranger was opposed by the Mirarr traditional owners is an understatement. Ranger became a flashpoint in the struggle of land rights, attracting national media attention and protests. And many people today may not appreciate that Ranger's history is also intrinsically linked to the Kakadu National Park, which, like the uranium mine of Ranger, was established without the agreement of traditional owners. Fast forward almost half a century later to March this year, in opposition we supported the long-awaited return of the remaining half of Kakadu National Park back to the 13 clan groups. This was a milestone in the unfinished business of Aboriginal culture and history in Australia. Now, in government, we are putting forward amendments through this bill that would take the next step toward the eventual return of Ranger to its Aboriginal traditional owners. This too will form part of the story of this country's unfinished business. In concluding, I wish to thank ERA, the Northern Land Council and the Gundjeihmi Aboriginal Corporation representing the Mirarr people for their very close engagement on this bill. Ranger's rehabilitation is a priority for all parties, and we look forward to seeing Ranger being a world-class example of mine rehabilitation. I commend this bill to the Chamber.
The debate must now be adjourned, and I give the call to the member for Page.
I move that the debate be adjourned.
The question is that the resumption of the debate be made and order of the day for the next sitting. I'll put the question. All those of the opinion say aye. Against no. I think the ayes have it. I call the clerk.
Government business. Notice number 4. Financial Accountability Regime Bill 2022.
I give the call to the Assistant Treasurer and Minister for Financial Services.
Thanks, Speaker. I present the Financial Accountability Regime Bill of 2022 and the explanatory memorandum to this bill and the Financial Sector Reform Bill 2022, the Financial Services Compensation Scheme of Last Resort Bill 2022 and the Financial Services Compensation Scheme of Last Resort Collections Bill of 2022.
And I call the clerk.
First reading, a bill for an act to provide for a strengthened accountability framework for financial entities in the banking, insurance and superannuation industries and for related purposes.
I give the call to the Assistant Treasurer and Minister for Financial Services.
I move that this bill be now read a second time. This Financial Accountability Regime Bill of 2022 establishes the Financial Accountability Regime, or FAR, which replaces and extends the Banking Executive Accountability Regime following a number of recommendations of the Hayne Royal Commission. The bill underscores the government's commitment to finalise the action necessary to fully address the recommendations of the Hayne Banking Royal Commission and implement measures that compel the financial services industry to act in the public's interest. Financial services executives make decisions that impact upon the lives of ordinary Australians who have no choice other than to engage with the system that they operate. As a result, the community reasonably expects higher standards and accountability and integrity of financial services directors and executives. The Banking Royal Commission revealed that in too many instances of misconduct across the sector and highlighted that industry practices often did not meet community expectations. These issues were frequently found to be systemic and part of a corporate cultures that can only be improved and remedied from the top down. The bill would establish the FAR with the same design specifications proposed by legislation introduced by the former government in October 2021, which lapsed when Parliament was dissolved. The requests made by the former Senate Standing Committee for the Scrutiny of Bills and the Senate Economics Legislation Committee were considered and have been addressed in the explanatory memorandum accompanying this bill. The FAR would extend the existing responsibility and accountability framework to the insurance and superannuation sectors to ensure that heightened accountability obligations are in place across the wider financial industry. The FAR ensures that where these community expectations are not met, appropriate consequences will follow. I'd like now to turn to the provisions of the bill. The FAR imposes heightened accountability obligations for prudentially regulated financial institutions, meaning banks, insurers and superannuation entities. These institutions are referred to as accountable entities within the regime. The FAR regulates directors and the most senior and influential executives of accountable entities. These individuals are referred to as accountable persons within the regime. The FAR imposes 4 core sets of obligations. First, accountable entities and accountable persons must conduct their business in a proper manner, which includes acting with honesty and integrity and with due skill, care and diligence. Dealing with the Australian Prudential Regulatory Authority, APRA, and the Australian Securities and Investment Commission, ASIC, in an open, constructive and cooperative way, preventing adverse impact on the accountable entity's prudential standing, and finally preventing breaches of certain specified financial services laws by their accountable entity. Further, accountable entities must ensure clear identification of accountabilities for accountable persons in the organisation across key areas of operation, and defer at least 40% of the variable remuneration of accountable persons for a minimum of 4 years. Variable remuneration will be reduced where accountability obligations are breached. Ensuring there are financial consequences for the accountable persons who do not meet their obligations will increase their focus on the long-term outcomes of their decisions. The FAR will be supported by the imposition of notification obligations which require accountable entities to provide APRA and ASIC with certain information, such as information relating to the responsibilities of their accountable persons or breaches of certain obligations by accountable entities or their accountable persons. Both APRA and ASIC will jointly administer the regime. They will have the power to disqualify accountable persons, investigate suspected breaches of the regime and direct entities to take remedial action and to apply to the Federal Court to impose a civil penalty on accountable entities. The FAR will apply to the banking industry 6 months after royal assent and to the insurance and superannuation industries 18 months after royal assent. Through this bill, the government is finalising the necessary actions to ensure that financial institutions are meeting the community's expectations and shifting their focus from profit at all costs to outcomes for all Australians. Full details of the measures are contained in the explanatory memorandum.
The debate must now be adjourned. I give the call to the member for Page.
I move that the debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. I put the question. All those of the opinion say aye. Against noes, I think the ayes have it. And I call the clerk.
Government business, notice number 5. Financial Sector Reform Bill 2022.
Give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. I present the Financial Sector Reform Bill of 2022.
And I call the Clerk.
First reading, a bill for an Act to deal with consequential amendments and transitional matters arising from the enactment of the Financial Accountability Regime Act 2022 to establish the Financial Services Compensation Scheme of Last Resort, to amend the National Consumer Credit Protection Act 2009 and for related purposes.
I give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. I move that this bill now be read a second time. The Financial Sector Reform Bill of 2022 is part of a package of bills that finalises a number of remaining recommendations from the Banking Royal Commission. It also delivers on the government's commitment to ensure safe and well-regulated consumer markets for credit products, such as small amount credit contracts, also known as payday loans, and consumer leases. It's disappointing that I have to introduce these measures here today. These measures all should have been implemented and introduced by the former government. In February 2019, the former Treasurer promised to deliver his response to the Banking Royal Commission within 2 years. Even with Labor's full support, the Coalition chose not to prioritise the measures contained within this bill that implement the response to the Banking Royal Commission. The measures relating to small amount credit contracts date back even further, back to a 2016 report that laid out a clear path for the government to act on payday lending for nearly 6 years. The Turnbull-Morrison governments failed to act on this report. These failures reflect the Coalition's continued unwillingness to stand with Australians against misconduct in the financial services sector. This is a coalition that voted against the Banking Royal Commission 26 times before finally acceding to it. Nevertheless, I hope that we are able to secure the Parliament and the Opposition's support to make the sensible measures that I'm introducing here today. Schedules 1 and 2 to the bill make minor and consequential amendments to various Commonwealth laws to support the financial accountability regime and to provide transitional arrangements relating to the repeal of banking executive accountability regime. Schedule 3 to the bill establishes a Financial Services Compensation Scheme of Last Resort, the CSLR. The government has committed to introducing a CSLR, and today we deliver on this commitment. This bill is part of a package of bills that establish and fund the CSLR. Speaker, in 2019, the Banking Royal Commission endorsed the 3 principal recommendations of the 2017 supplementary final report of the review of the Financial System External Dispute Resolution and Complaints Framework. A shorter and more easy title, the Ramsay Review, regarding the establishment of a CSLR. Now, the Ramsay Review noted the inadequacy of existing redress measures in ensuring all consumers are compensated for losses and recommended the establishment of an industry-funded and forward-looking CSLR that targets the areas of financial sector with the greatest evidence of need. The CSLR is designed to provide compensation to consumers who have received a relevant determination in their favour by the Australian Financial Complaints Authority, hereafter AFCA, where that determination remains unpaid. Claimants may receive compensation of up to $150,000 where they have an unpaid AFCA determination in their favour for the following financial services or products: personal advice or relevant financial products to retail clients, relevant financial products to retail clients, credit intermediation, securities dealing and credit provisions. Now, the cap on claims helps to maintain the ongoing financial sustainability of the scheme at the same time as balancing the interests of consumers. The operator of the CSLR will be a subsidiary of AFCA, limited by guarantee, and operate on a not-for-profit basis. The operator must act in line with the primary legislation and regulations, with compliance to be ensured by ASIC. The operator will be managed by a board consisting of an independent chair appointed by the Minister, a person who is a member of the board of AFCA, and an actuary who has at least 5 years of actuarial experience. The CSLR is designed to act as a last resort mechanism. After the claimant has notified AFCA that their determination remains unpaid, AFCA will be required, where appropriate, to take steps to ensure the relevant entity pays the compensation owed. The CSLR operator will also need to confirm that no other scheme is available to pay all or part of the compensation owed, including any state or territory arrangements. Measures have been added to reduce the inclination of financial firms from relying on the CSLR and to facilitate better compliance with AFCA determinations. For example, ASIC must cancel an AFCA member's Australian Financial Service licence or their Australian credit licence if the CSLR provides compensation to a claimant. The government notes the recommendation made by the former Economic Legislation Committee, which were tabled on the 15th of February this year, on the CSLR bills introduced by the previous government, including the recommendation to include managed investment schemes in the scope of the CSLR. There have been no changes to the scope of the CSLR, and the provisions being introduced today are substantively the same as those considered by that committee. The CSLR provisions have only been subject to minor and targeted amendments to reflect the passage of time and further stakeholder feedback. The scope of the CSLR reflects financial products that have a history of unpaid determinations and have been subject to significant regulatory reform, which have reduced the risk of misconduct. This is an important point. The government will continue to consider potential enhancements to the regulatory framework of managed investment schemes. If I could turn to Schedule 4 of the bill, which amends the National Consumer Credit Protection Act of 2009, hereafter the Credit Act, to strengthen the consumer protection framework for consumers of small amount credit contracts and consumer leases through the introduction of new obligations for providers of these credit products. SACs are loans of up to $2,000 where the term of contract is between 16 days and 12 months, while a consumer lease is typically a contract for longer household goods, longer than 4 months, where the consumer does not have the right or obligation to purchase the goods. These measures give effect to the government's response to the 2016 review of small amount credit contract laws, which identified a number of predatory lending practices that led to some consumers experiencing financial hardship. Key reforms, including strengthened caps on the amount of income a consumer can spend on repayments before they are ineligible to enter into certain contracts, credit products, I should say, caps on the cost of consumer leases, equal repayment intervals for small amount credit contracts, and finally prohibitions on certain types of unsolicited communications and referrals. Now, combined with anti-avoidance provisions, these reforms will enhance the existing consumer protections, including responsible lending obligations, while making sure that these credit products are more affordable and less harmful. The government acknowledges that most of these reforms will require some time for industry to implement, so the bulk of the proposed changes will commence 6 months following royal assent. The Legislative and Governance Forum and Corporations was notified of this bill as required under the Corporations Agreement of 2002 and the National Credit Law Agreement of 2009. Full details of all of the measures are contained in the explanatory memorandum.
Thank the Minister. The debate must now be adjourned. Give the call to the member for Page.
I move the debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. I'll put the question. All of those opinions say aye. Against no. I think the ayes have it. And I call the Assistant Treasurer and Minister for Financial Services.
I present the Financial Services Compensation Scheme of Last Resort Levy Bill of 2022.
And I call the Clerk.
First reading, a bill for an act to impose levy on persons relating to the AFCA scheme and for related purposes.
Give the call to the Assistant Treasurer and Minister for Financial Services.
I move that this bill be read a second time. This bill is one of two bills which form the levy framework for the Financial Services Compensation Scheme of Last Resort, hereafter the CSLR. The CSLR levy framework is designed to establish an ongoing annual levy for entities that fall under a subsector in the scope of the scheme. The framework will issue levies in advance of a financial year based on expected claims in that upcoming financial year. The first ongoing levy is expected to be issued from January 2024 for the 2024-2025 financial year. The first year of operation is 2022-2020. Sorry, I withdraw that. The first year of operation, 2023-2024, will be partly funded by a one-off levy issued in 2023-2024 financial year. It will be imposed on the 10 largest financial sector entities, including private health insurers and superannuation trustees. This will fund the payment of compensation and associated costs relating to complaints lodged with AFCA up to the date where the bills were introduced into the House of Representatives. The ongoing levy amount in the subsequent financial years for a member of an in-scope subsector will be determined in line with the regulations. The regulations will impose levies on members consistent with the approach applied under the Australian Securities and Investment Commission industry funding model. The levy will factor in compensation amounts payable, associated Australian Financial Complaints Authority complaint handling fees and administrative costs of the CSLR operator and of ASIC. The CSLR is designed to be financially sustainable and provide assurance to relevant financial market sectors about the maximum amount expected to be levied. The scheme applies subsector caps of $20 million and an overall scheme cap of $250 million. This limits the amount leviable within a single levy period, whilst maintaining the ability to accommodate any unexpected large-scale events or failures. The levy framework provides the Minister with the ability to issue special levies to in-scope and out-of-scope firms in response to any higher-than-expected outlays, such as a black swan event. Full details of all of the measures are contained within the explanatory memorandum.
The debate must now be adjourned, and I give the call to the member for Page.
I move that debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. I'll put the question. All those opinions say aye. Against noes. I think the ayes have it. I give the call to the Assistant Treasurer and Minister for Financial Services.
I present the Financial Services Compensation Scheme of Last Resort Levy Collections Bill of 2022.
call the clerk.
First reading, a bill for an act to provide for the collection of levy imposed on persons relating to the AFCA scheme and for related purposes.
I give the call to the Assistant Treasurer and Minister for Financial Services.
I move that this bill be read a second time. This bill is one of two bills which form the levy framework for the Financial Services Compensation Scheme of Last Resort. The one-off levy imposed for the first year of operation, 2023-24, will be issued by August 2023, and the ongoing annual levy will be issued in advance of each new financial year, with the first to be issued from January 2024 for the 2024-25 financial year. The CSLR operator will estimate compensation and AFCA complaint costs to be paid out in the upcoming financial year, as well as associated administrative costs. These estimates will then determine the total levy amount for each subsector to meet expected outlays in the upcoming financial year. Levy notices will be issued by the Australian Securities and Investment Commission. ASIC will also be responsible for the collection of levies and have the power to facilitate and enforce the payment of levies. These powers will include the ability to seek information from relevant firms for the purpose of correctly calculating the firm's levy, and to impose penalties for late payment, and to impose a shortfall penalty where incorrect information has been provided. Full details of the measures are contained in the explanatory memorandum.
The debate must now be adjourned, and I give the call to the member for Page.
I move the debate be adjourned.
The question is that the resumption of the debate be made in order of the day for the next sitting. I'll put the question. All of those of the opinion say aye. Against noes. I think the ayes have it. And I call the clerk.
Government business, notice number 6. Treasury Laws Amendment 2022 Measures Number 3 Bill 2022.
I give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. I present the Treasury Laws Amendment 2022 Measures Number 3 Bill of 2022 and the explanatory memorandum to this bill, the Foreign Acquisition and Takeover Fees Imposition Amendment Bill of 2022 and the Income Tax Amendment Labour Mobility Program Bill of 2022.
And I give the call to the clerk.
First reading, a bill for an act to amend the law relating to foreign investment and acquisitions, taxation, coronavirus and superannuation and for related purposes.
I give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. I move that this bill be read a second time. Schedule 1 to the bill delivers on the government's 2022 election commitment to double financial penalties that relate to foreign ownership of residential property in Australia. Non-compliance with the residential land obligations for foreign persons has flow-on effects for Australians, for Australia's housing stock and housing affordability. This increase to residential penalties will ensure that these penalties effectively deter foreign persons from contravening the residential land provisions of the Foreign Acquisitions and Takeovers Act of 1975. Schedule 2 to the bill amends the taxation secrecy provisions to enable the ATO to share taxation information with an Australian government agency, including states and territory governments, for the purposes of administering major disaster support payments. Now, this measure will assist Australian government agencies to address the needs of individuals and businesses significantly disrupted by a major disaster event more efficiently and more effectively. The sharing of taxation information will only be authorised if the Treasurer is satisfied that the program supports individuals and businesses affected by a major disaster. Schedule 3 to the bill extends the operation of a temporary mechanism that has been operating during the COVID pandemic, which allows arrangements for complying with information and documentary requirements under Commonwealth legislation to be altered, including requirements to give information in writing and produce, witness and sign documents. These provisions address continuing difficulties experienced by individuals, businesses and government agencies in complying with information and documentary requirements, including requirements to witness and sign documents. The mechanism is temporary. It will expire at the end of 2022. The effect of the measure will be to continue the operation of these provisions until the end of 31st of December 2023. Any determination made under the mechanism will cease to operate after the 31st of December 2023. Now, Schedule 4 to the bill makes amendments to set out tax arrangements of foreign resident workers participating in the Pacific Australia Labour Mobility Program, also known as the PALM scheme. The PALM scheme will help to meet workforce shortages in Australia, as well as support the economic development of Pacific nations and Timor-Leste. Under the new PALM scheme, eligible businesses can recruit workers to help fill unskilled, low and semi-skilled workforce shortages in any sector, including agriculture, meat processing, hospitality and tourism, but mostly in regional and rural areas. Schedule 4 specifies that resident workers participating in the PALM scheme will pay a final withholding tax of 15% for each dollar of income earned under the scheme from the 2022-23 income tax year. PALM scheme workers who are Australian residents for tax purposes will of course pay ordinary resident taxes. This ensures that such workers pay tax at an appropriate rate on program income consistent with similar migration programs. Schedule 5 to the bill will require the Australian Prudential and Regulatory Authority to take account of religious obligations when conducting the annual performance test on superannuation products. Trustees will now be able to apply to have their faith-based products face a supplementary test that considers their faith-based investment strategy if they fail the original test. A faith-based product that passes this supplementary test will not be subject to the consequences of failure. Faith-based products will not escape scrutiny under this amendment. Products will be assessed to ensure that their investment is in accordance with their faith-based investment strategy. Faith-based products that fail both the original and the supplementary test will face the same consequences as any other superannuation product. This measure was a 2022 Labor election commitment, reflecting Labor's commitment to working with communities of faith. In developing this measure, I met and I spoke with faith leaders around Australia. They spoke to me about the importance of being able to live their faith in every part of their lives. This is why this measure is so important. It will ensure that Australians of faith are able to participate fully in our superannuation system without compromising on their values or on performance standards. Now, I know that many Australians of faith are watching this today to see whether this parliament supports them. These changes to the performance test will strike the right balance. The amendments give members back the ability to invest in faith-based superannuation products while continuing to hold trustees to account for the investment performance that they deliver and the fees that they charge members. Full details of all of the measures are contained in the explanatory memorandum.
The debate must now be adjourned, and I give the call to the member for Page.
I move the debate be adjourned.
The question is that the resumption of the debate be made in order of the day for the next sitting. I put the question. All of those of the opinion say aye. Against noes. I think the ayes have it. The call to the Assistant Treasurer and Minister for Financial Services.
I present the foreign acquisitions and takeover fees Imposition Amendment Bill of 2022.
I call the clerk.
First reading, a bill for an Act to amend the Foreign Acquisitions and Takeovers Fees Imposition Act 2015 and for related purposes.
Give the call to the Assistant Treasurer and Minister for Financial Services.
Thank you, Speaker. I move that the bill be read a second time. This bill amends the Foreign Acquisition and Takeovers Fees Imposition Act of 2015, the FATA Fees Act, to align the indexation of fee cap under the Act with the indexation of fees in the Foreign Acquisition and Takeover Fees Imposition Regulations of 2020. As part of the government's commitment to double foreign investment fees and penalties, legislation was made to double foreign investment application fees from the 29th of July this year. The doubled fees amounts incorporate the cumulative total of indexation prior to the doubling. The bill amends the FATA Fees Act to similarly incorporate the cumulative total of the indexation for the same time period into the fee cap amount to ensure the fees and the fee cap indexation remain in lockstep. The fee cap itself is not doubled. Full details of the measures are contained in the explanatory memorandum.
The debate must now be adjourned, and I give the call to the member for Page.
I move the debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. I'll put the question. All of those opinions say aye. Against noes, I think the ayes have it. And I call the clerk.
Government business, notice number 7, remote participation in the Federation Chamber.
Give the call to the Leader of the House.
Thanks, Speaker. I move the motion relating to remote participation in the Federation Chamber in the terms in which it appears on the notice paper. Mr Speaker, this resolution is the next stage in an issue that I know is very dear to your heart and all members have a concern about, which is making sure that we properly respond to the various principles that were raised in Kate Jenkins' report with respect to the standards in Parliament House. And one of those key standards goes to us trying to make the place as family-friendly as possible. One of the issues that the pandemic took us to was for the first time starting to acknowledge that there can be reasons, quite legitimate, that members are not able to physically bring themselves to the chamber, and how do you make sure that you're properly representing your electorate during that time. Now, while the various lockdown reasons that brought TV screens into the chamber have passed and hopefully don't return, that has raised the question of can we do better when a member is in particular on parental leave? Can we do better when a Member of Parliament is formally given leave for a long period of time and that leave is because they can't in fact get to Canberra, but there are other ways in which they continue working during that time, and the circumstances mean coming this far is not possible, but is there a way of them still being able to formally represent their electorates? In consultation with members, there has been a suggestion that often the best place to make speeches about your electorate is not in fact here, but in the Federation Chamber, and that's where those opportunities often arise. And we don't want to and I think it's also fair to say that while we did our best during the lockdown period to find ways for people to make speeches in here through the screens, it doesn't work as well as ordinary debate in the chamber. So what's being proposed here is that we have a go now of presuming on a permanent basis that the screens will remain in the Federation Chamber, but they will only be available to members where the House has voted that the people have leave. And this is for two reasons. One, when we voted that someone has leave, it's usually for parental leave purposes, but sometimes it's because someone's really not well and they just can't travel here, but would be able to travel to their electorate office to be able to advance a speech about their electorate, that they'll be able to do that in the Federation Chamber. The the concept here is if someone wants to take a period of time off, and the Parliament used to only grant very limited time for people to take time off from sittings because there was a newborn in the family, well, we're now being more reasonable than we used to be in making sure that it's now a reasonable length of time. But the flip side is during that time, if someone can make a speech about their electorate, advancing the cause of their electorate from their electorate office using the Federation Chamber, shouldn't we allow it? So this is the next step in Parliament opening itself up in a family-friendly way. There's been good consultation as I've tested this idea basically since the election, both with the opposition and with the crossbench. I want to thank all members, including the Manager of Opposition Business, for their cooperation in this. It may refer further tweaking. We'll see how it goes. But effectively, the reason we've limited it to where people formally have leave, I don't want to create a situation where someone really could have made it here and then just starts to use this as a proxy for not making the trip to Canberra. But clearly, when the House has voted that someone has leave, we have all voted together, and I've never seen a division on one of those votes. We've all voted together saying this is a legitimate reason. If within that context someone now will have an avenue for the first time, even though they're caring for a newborn, to be able to make the trip to their electorate office and make a speech about their electorate to the Parliament, get it recorded in Hansard, and their electors get properly represented in that way, I think that's a really good step forward. It's not a huge step, but what it means, if someone's taking significant time off to care for a newborn, that time off will still allow them to have speeches recorded in Hansard representing their electorate, and I'd commend the resolution to the House.
I call the Manager of Opposition Business.
Thank you, Mr Deputy Speaker. I rise briefly to put on record that the opposition supports the motion moved by the Leader of the House, and I want to thank him for his collaborative approach on this issue. As the pandemic showed us, working from home is not necessarily an obstacle to productivity, and workplaces around our nation, indeed around the world, have adapted to this paradigm shift, and the Parliament should be prepared to too. Remote participation via a video facility in the workings of the Parliament is, of course, an innovation that began under the previous Parliament, under the Morrison government, as we collectively responded to the restrictions imposed by COVID-19. And before the August sittings of the Parliament in 2020, the then Leader of the House developed the agreement for members to contribute remotely to parliamentary proceedings in close consultation with the then Manager of Opposition Business, now Leader of the House. And so I'm pleased to see this bipartisan approach continuing in this Parliament with respect to remote participation. I do think that this change will allow parliamentarians in the narrow and defined circumstances that the Leader of the House has outlined to be able to effectively or more effectively represent their electorate, even in circumstances where they're unable to come to Canberra. I think the limitation to members who have formally received leave is an effective mechanism so that this targets members who are in an appropriate category to be able to use this practice to give effect to their responsibilities to represent their electorate at a time when they may be dealing with other responsibilities, such as family responsibilities, or may have other reasons why they have needed to obtain leave from the Parliament. The Coalition, of course, supports sensible efforts to make this Parliament more family-friendly, and we're very alive to the matters raised in the Jenkins report Set the Standard, which outlined ways to improve workplace culture in the Parliament. So I conclude by confirming that the opposition supports this motion.
The question is that the motion be agreed to. All of that opinion say aye. Aye. To the contrary, no. I think the ayes have it. I have received a message from the Senate informing the House that the Senate has agreed. Oh, I'm sorry. Okay, sorry, I call the Assistant Treasurer.
Thank you, Deputy Speaker. I present the Income Tax Amendment Labour Mobility Program Bill of 2022.
call the clerk.
First reading, a bill for an act to amend the Income Tax Seasonal Labour Mobility Program Withholding Tax Act 2012.
Call the Honourable Minister.
Thank you, and my apologies, and I promise that this is the last of a big package of bills I'll be introducing this morning. I move that the bill be now read a second time. The Income Tax Amendment Labour Mobility Program Bill of 2022 makes amendments which support Schedule 1 to the Treasury Laws Amendment 2022 Measures No. 4 Bill of 2022. Together, these bills ensure that foreign resident workers participating in the Pacific Australia Labour Mobility Program scheme will pay a final withholding tax of 15% on income earned under the scheme. Schedule 1 to the bill specifies that the term the Seasonal Labour Mobility Program will be substituted with certain labour mobility programs to enable relevant workers in the PALM scheme and workers in potential future visa schemes, for which the same tax treatment is appropriate, to access the final 15% withholding tax rate from the 2022-23 income tax year. The PALM scheme will help meet workforce shortages in Australia, as well as support the economic development of Pacific nations and Timor-Leste. Further details of the measure are contained within the explanatory memorandums.
Okay, I don't have that bill with me. The debate must now be adjourned. Opposition member, would you mind moving that the debate be adjourned? Member Petrie.
Yeah, thanks, Mr. Deputy Speaker. I move the debate be adjourned.
The question is that the resumption of the debate be made an order of the day for the next sitting. All of that opinion say aye. To the contrary, no. I think the ayes have it. I call the clerk. Well, message from the Senate. I have received a message from the Senate informing the House that the Senate has agreed to the following resolution: that the time for the presentation of the report of the Joint Select Committee on Parliamentary Standards be extended to no later than the 1st of December 2022. The Senate requests the concurrence of the House in the variation to the resolution of appointment of the committee. I call the Honourable Minister.
Thank you, Deputy Speaker. I move that the message be considered immediately.
I put the question. All of that opinion say aye. To the contrary, no. I declare the motion carried. I call the Honourable Minister.
Thank you, Deputy Speaker. I move that the House concur with the resolution of the Senate.
I put the question. All of that opinion say aye. To the contrary, no. I declare the resolution carried. I have received advice from the Chief Government Whip that she has nominated Dr Garland to be a member of the Selection Committee in place of Ms Claydon. I call the Honourable Minister.
Thank you, Deputy Speaker. I ask leave of the House to move a motion for the appointment of a member to the Selection Committee.
Is leave granted?
Yes.
Leave is granted. Please proceed.
I move that Ms Claydon be discharged from the Selection Committee and that, in her place, Dr Garland be appointed a member of the committee.
I put the question. All that opinion say aye. To the contrary, no. I think the ayes have it. I call the clerk.
Government business. Order of the day number 1. Aged Care Amendment implementing Care Reform Bill 2022. Resumption of debate on the second reading and on the amendment moved by the member for Mayo to the amendment moved by the member for Farrer.
The original question was that this bill be now read a second time, to which the Honourable Member for Farrer moved, as an amendment, that all words after that be omitted with a view to substituting other words. The Honourable Member for Mayo has moved, as an amendment to that amendment that all words after whilst be omitted with a view to substituting other words. The immediate question is that the amendment moved by the Honourable Member for Mayo be disagreed to. The question now is that the amendment moved by the Honourable Member for Farrer be disagreed to. And I call the Honourable Member for Capricornia.
Thank you, Deputy Speaker. All Australians want and expect our older Australians to be well supported and cared for in our community, including in residential aged care homes. That is why, in government, the Coalition called the Royal Commission into aged care quality and safety to ensure our oldest and most vulnerable Australians receive care that supports and respects their dignity and recognises the important contribution they make to society. The final report of the Royal Commission makes 148 recommendations, following 23 public hearings over 99 days, 641 witnesses and over 10,000 public submissions. They are the product of wise and compassionate scrutiny of Australia's aged care system. In response to the Royal Commission, the Coalition committed $19.1 billion to a 5-year plan to improve aged care, with new home care packages, respite services, training places, retention bonuses and infrastructure upgrades. The opposition remains committed to supporting the health, safety and well-being of older Australians and understands the important role that aged care providers, care workers and nurses play in ensuring this support is provided in residential aged care settings. Speaking to this bill hits very close to home for me. My father, who is 86 years old, is in the aged care system at the moment, and I understand what the families are going through when it comes to aged care. I want to thank all the aged care staff that are looking after him and for their tireless work in making him comfortable. While I'm visiting him, families of other residents and patients are grabbing me in the hallways to share their experiences, telling me about their own dire situations. They ask me for help to find doctors for their parents or elderly loved ones. Tragically, some are telling me about their mums and dads dying in agony waiting for a visit from a doctor. In some cases, they are given Panadol for the pain they are experiencing while they wait and then they pass away. I recently met with the CEO of Benevolent Aged Care, Alison Moss, about the issues they're facing delivering aged care services in Rockhampton. They are struggling to provide quality care due to a lack of staff. They have 22 beds available in their newly built and state-of-the-art facility, but due to the struggles with staff and shortages of doctors and nurses, these beds are unable to be filled. I have also recently been notified that Access Aged Care, a provider offering clinical services to residents in residential aged care facilities, will soon be withdrawing the services from Rockhampton. Despite intense recruitment efforts, Access Aged Care has been unable to secure the services of GPs in Rockhampton to support its care model and, as a result, will no longer be providing services. This has the potential to impact emergency departments, as residents can no longer be treated on site at their facility and will be taken to the emergency department for treatment. This will affect approximately 170 residents in the local area. A&E at Rockhampton Base Hospital faces constant ambulance ramping at a rate of 45%, one of the worst ambulance ramping rates in Queensland. Shortages of doctors in nursing homes mean that the elderly are being sent to A&E for scripts or checkups, which could be done by a GP in a nursing home. This is clogging up the system. Mr Deputy Speaker, we were told this government was going to listen, they were going to consult and they were going to care. I heard the slogans constantly during the election. They recited over and over again, Medicare, aged care, we care. Unfortunately, I have sent correspondence to the Minister for Aged Care, Annika Wells, on multiple occasions about the terrible state of aged care in Capricornia, about Access Aged Care pulling out of the PHN, and to make her aware of a bipartisan aged care forum I hope to host in Rockhampton that she would be more than welcome to attend. To date, I have not received a single response. This is shameful behaviour of the Minister, and I implore her to stop playing politics with this important issue. The Minister would be well served to remember that aged care is too important for politics. The Implementing Care Reform Bill contains 3 schedules amending the Aged Care Act 1997. Schedule 1 establishes a new responsibility for providers of residential aged care to ensure that a registered nurse is on site 24 hours a day, 7 days a week by July 2023. Schedule 2 of the bill introduces a new power to enable the government to cap fees that approved home care providers may charge care recipients, and it moves the home care providers' ability to charge exit amounts. And Schedule 3 of the bill introduces a new requirement for the Secretary of the Department of Health and Aged Care to publish additional information in relation to aged care providers and their costs, with the aim of allowing older Australians and their families to make more informed care decisions. The opposition urges the Labor government to continue at generational reform of the aged care system for the benefit of all Australians and to stop playing political games with older Australians and their families. Our nurses have worked tirelessly on the front line through the COVID-19 pandemic, protecting lives and keeping Australians safe. We especially recognise the amazing support that nurses provide our older Australians, particularly their critical work in aged care homes since the outbreak of the pandemic. We know these were not easy times, yet our nurses stood up when it mattered most to protect so many older Australians, and we are grateful for their work. The opposition have grave concerns regarding the extreme use of unreleased subordinate legislation by the government. Instead of containing adequate complexity and information, this bill does not actually outline the necessary details on how it will impact aged care providers in practice. The opposition considers this bill more of a legislative framework than detailed legislation. The lack of detail with the legislation and the lack of ability for parliamentary scrutiny of its subordinate legislation is a serious concern for the parliament and for the aged care sector. These concerns are echoed by many stakeholders and witnesses who appeared at the Community Affairs Committee inquiry into the bill. The government must listen to the concerns raised by the witnesses at the inquiry, and the stakeholders will be affected by this legislation. Schedule 1 of this bill allows the government to implement registered nurses into residential aged care facilities on a 24-hour basis by July 2023. However, this timeline is not consistent with the Royal Commission's final report, which recommended making it mandatory to have a registered nurse on-site 24 hours a day from July 2024, with an accompanied minimum care minutes requirement. The opposition notes the unique challenges faced by aged care providers in rural and regional Australia, particularly regarding access to the registered nurse workforce. The Royal Commission considered a range of factors when recommending that timeline, recognising the current workforce shortages and the time required to train or access the necessary additional workforce. Given the government has brought the start date of this recommendation forward by a year, they must specifically outline what support will be provided to regional and rural providers and other providers already struggling with viability and workforce challenges. The government must outline how they plan to get the additional nurses into aged care homes in regional and rural aged care facilities following their jobs summit. The opposition supports the Royal Commission's recommendation on 24/7 RNs in aged care facilities where it is possible by 2024 and in line with the Royal Commission recommendation. Excuse me. The opposition also calls on the government to provide oversight of the delegated legislation that puts in place a mechanism and details of possible exemptions. The government has not been transparent with any of the details of this exemption clause. This lack of transparency creates uncertainty for providers who are already under stress from the COVID-19 pandemic. This information is particularly critical for rural and regional providers who will likely be subject to significant difficulties in finding the additional workforce to meet the requirement within the timeframe set by this bill. Speaking to Schedule 2, former Minister for Health Greg Hunt and Minister for Aged Care Services Senator Colbeck required for the first time that information be published relating to the median prices charged for home care services, increasing the transparency on home care prices. This bill now enables the government to cap charges that approved home care providers can charge care recipients and removes home care providers' ability to charge exit amounts. The opposition supports these reforms as they are sensible amendments broadly supported by the sector. We remain committed to ensuring downward pressure on home care prices and that older Australians can make informed decisions about aged care services. Speaking on Schedule 3, the opposition agrees that we need more transparency in the aged care sector to ensure older Australians and their families are able to make informed care decisions. That is why in government we introduced substantial reforms to increase transparency, including from the 1st of July 2019, we required all home care providers to publish their pricing information in a standardised schedule published on the My Aged Care website, providing greater visibility of median prices. We invested in the My Aged Care website to ensure that older Australians and their families were able to easily access and compare information about aged care providers. The publication of additional information to increase sector transparency and to increase consumer understanding of the sector is supported by the opposition. I believe that more information assists in making more informed choices. Deputy Speaker, the Coalition has a proud and constructive history of delivering for the aged care sector. The Coalition's 2022-23 budget delivered funding for aged care reform of $522 million, which built on the previous funding contained in the previous budget. This brought our total investment in response to the final report of the Royal Commission to more than $19.1 billion. Our 2022-23 budget responded to 10 recommendations of the Royal Commission and built on our existing 5 pillars of aged care reform. We delivered record investment across the aged care system over the forward estimates, from $13.3 billion in 2012-13 under Labor to $30.1 billion in 2022-23 under the Coalition. By 25-26, funding in aged care was estimated to grow to an estimated $34.7 billion per year under the Coalition. We also remain committed to providing our old Australians with support to live in their own homes for longer, and that is why we increased new home care packages from 60,308 under Labor in 2012-13 to 275,597 in 2024-25, an increase of 357%. We are currently in the second year of the 5-year plan, and it is imperative that the government now continue our work to support the aged care sector. I also implore the Labor government again not to play politics with aged care. People like my father and the families I meet deserve better. Thank you.
The immediate question is that the amendments moved by the honourable member for Mayo be disagreed to, and I call the honourable member for Wills.
Thank you, Deputy Speaker. I think, like others in this place, I've reflected a number of times about the importance of respecting older Australians in their senior years. And it's not just about good manners, although it's a big part of it. It's about recognition of their hard work, the contribution that they have made to their communities and to the broader society and to the country, really. And older Australians really deserve dignity as they age, and they deserve a government that will actually look out for them. Our value as a society is found in how we actually treat each other. But there is little pride to be found in the treatment of people in aged care and the hard-working staff as well in that industry. Neglect is probably the best single word that can be used to describe how they have been treated or not treated. That is the simple yet poignant way this issue has been described by others. That is what the Albanese government has committed to putting the care. Why we've committed to putting the care back into aged care, to rewrite that, to reverse that neglect, to actually care. And it's what we promised at the last election, and it's what we are delivering with this bill, which will implement 3 of our urgent reforms to aged care. It will require approved providers of residential aged care to have a registered nurse on duty 24 hours a day, 7 days a week from July 1st, 2023. This will extend to specified kinds of flexible care, something we will work closely with state and territory governments to implement. For aged care residents and their families in my electorate of Wills, in the northern suburbs of Melbourne, this is incredibly important, Deputy Speaker. It will mean less unnecessary trips to the hospital simply because a nurse is unavailable. That's taking pressure off our health system. These trips, usually at all hours of the night, cause a great deal of stress to residents and their families and adds to the already significant workload of the people that care for them. Less unnecessary trips to the hospital will also reduce exposure to illnesses, the risk of which we are acutely aware of course, during the pandemic. We are also particularly conscious of this in my electorate of Wills, where significant outbreaks have occurred across aged care homes. For the families with relatives who contracted COVID-19 in aged care, I know how important this reform is for them. It's critical. I've spoken to dozens of them, family members and people in aged care, including those who lost loved ones tragically. They have all told me about the greater investment in care hours required to improve the living conditions in these aged care facilities. It was a constant theme, constant refrain. Affordability is also another challenge, Deputy Speaker, that the Albanese Labor government is committed to addressing. This bill will cap the amount recipients can be charged for the administration and management of home care packages and remove exit amounts entirely. More than 210,000 Australians currently receive home care packages, and I know from the dozens of stories that have been shared with my electorate office just how much cost remains an ongoing stress for recipients and their carers. By capping these fees, we will make it more affordable for people receiving home care packages, and we will make it clearer, providing a better picture of expected costs, which can be exceptionally difficult to fully grasp when navigating what is a very complicated system. So improving transparency in the sector is a priority for the Albanese Labor government. Australians across the country have been rightly shocked about the secrecy and scandals arising that we've seen in this sector. It's been shocking to ordinary Australians, people who know that they have family members in aged care facilities. All of the front-page reports of the lavish lifestyles of aged care home executives and the owners of those facilities. Just shocking. And I think a direct hit to that sense of fairness that Australians hold so dear. All this was happening while residents were slapped with increasing fees, and aged care workers remain some of the lowest paid workers in our economy. So the final part of this bill will give Australians a greater picture of the operations of aged care providers, including where they are directing their money. Shining a light, transparency, very important, Deputy Speaker. It will require the Secretary of the Department of Health to publicly provide information about the expenditure of aged care providers. This will include information on the expenditure directed towards staffing and care hours, food and nutrition, cleaning, administration and maintenance, as well as the profit and loss, the bottom line. This information will be made easily available to the Australian public, to those family members, providing them with the information they need to make decisions about the care for themselves or for their family members. Now, this is what real action looks like from a government that is actually committed to respecting older Australians and putting their care back into aged care. It's not rhetoric, it's not grandstanding, it's not talking about it, it's actually doing something about it. And as a government, we will also continue to seek further reforms, including working with the sector to implement mandatory nutrition standards, ensuring all people in care receive high-quality, nutritious food. We will mandate an average of 215 minutes of care per day, as recommended by the Royal Commission into the sector. Just like providing more nursing hours, this will reduce the workload of staff and provide more time for the provision of basic standards of care, which, frankly, we should all expect as a baseline minimum. Now, I know how important this is for the hardworking staff who care for our older Australians. It's a tough job, probably one of the toughest jobs out there. The care, the commitment that they make is really incredible. It is really giving of yourself, and it's highly stressful, but it's also very, very difficult work. And it requires a lot of skill and a lot of compassion, and a lot of hard work goes into caring for our older Australians. It's got to be acknowledged how difficult that job is. And it's often a thankless job as well. And that's something that we're trying to redress here by acknowledging the hard work of aged care sector workers. And we know how insufficient their pay is for the level of work they do, for that type of commitment. That's why it's so important that we redress these issues. Put the care back into aged care, Deputy Speaker. Acknowledge and reward through their better pay the aged care workers that do that thankless job to look after older Australians, and make a real difference to the lives of older Australians. Give them the dignity that they deserve, given the commitment and contribution that they have made to this nation over their working lives. Thank you.
The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the member for... Is there any? Call the honourable member for Grey.
Thank you very much, Mr Deputy Speaker, and I do support the amendments. Aged care, of course, is a very important issue within all of our communities. And of course, as I often say in this place, I come from one of the most rural and regional electorates in Australia, and it is a great concern to me how these individual units are affected by any changes we make in this place. Now, we are all very aware that staffing issues are a problem right across the industry, but they're more acute in rural and regional Australia than they are, in fact, in the cities. And we've had some difficulties in the recent past. I've had a major, for us, let's say, a major-sized unit, over around about 80 beds, having some real difficulty meeting standards. Be fair to say, we absolutely need our facilities to meet those standards. Given the degree of difficulty that is sort of evolving at the moment, sometimes I think it needs a little bit of a soft touch, and to make sure we can't run the risk of actually closing these beds. In another case, in the city of Whyalla, we've had a community-owned service who operate all of the residential care spaces in Whyalla under extreme pressure and forced to close one of their 3 facilities. In that space, the former government, I'm very pleased, stepped into the breach and assisted Helping Hand come to Whyalla and provided around about $3 million worth of assistance to actually keep the facility going, to get their management systems in place, and to make sure that we have a seamless change of managing and ownership in Whyalla. Now, Helping Hand have been there for most of this year, a little more than that, and they need to make a decision in the very near future about whether they are going to go past the 12-month point and actually purchase the facility and stay permanently in Whyalla. In the lead up to the election, I secured an electoral commitment from the Coalition to advance $10 million for capital works in Whyalla. Now, I don't make any bones about this, and I've spoken to the Health Minister, Mark Butler. It was not matched by Labor, but it was very welcome offer from the Coalition. I've spoken to the Minister since and just saying how important it is that we secure this support, even though I understand it wasn't a Labor commitment. And there is a funding round coming up, I believe, in November. I've also spoken to the local state member there, Eddie Hughes, who is a Labor member, and we are at one on this issue. We just simply need to get capital investment into Whyalla to secure the long-term management of a larger organisation that have those the efficiencies that actually come with being able to run that type of organisation. One of the problems we had, of course, it was Kindred Living at the facility that was closed, was we just could not get enough registered nurses. And in fact, it's one of those paradoxes, I suppose, that the hospital too was struggling for registered nurses, and so set up a method operandi, if you like, which led to the raiding of registered nurses out of kindred living, which only exacerbated the problem. And people have said to me, well, why couldn't we stop the hospital raiding that staff? Well, of course, it really either got to have a shortage of nurses somewhere. Like what the problem is, we have a shortage of nurses, whether it be in the hospital or in the aged care sector. So we know that we have to address that as a matter of urgency. And so I'm confident the Minister is listening, the Minister for Health and Aged Care, and that we will reach a position where we can secure that long ongoing service from Helping Hand. I know it would be difficult for him to sign off on some kind of grant in front of the process, and I think that's right and correct, and he's holding his ground in the right manner. But as long as the government, as long as the Labor Party are committed to making sure that we have long-term classy operators in Whyalla and that we achieve some reinvestment, which will see to get rid of the shared rooms, to get rid of the shared bathrooms. If we know anything after COVID, Mr Deputy Speaker, is that you don't want shared bathrooms in an aged care facility. So we will move the dial forward, and I give my assurance to the people of Whyalla I will not rest until we make sure that we have nailed down that long-term commitment from Helping Hand and that we have a commitment to build new facilities and upgraded facilities in Whyalla and then expand the facilities.
The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the honourable member for Bendigo.
Thank you, Acting Deputy Speaker, and it gives me great pleasure to rise to speak in favour of the legislation that is before us. It's long overdue, these reforms to aged care, and it is one of the key commitments of the Labor government is to rebuild the aged care sector, to restore the dignity, quality and humanity back into aged care. The Royal Commission broke many hearts. It exposed the true crisis that is in aged care. But for many of us and many of the families, many of the residents living in aged care, it's stories that we had heard before. For far too long, the sector had been let fall into the crisis that it is today. And what the bill before us does, it introduces a number of key reforms that will help get the sector back on track. Just as a way of an example, I just wanted to share with the House some of the conversations that my team and that I've been having with people in the Bendigo electorate. So serious was the challenges in our electorate when it came to aged care that we actually ran our own survey and our own consultation work around the same time as the Royal Commission to share the experiences of local people. We also organised our own rally to give family members the opportunity to speak out and to give workers an opportunity to speak out to try and get the former government's attention about what was happening in our region. And I can remember being at the rally and inviting some family members up to speak, and had to do the health check, the mental health check, and said, look, what we're talking about is quite confronting. If this is a trigger for you, please reach out. Because there were lots of tears, there were lots of stories that were being shared that triggered some really traumatic memories for many of the people that were there, because they'd lost loved ones in aged care that hadn't received the appropriate support that was needed because the sector is in crisis. One example of that is Bernadette, who was a primary carer for her friend. Her friend Leonie was in aged care. She contacted us to say there's not enough qualified staff, that Leonie had reported that staff did not know what medications she had to take, that they were often trying to give her the wrong medications. She said she was unable to walk and reliant upon staff for toileting, but felt really embarrassed or, was concerned about calling them, pressing the call button because she knew how overworked they were. The food was inadequate, and recently Leonie had just been given a party pie and sausage roll. Her GP had recommended for Leonie that multivitamins be provided to Leonie to compensate for the poor food and poor quality. This is Leonie's experience. Leonie is one of the many people in my electorate that really welcomed Labor's commitment and the reforms that are before us. The 24/7 registered nurse, for example, would ensure that Leonie wouldn't be in that situation going forward, that she would actually have the nurse on site to help ensure that she was receiving the right medication, wasn't trying to be given the wrong medication. Another example, Kylie contacted my office. She is a nurse in residential aged care, and she said that she was leaving. She was heartbroken to be leaving the sector, but she's just burnt out. She works extremely hard, worked overtime every week and weekends, double shifts when they were asked, because she didn't want to leave the residents in the situation that Leonie was in. But after years of doing this, it had taken its toll and she was burnt out. When asked did she support the reform about a requirement for 24/7 registered nurses to be in the electorate, she said yes, because it would mean that her employer would have to have a replacement nurse for when someone called in sick. Because quite often that wasn't the case. It was left up to the facility, and if they couldn't get somebody, they were left short-staffed. We acknowledge that there's a lot of training that we need to do, there's a lot of work we need to do to encourage nurses back into the sector. But if we are able to improve and support registered nurses like Kylie, Kylie may come back. She may come back into the sector. They're the kind of people we need to encourage back in. I also wanted to share the example of Robert. Robert is 97, World War II veteran, one of the last remaining World War II veterans that we have in our country. Living in Bendigo, does not miss an Anzac Day. He's on the home care support system. He fears going into aged care because of the examples that I've shared and that others have shared. So he still lives at home with his 90-year-old wife. They've been together for a while. She's now in a wheelchair on a level 4 package. Robert is on a level 3 package. My aged care, home care, is their only support that they receive. There's no family. But it's complex to navigate. They have a private provider that is very who helps to manage their package, very limited in detail. Robert thought he had been doing the right thing, where he was saving funds for OT work and assisted equipment needed for his wife. But he was actually doing it. It wasn't right to be doing it that way. He was unaware that because that his funds could be used to help his wife, which in turn then denied him being eligible for a level 4 package and therefore support for himself. So because he wasn't quite aware and the complexity of managing the case, and because he had a private administrator provider that was based in Melbourne, he couldn't get the information that he needed. He was going without the extra support to help his wife toileting. So here he is, a 97-year-old World War II veteran, living at home, trying to live longer, live better at home, supporting his wife to toilet because he wasn't aware of how his package worked properly. And it ended up coming through to my office asking for, can we move him from a 3 to a 4? And we contacted My Aged Care to unpack that. Well, he couldn't move to a 4 because he hadn't spent all of the 3. The miscommunication. And so much of their package had been lost in administration fees. And that speaks to one of the other reforms that's before the Parliament today. And that's about capping the home care charges. This bill also reflects our commitment to cap the amount that can be charged by administration and management for people receiving home care packages and removing exit amounts altogether. It was a key recommendation of the Aged Care Royal Commission into aged care quality and safety, and that heard up to 50% of home care packages were being eaten by administration and management fees. That's definitely been the experience of Robert, and that's part of the problem we have with this sector, is with the private managers and private providers and private organisations. They're also not very good at sharing with their clients or with their customers how best to use their package. And a year and a half down the track, this very kind, very gentle, very strong World War II veteran is calling my office to find out what can be done to support his wife. It shouldn't be this hard. A veteran should not have to come to their MP's office to get support to help toilet his wife. That is why the capping of home care charges is important. It will encourage more not-for-profits to be in the sector. It will encourage and it will actually see probably the exiting of many that are in the sector to make a profit, not deliver service. These proposed changes provide pricing transparency for people like Robert and for providers, and creates greater clarity about direction and direct and indirect costs. All of these changes are necessary. Robert isn't the only one that's raised home care changes with me. There's a group in Castlemaine, and this is one of their key issues that they spoke to me about in the lead up to the election, the frustration that they're looking at their money dwindle, that isn't actually going on support for them but going in administration fees, and then the cost of exiting, so they feel trapped with a dodgy provider that they can't move to the next without paying an exit fee. So they welcome these changes that are before us today. The other key change that is really being welcomed by people in my electorate is the transparency of information. In this bill, we are committing to improving integrity and accountability in aged care, providing greater transparency about what aged care providers are spending money on. And that goes to the food example that I used in the case of Leonie. Part of the frustration that Leonie and her friends spoke to my office about was it is expensive for a lot of our older residents to be living in aged care. They've had to sell their home, or the money's gone into a bond. They are paying a lot to be in these facilities, yet all they get served is a sausage roll and party pie. It's not good enough when they feel that they're paying a lot from their income. So having the transparency of information it holds the sector accountable and keeps them honest. It allows people and residents and family members to know exactly where the money is spent. It also allows our parliament and our government to really understand, where the money is going in aged care. If all the money that is being spent on staff and that we need more, then we can look at that. But if the money is going into mega profits for not-for-profits or for individuals, then we need to know that. These are why these changes that are before us are so necessary. The legislation that we have is part. The other legislation that was moved through in the first sitting fortnight together is our demonstration as a government that we are getting on with the reform that the sector requires. We do not want to be here in 3 to 4 years' time and still have family members coming into our electorate offices crying because their loved one has passed away in pain, or in a position where they didn't get the help that they needed. We want everybody to live their best life, and when they exit this life, go with peace, dignity and in humanity. We want to see that return to our sector. In the few moments I have left, I do want to thank everybody that continues to work in aged care that has just hung on. It's been really tough the last few years. The short staffing, the pressure on the sector, but it's been particularly tough in states like my state of Victoria, where we've had the longer lockdowns, the longer exclusions, not allowing family members and friends in because of the risk of COVID to aged care. It was done for a reason, health reasons. Aged cares are quite susceptible to COVID. We've lost a lot of older Australians to COVID. And a lot of the residents really understand that, but it has taken its toll, not just on the residents but also on the staff. They are burnt out. And for those who've hung on and still there, all I can say is that it will get better. These reforms that Labor is moving on in government will improve the aged care sector. We are committed to seeing the wages lifted for these aged care workers, these angels who've hung on to make sure that these residents do have the support that they need. We understand that things have happened that have broken your heart, but thank you for sticking it out, because it will get better. These reforms are a step in the right direction, and we acknowledge there's a lot more to do. And I look forward to being able to go back out to these facilities when we do have a 24/7 nurse that's on, that there is a replacement if that person's not able to be there. I look forward to the activities officers being able to be genuine activities officers and not having to drop activities to double up and be PSAs because someone's called in sick. The transparency is critical, making sure we know where the money goes, whether it's taxpayers' money or whether it's individuals' money. And finally, about the home care packages. There's a lot of work we need to do to clean up this sector, and the capping of home care charges is just the beginning. Older people deserve our respect and support, and I'm proud to be part of a government that is moving on implementing many of the recommendations of the Royal Commission.
The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the honourable member for Sturt.
Thank you, Deputy Speaker. And it's been very interesting listening to all the contributions from other members on this, because there's obviously some clear commonalities that we all experience in our interactions with the aged care sector as members of Parliament. Obviously, in dealing directly with constituents, I can tell from the previous contributions we all have very similar issues that are brought to us as local members of Parliament. And they're not all bad experiences, by the way, and I'll make a comment on that in a minute. But naturally, the people that reach out to come and see their MP are probably disproportionately because they've got an issue that needs support in overcoming. I accept that, but I want to make a few comments about the inherently fantastic people that work in our aged care system and the fantastic work that they do in a moment. But the second thing, following on from that, is I think all of us, as human beings, not just as members of Parliament, I don't think there'd be any Australian that hasn't had a direct personal experience and interaction with the aged care system in this country at the moment and for many years into the past, and all of us will into the future. My last surviving grandparent is now in a residential aged care facility. Two of my three deceased grandparents came to the end of their lives in an aged care facility, and of course, you know, there are many other members of my family that have and will in the future need the aged care system, hopefully for as brief a period as possible and not for a very long time. But it's very important to all of us that we have an excellent aged care system that is providing the highest standards of care and support in the most flexible way to people that need that care in the last moments of their life. So my grandmother not only spent the last period of her life in an aged care facility, she also spent most of her career working in the aged care sector. She was an aged care nurse for many decades. She'd become a nurse during the Second World War and served in the army as a nurse at the Heidelberg Hospital in Melbourne, nursing returned soldiers. there, many of whom were POWs that had returned to that hospital and had very traumatic and serious challenges insofar as the care that they needed. And then she came back home to Adelaide, worked at the repatriation hospital for a reasonable amount of time, doing similar work caring for veterans, and then became an aged care nurse for the remainder of her career as a nurse. And she was someone that absolutely loved that work. She loved caring for vulnerable people. At times it was very difficult because obviously the sorts of care and the circumstance that people in is very challenging and emotionally draining, but she absolutely loved and found so fulfilling doing that work. And I think she is the same as almost everyone that works in the aged care sector. And we all, as members of Parliament, have the opportunity, I'm sure if you're anything like me, to regularly visit our facilities, talk to management and the staff, as well as the residents, about what their issues are and the challenges they've got, but also my observation is that inherently the people working in the sector, whilst we need to do better in the support that they've got, they very much get an enormous amount of fulfilment from doing the work that they do, and they are great heroes in our society. And I'd like to pay tribute to everyone that works in the aged care sector, because we're very lucky to have your dedication. The Royal Commission obviously brought to light in some cases quite shocking examples of unacceptable circumstance in our aged care sector, and I've got no dispute with any of the commentary in the Royal Commission around that. But I just also think we've got to remember that whilst there are some bad circumstances, there will be always, unfortunately, bad operators with bad faith. But my personal experience, and I think it's the case across the sector, is that most operators are inherently doing excellent work with the resources that they've got. And the aged care facilities that I visit in my electorate are doing fantastic things, and the aged care facilities that I've experienced when members of my family have been cared for by them are doing fantastic things. So there are people that need to lift their game, but it's important that we don't let the zeitgeist become some sort of sense that we've got an aged care sector, particularly on residential aged care sector, that is on the whole providing very low quality and poor care, because that's not the case, certainly in my experience. But I want to be a constructive participant in this place, in doing more wherever we've got the opportunity to improve things. And the reality is that the demand on aged care services will only grow exponentially into the future. A large part of that is for inherently good reasons. People are living longer. Modern medicine is changing our life expectancy, and it is allowing people to have longer lives and a lot more options around treatment for things that would have ended their lives much sooner. That's of course meaning that other conditions are my own grandfather's circumstance at the moment, which is very common. He's very lucky to be alive at 93 years old, almost 93 years old, but of course he's in a circumstance of significant mental deterioration through having dementia. He's physically fit as a fiddle, which is great, but of course he is in a circumstance where, because of his dementia, he needs very significant care in a residential circumstance. Prior to him going into that circumstance, he had, I have to say, really good community care support, and my grandma was in the same situation before she passed away, where they had good support and access to community care packages that allowed them to stay at home for much longer than they otherwise would have been able to. And that's another thing I think that's really important as we're looking at addressing aged care reform and how the system will change into the future, that we're making sure that we are helping people to stay in their homes for as long as they can, provided that they want to and it's safe to do so. So that's a difficult circumstance to confront for any family. Certainly in my family's case, my grandparents that had to go into residential aged care, of course, didn't want to, and we did the best we could as a family to support them to stay out of residential care for as long as it was safe to do so. But you know, there will always get to a point where that's not tenable, but it is important that we have a good flexible system that can, for as long as possible, have people in a circumstance where they are able to stay in a home care situation where supports can be funded, as we do through community aged care packages, and they've changed a lot over the years, but the principle of helping people to age in place, age in their home, is one that's very much important for them. And of course it is important that we make sure that, particularly where they want to, if we can keep them out of the residential system for longer in a safe way, it takes the burden off the explosive growth we would have in residential care if we weren't doing as much as we could to further support people in that circumstance to stay in home care. So, look, this bill has been well commented on through a very long list of second reading speeches and contributions, and I do note particularly my colleagues who have talked about. I'm a metropolitan electorate, and I understand the issues that are acute in the sector to my electorate, but it has been quite valuable to hear contributions from members whose, particularly in the residential aged care side of things, have very different circumstances and challenges because of those circumstances, where smaller communities have much smaller facilities, very much more common to be community developed and run, and with very difficult challenges around viability. And I don't have that challenge in my electorate, but I have to say I recognise and back to the hilt people who represent electorates where they do have those facilities, and how vital it is that we support those facilities to stay operating and open. It is very traumatic for people to go into residential aged care, but if you have lived your entire life in a particular community, compounding the trauma which happens at times when people are taken from their home into a residential facility because it's not tenable for them to stay in their home anymore, to then also remove them from their community and add that additional burden of them not having many people that are a part of their family and their social circle at long distance from them, and therefore clearly not able to provide that nourishment that they need of regular visitations, etc., then that would be a very distressing and disappointing outcome. And so I commend the comments of many members who have talked about some of the challenges that are associated with mandating certain requirements on operators that will be near impossible for some existing residential facilities that are operating to meet. And so I hope the government is very much attuned to and very concerned to make sure that they think through how they structure exemptions for facilities that could have their viability dramatically impacted if we're not careful. So I think that point's been made well, comprehensively, by a lot of my colleagues, and I add my weight to it to make sure that it is really reinforced to the Minister and the government, and I hope that in a good faith way they are able to structure exemptions that ensure that those facilities can be viable. I think that I've talked about community care, and really in concluding I just make the point that I want to see the community care side of this sector be very much focused on being about people accessing that care and support, not being about becoming some huge profit centre industry. The aged care sector is not there to make people extremely wealthy. It's there to support that greatest generation, people that have served our nation, that have built this nation, and who need us as a government and as a society to give them the highest standard of support and care. And when it comes to community care, I have a lot of constituent experiences that have been very disappointing, but I won't go into the specifics of those details publicly in this debate, but I think every member of parliament would have similar experiences of certain providers around community care clearly making a lot of money rather than necessarily delivering an excellent outcome for the people that the system is there to support. So I'm certainly a happy participant and supporter in this place wherever I get the opportunity to support further change if it's necessary to make sure that that's the outcome we're getting around community care provision. So with that, I'd like to just reiterate my thanks to everyone in this sector. It's been a very difficult few years with the compounding challenges of COVID and the workforce in aged care and what they had to struggle through. In some states in particular, we know was extremely taxing and brutal and draining. And so thank you very much to the people that work in the sector. I hope that we as a parliament will continue to be delivering change for you that improves the quality of care to people that need it, and also ensures that the great heroes of the workforce of our aged care system are properly valued for the work that they do. And with that, I thank the House for the opportunity to contribute on the second reading.
I thank the honourable member for Sturt. The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the honourable member for Warringah.
Thank you, Mr Deputy Speaker. I rise to speak on the introduction of the Aged Care Amendment Implementing Care Reform Bill 2022. This is a bill I welcome, following the dire revelations of the Royal Commission into aged care. I would like, though, first to thank the many who work incredibly hard in this sector, and they do their job well. And the revelations of the Royal Commission would have been incredibly distressing for those in the sector that are endeavouring to give that very best of care to loved ones and to our older Australians as they go into that residential care. It's vitally important that this parliament, though, work to improve the standards of our aged care system. The recommendations of the Royal Commission were clear, that much-needed improvements to the way we care for our older loved ones must be implemented as a matter of urgency. So I would urge the Minister to accelerate implementing all the recommendations of the Royal Commission. Locally in Warringah, some 15% of residents are now over the age of 65. As Australia's population continues to age, the systems we currently have in place will need to be ready to cope with increasing demand. We must approach the issue with an unwavering compassion and acknowledgement that there are some systemic flaws in the past that weren't acceptable and that need to be changed. Under-resourcing and lack of preparedness have rendered many aged care facilities ill-equipped to adequately care for their patients and residents. And I think that was made all the harder during COVID, obviously, where additional requirements were imposed and placed upon aged care centres. And we have to remember, they are not hospitals. They don't have the level of care that is available in emergency departments. And so the balance between the resourcing and where the best care can be provided needs to always be front of mind. I've spoken with many local residents, nurses and aged care workers who all believe strongly that having registered nurses on duty will absolutely improve the quality of care and reduce the burden on the health system generally. Registered nurses have the skills and training to treat many more incidents and prevent them from happening in the first place. It will reduce the number of residents being taken to hospital, with care being able to be provided at the facility, reducing strain on our stretched ambulance and hospital services. The Implementing Care Bill clearly seeks to improve the system, and I urge the government to ensure these measures succeed. Costings of the bill are not insignificant. We know this is an issue. An accumulated $460 million over forward estimates, it's substantial. However, it's an investment absolutely worth applying to appease this shocking crisis. And as many have highlighted in this debate so far, it may still not be enough to truly cover the implementation of the measure. The 3 schedules in the bill will improve safety and access to care rights, as outlined in the Australian Charter for Healthcare Rights. The implementation of a mandated posting of a registered nurse 24/7 in aged care facilities is a welcome improvement to this access. It's an improvement I've advocated for strongly already during the last parliament, and I spoke in support of the member for Indi's motion in 2021. I've done some extensive consultation with stakeholders and residents in Warringah, and I seek assurance from them that any exemption on their behalf, that any exemption criteria for Schedule 1 will be reasonable and that it would be consistent with the Royal Commission's recommendations. I echo the concerns of the member for Mayo and the Coalition's second reading amendments, with a lack of detail in the primary legislation and the extensive use of delegated legislation. It's critical that the exemption criteria be made known so that we can be assured that reasonable provisions will be in place to protect providers who are unable to obtain a registered nurse. And in that sense, I've listened to the contributions of other members in this place in relation to, obviously, the difficulties in regional and more remote areas. Nevertheless, we also need to ensure that this exemption process is not used by providers to avoid providing better care and having registered nurses. The department estimates that there is a shortfall of some 850 nurses at present to meet the needs of this bill, so we cannot penalise the ratings of these centres for not obtaining staff if it simply doesn't exist. So we need to ensure there are exemptions where reasonable steps have been made to recruit staff, but are prevented by lack of availability amid the skills shortage crisis. Gaps in individual shifts due to sudden illness or injury of staff and difficulties for employers to abruptly source casual staff should also qualify for a reasonable exemption. The onus should be on the federal government to appease the skills shortage we're facing and help ensure these exemptions are minimised. The bill also seeks to cap home care costs, specifically pertaining to service providers no longer charging for a cessation of care. I support this in principle, as we need to target and prevent unreasonable outlier prices in home care. Some stakeholders in my electorate hold concerns that this schedule would grant the government an unlimited power to regulate all home care prices. So I do call on the government to be always transparent and consultative if they are to implement discretionary regulatory powers. There are some issues still relating to the crossover between aged care and NDIS, and it's not pertaining to this bill, but it is an issue that I would urge the government to address, is the gap and the age discrimination that exists in the NDIS system as people then transfer to the aged care system. Public disclosure. The third schedule seeks to mandate public disclosure pertaining to aged care services. And I support this in principle because we need transparency. But I find it to be broadly written, and a general power to disclose information without parliamentary scrutiny could be problematic. So I trust the government will consider reasonable privacy with regards to important information if it's published. When the Royal Commission was released last year, Australians were collectively horrified to learn of the extent of the real human tragedy in the deeply fractured system. The malpractice and under-resourcing were a clear violation of the right to access adequate health care, and I'm pleased to see this bill introduced so early in the government's parliamentary agenda. The bill will aim to rectify these 3 serious gaps in the aged care industry that were outlined in the Royal Commission. So these are important to fix, but we must remember the Commission produced 140 recommendations to fix this system. So we must ensure progress is continual. There is significant pressure to reform the sector ahead of the impending jump in demand. To remain ill-prepared for this will be catastrophic. We can't allow this sector to under-deliver quality care. In consultation with the aged care workers in my community in Warringah, further fractures have been identified. One aged care worker I met with identified that there's a significant gap between some aged care participants receiving access to great support and others who are not. One aged care worker has alerted me to instances whereby she witnessed dangerously poor hygiene in facilities and at home, long wait times for support and assistance, and even if an emergency button had been pressed. She identified that, alarmingly, she's seen staff administering medication to control behaviour and believes that it may have been unethical and unnecessary sedation. We know these are the types of issues that were raised during the Royal Commission. Reporting these serious issues to the appropriate channels can prove challenging for some aged care workers. And I note that these complaints are not always acknowledged. So we need to ensure enough streamlined reporting systems are in place so that quality care can be monitored and applied consistently across Australia. In my community, there are concerns also that some providers have too many people on their books, and so they're not resourced enough to provide substantial care for all of them, with fears of a profit over people mentality still exists within the sector following the revelations of the Royal Commission. In particular, the concern is for older people without family or close relations, or if they're under public guardianship. They're often left behind with inadequate support. The disparity in quality of care needs to be addressed in those circumstances. It has to be acknowledged, instigating and navigating the aged care system can be a daunting thing to do for families and for older Australians. The sector can be quite complex, and many older people rely on family and friends to help guide them through the processes of application, assessment and engagement with service providers. Sadly, people who struggle to instigate or navigate the system find themselves being left behind. So as we age, our circumstances can change rapidly, and this heightens my concern that underinvestment in my aged care has seen waiting lists explode. It can take upwards of 12 months on a waiting list to access home care packages. In that time, one injury, a fall or a sudden cognitive decline can see an older Australian completely without access to the level of care they need to stay in their homes. So I do urge the government to eliminate the home care wait list as per the Royal Commission recommendations and reform the system to make sure it is sustainable and fit for the ageing population we're dealing with. Keeping people in their own home longer should be a core goal of the aged care sector. And this is again where we do see the age discrimination between the interaction of the NDIS scheme that finishes at 65 and then the aged care, which does not provide the same level of support. Again, for those without family or community assistance, they find themselves dangerously under-supported as their needs grow. Without ease of access to adequate supports, older people may be forced into aged care facilities. This is not a benefit to the government or the economy or the community. For those who live in residential aged care facilities, care needs to be equitable and consistent. The best way to ensure this is to ensure we have well-trained, well-resourced staff. There are profound opportunities to stimulate the economic benefits of a well-functioning aged care sector. We know this is where the megatrends and the employment opportunities are. We know this is where the skill shortages are. The reforms recommended by the Royal Commission could create around 30,000 additional full-time jobs in aged care by 2030. This excludes the additional 50,000 extra full-time workers that will be needed because of population trends. So now is the time to capitalise on the opportunities afforded by reforming the sector. But of course, we also need to make sure they are properly valued. You cannot expect people to work in these sectors, which we know are so incredibly essential to our ongoing standards that we expect in our community, without them being properly remunerated and valued in our society. So this bill brings forward good measures to address three key gaps that were revealed by the Royal Commission into aged care. It's vital the implementation of these schedules is done so thoughtfully and carefully, and meaningful changes can succeed. I wish to thank those who work hard. They work so hard to provide quality care within this sector. Their contributions are vital to our older Australians in our communities. It's time we ensure that the unacceptable standards of the past are amended, and I look forward to continued action from the government and the minister and seeing this happen. Thank you.
I thank the honourable member for Warringah. The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the honourable member for Fowler.
Thank you, Deputy Speaker. Like all Australians, I want to see care for our elderly improved where possible and considered deeply. After all, it is something that affects us all. I had the privilege of seconding the amendment made by the member for Mayo, Rebecca Schaake, yesterday in the House. She is a strong advocate for regional Australia, and I trust that her amendment to this bill will ensure senior Australians receive better quality care for what they pay, and it will make it more difficult for vultures that wish to take advantage of our most vulnerable. My contention is not with the government's proposal to cap fees, making aged care more affordable for Australian families, or to improve the availability of information for senior Australians to make informed decisions. However, I do take issue with Schedule 1 of this bill, which proposes to establish a responsibility for providers of residential aged care to ensure that a registered nurse is on-site 24 hours a day, 7 days a week by July 2023. Our nurses have worked tirelessly on the front line through the COVID-19 pandemic, protecting lives and keeping Australians safe. I would especially like to recognise the incredible care given by our nurses in Fowler in supporting a particularly vulnerable elderly population. Some of the people they cared for did not speak English as a first language. Others did not speak English at all, adding to the complexity and stress already being experienced during the pandemic. We will never be able to thank these nurses enough. Despite being immensely overworked during the last few years, the government proposes to have skilled nurses on call 24 hours a day, 7 days a week. I do not harbour concerns over the validity of this proposal. Rather, I'm worried that not enough consideration has been put into how we will support these nurses and how we will expand the number of nurses available for this demanding job. This government needs to be careful to not simply throw money at the situation. Detailed planning needs to be put in place as to how new nurses will be brought into the industry, how they will be trained, and how these skilled workers will be retained. Currently, the proposed staffing standards are pitched well above what can be provided by aged care facilities. The government has stated that nearly 900 new registered nurses will be required to meet the new standards. However, the Aged and Community Care Association has estimated that the sector will instead need 1,440 registered nurses to meet the new staffing requirements. The government's proposal, therefore, considers the minimum requirements and does not take into account the COVID fatigue of a large portion of our nursing workforce. My constituents, like many around the country, struggle to find and afford care, either for themselves or their parents. Recently, I had a constituent write to me outlining the struggles she had in finding a home care nurse for her father, Anthony Best. Anthony is 90 years old and suffers from macular degeneration. He was assessed for the Commonwealth Home Support Program through the My Aged Care framework, however received no further assistance. His daughter Louise managed to find an at-home nurse, however the standard of care was not what was expected. Due to shortages of quality nurses, the care provider was sometimes unable to provide a nurse at all, and at other times the level of care was not what was required. In Louise's words, the system is broken. While the government proposes to increase the workload of nurses in our communities, they have yet failed to outline how these nurses will be supported so that stories like Anthony's can be avoided. Additionally, regional electorates have already raised concerns around staffing and the lack thereof. My community of Fowler is similar in that sense. We will see a skill shortage as we not only need qualified aged care providers, but they also need to be catering to our non-English speaking residents. There is a cultural and language barrier that needs to be overcome. Knowledge is often disseminated via community groups, friends and family as opposed to formal channels. This was evident during the COVID testing challenges, in which misinformation was raised amongst non-English speaking communities. Our healthcare systems can and should do better for cold communities. Our community of Fowler is a very diverse electorate with a growing population in the southwest corridor and a low expectation of the aged care system. This widening of capacity constraint in the aged care system is being compounded here in Fowler. Many view aged care as only choosing to place their elderly members in aged care facilities without understanding that there are other options to support the elderly and to keep them at home as long as possible. The Cold community have strong family ties, evident through family compositions that are of multiple generations, example, grandparents, parents, children of the same household. They are also generally reluctant to move their elderly away from the home. Services such as shopping trips or GP visits would go a long way to supporting these families without the need to relocate the elderly fully. Matching these offerings would alleviate demand on full-time aged care facilities. I also point to one of my other constituents from St John's Park, Mr Tang. Mr Tang currently lives with his wife and daughter. He came to our office recently inquiring after nursing home places for when he is unwell and immobile. He is worried he will not have the funds to put into securing a place in a nursing home that speaks his language. He says it will cost him $200,000 to move into an aged care home and fears this could cripple his family. Therefore, I support the Home Care Package program, which supports older people with complex care needs at home so they can be closer to their families. Providing alternative aged care options will alleviate pressures on aged care homes and will ensure families can stay together as a unit. But families that have tried to care for their elderly, if possible, at home, do not have enough access to resources or financial support available to our electorate. Fowler constituents face challenges in the understanding of certain aged care services offered and how to access them. Beds available in aged care facilities can do cater to a whole community are very limited, such as those that cater for culturally dietary requirements and multilingual staff. Recognition of overseas qualifications could also alleviate this pressure on our aged care facilities, who will now have to provide 24/7 care. Refugees and migrants are more than just their harrowing stories of escaping war-torn countries. They are skilled professionals. They are also qualified nurses and doctors. While the government looks to bringing in further 35,000 skilled migrants to our country to tackle the skills shortage, I ask, why not look in our own backyard first? In my electorate of Fowler, we have many migrants and refugees who have skilled qualifications from their homelands. Unfortunately, many do not have the paperwork or evidence to back up their qualifications. Speaking from experience, when you're fleeing persecution, violence or war, you're not thinking about the university degree paperwork or your qualification documents. You are thinking about how to save your life and those of your loved ones. According to the Asylum Seekers Resource Centre, the current recognition of prior learning process is complex and lengthy, which can be difficult for someone who has no knowledge of how our government works. They recommend a new skills assessment system for people without evidence of qualifications against an established benchmark, which should be combined with tailored courses and employment placements to identify their gaps in knowledge. We are wasting the potential of a huge group of people who are ready and willing to work. I commend upskilling our community and offering more government-funded courses in TAFE would be a good alternative to just university courses. I point to countries like Canada, which fast-tracked visas for refugees nurses in the pandemic. They hope to expand foreign credential recognition program with aims to employ an extra 11,000 overseas-trained healthcare workers a year. Furthermore, those who are seeking asylum could wait up to 5 years for the applications to be processed. During this time, they are kept on punitive bridging visas, which leaves them in purgatory, unable to work or study. I appreciate that the Labor government has committed to reducing this delay in visa processing. However, more needs to be done to action to tackle the crisis at our doorstep. Over 100,000 people are currently seeking asylum. While they wait for their visas to be processed, many cannot access social services, do not have the right to work, or do not have the right to study. There is no access to higher education, and all are excluded from subsidised funding for apprenticeships, training and certifications. If we are to look at reforming TAFE as part of Jobs and Skills Australia, we must also acknowledge that shorter and more practical technical courses could open opportunities to a wider cohort of staff and accelerate the supply to the industry. Aged pensioners who are alone and take care of themselves are reluctant to seek medical treatment due to financial constraints. The recent increase in GPs not bulk billing is accelerating this, which leads to their health deteriorating and adds additional demand to aged care services. With the cost of living pressures, we cannot expect our elderly and vulnerable to break their budget just to get simple healthcare services. We have also received many phone calls from other aged pensioners who have had concerns regarding having to pay out of pocket to see their local GPs. While I commend the government for acting in aged care and continuing the reform by the previous government, This cannot become a tokenistic gesture to stop the cries for help from senior Australians, nurses and the families that just want affordable and quality care for their loved ones. Too long in this House has grant spectacles been the way of government after governments to ease the pressure on them from the Australian people. Now is the time to act. Now is the time to create long-lasting and meaningful change in a sector that has been neglected and forgotten for far too long. I will continue to hold the government to account beyond the implementation of this bill, and I will continue to fight for senior Australians and the frontline workers who wake up every day and put their scrubs to look up after our most vulnerable. When I came to Australia, I was told of the Australian dream. I was told you could achieve the dream if you could contribute to your country and work hard to own a home and raise a family. Part of that dream is that when you get older, you would be cared for. Mr Deputy Speaker, I will not let Australians who have spent the entirety of their life working to be robbed of that dream. Thank you.
I thank the honourable member for Fowler. The immediate question is that the amendment moved by the honourable member for Mayo be disagreed to, and I call the honourable minister.
Thank you, Mr Acting Deputy Speaker. The Albanese Labor government is taking a different approach to governing than the previous government. We are not afraid to tackle the big challenges facing our country, and we are not afraid to do it at the earliest possible opportunity. And we're not afraid to consult or to reach across the aisle and work with our parliamentary colleagues, regardless of political stripe, to face those challenges. Even if sometimes we agree on how to do it or how fast to do it, I think it's fair to say that everybody in this parliament wants to see a better future for older Australians and for the aged care sector. And I want to thank all members for their contribution to the debate on this bill, all of which has been thoughtful and many of which has been based on their or their loved ones' lived experience in aged care. I'd also like to acknowledge and thank everybody who has either contributed to the Senate inquiry or to the ongoing consultation around the delegated legislation. And I want to reassure those who have taken the time to participate in these processes so far that we have heard you and the issues that you have raised, and that we are moving government amendments to this bill today as a result of your contributions to this consultation. The Royal Commission told us that we need to do better, and this bill is our earliest opportunity to take steps on that journey. The bill makes important practical changes to the delivery of aged care services, and it provides greater oversight of what funds are being used for. Importantly, this bill also introduces limits on amounts that can be spent on administration costs as opposed to direct care. These measures put the quality and safety of older Australians first. The bill introduces a new responsibility for approved providers of residential aged care and of specified kinds of flexible care to have a registered nurse on site and on duty at every residential facility 24 hours a day, 7 days a week from 1 July 2023. This will save thousands of unnecessary trips to hospital emergency departments and will ensure that older Australians living in residential aged care have access to the nursing care that they deserve. From 1 January 2023, the bill also introduces powers to enable the government to cap administration and management charges for older Australians receiving a home care package, and removes the ability to charge care recipients for ceasing care. This will maximise funding that is available to address care needs. There is currently little transparency of how providers set their prices for care and package management, and there is no cap on how much that they can charge. The Royal Commission heard that some providers were charging up to 50% of home care package funding for administration and management. And I know I have heard that in my electorate, I know the member for Mayo has heard that in her electorate, and that is something that we seek to address as soon as possible. And this bill will provide the means to ensure high levels of administration and management charges are reduced, and that money goes instead directly to meeting care needs. Lastly, this bill will include amendments relating to the transparency of providers' financial information and other valuable information about providers' operations to empower older Australians to make more informed choices about their care and shine a light on providers not doing the right thing. Mr Acting Deputy Speaker, I'd like to take a moment to acknowledge and respond to some of the feedback that we have received regarding this bill. During the Senate inquiry process, some concerns have been raised regarding regional and rural aged care homes and the impact the new nursing requirement will have on their ability to operate. We are aware of the issues facing these facilities, and this is exactly the reason why there will be sensible and limited exemptions available while we move to this new 24/7 nursing standard. These exemptions will be designed in consultation with these providers and other stakeholders to ensure that we get them right. It is also why, under the new AN-ACC funding model, which will start on the 1st of October, remote and very remote facilities are forecast to receive, on average, approximately $290 per bed per day, which is $83 more than the average funding from the current ACFI system. Some people have also raised the question of how the 24/7 nurse standard will be enforced and whether there will be consequences for those without an exemption. As with any situation where an aged care provider fails to meet their responsibilities around care standards, the Aged Care Quality and Safety Commission can undertake regulatory responses that include education, monitoring provider performance, directing a provider to take specific action, and enforcement actions such as sanctions. Ensuring best practice and the safety of older Australians is a priority for the Albanese Labor government. We also acknowledge that comments raised during the Senate inquiry process around ensuring appropriate levels of consultation for the delegated legislation. We agree there should be consultation around the detail, and there will be. On top of hours and hours of Royal Commission hearings that formed the basis of its important recommendations that this bill will help address, consultation on the delegated legislation is continuing and will be undertaken to determine policy parameters and, where timing permits, on exposure drafts of the proposed delegated legislation. Specifically, the delegated legislation for the exemptions to 24/7 nurses will go through an exposure draft process. I'd also note that all amendments to delegated legislation will be subject to disallowance and therefore continue to be subject to parliamentary scrutiny. Before I finish, I just want to acknowledge the proposed amendments by the member for Mayo. We do not support the amendment to the bill. We are concerned that there is a real lack of certainty about what a schedule of reasonable charges would look like and the responsibility that such a schedule would place on approved providers, and I'll hop into that in a moment. However, I really do appreciate the intent of the amendment. The government will not tolerate providers cost shifting when we can cap administration and management fees. The bill already allows us to manage charges if unscrupulous providers try to get around the new caps. We will be watching this closely, and we will respond and identify those providers who are doing the wrong thing. Setting reasonable fees for aged care services is not straightforward. If we set the fees too high, providers that can deliver effectively at lower prices will get a benefit at a cost to taxpayers. If we set them too low, providers who cannot deliver for the national price, for example, a small provider delivering personal care in a rural area, might just stop offering that service altogether. The cost of providing services isn't the same across the country or for all providers. And the last thing that we want for providers in rural and remote areas already struggling is to stop offering critical personal care services to people in their community because we have legislated a charge that does not meet the real cost of providing that service. However, I thank the member for Mayo for her engagement on the bill, for her long-standing dedication to better aged care policy and real outcomes for older Australians in need of care. I look forward to working with her and all my colleagues to deliver better outcomes for old Australians in sessions to come. I thank all members for their contributions to debate on this bill, and I commend the bill to the House.
I thank the Honourable Minister. The immediate question is that the amendment moved by the Honourable Member for Mayo be disagreed to. All of those of that opinion say aye. To the contrary, no. I think the noes have it. Ayes have it. Division required. Ring the bells for 4 minutes.
You put that in.
Order. Block the doors. The question is that the amendment be disagreed to. The ayes will pass to the right of the chair and the noes to the left. I appoint the honourable members for Werriwa and Bean as tellers for the ayes and the honourable members for Grey and Parkes as tellers for the noes. I ask members to remain in their seats. That's my Order. The result of the division is ayes 70, noes 65. The question is there resolved in the affirmative. The question now is that the amendment moved by the Honourable Deputy Leader of the Opposition be disagreed to. I'll put the question. All of those of the opinion say aye. No. I think the ayes have it. Noes have it. Division required. Ring the bells for 1 minute. Block the doors. Block the doors. The ayes will pass to the right of the chair, the noes to the left. I appoint the honourable members for Werriwa and Beans as tellers for the ayes, and the honourable members for Gray and Parkes as tellers for the noes. Members are changing their vote. Please advise the tellers. Order. The result of the division is ayes 74, noes 61. The result of the division is in the affirmative. The question now is that this bill be now read a second time. I'll put the bill. I'll put the motion. All those in favour say aye. Aye. Against, noes. I think the ayes have it. And I call the clerk.
Second reading. A bill for an act to amend the Aged Care Act 1997 and for related purposes.
Order. members can leave the chamber as quickly and as quietly as possible. The House will now consider the bill in detail. I understand it is the wish of the House to take the bill as a whole. The question is that the bill be agreed to, and I give the call to the honourable member for Mayo.
Thank you, Mr Speaker. I wish to talk to the amendment.
Are you wishing to move the amendment? You'll move the amendment in your name.
Mr Speaker, I move the amendment as circulated in my name.
I call the member for Mayo.
Thank you, Mr Speaker. This amendment is very simple. It aims to supplement measures provided to Schedule 2 of the bill. It does not limit matters which may be provided in the user rights principles under the Aged Care Act. It does, however, specify that those principles should include a reasonable schedule of charges associated with the provision of care recipients. With respect to administration and management of care, with respect to services and equipment.
Otherwise, the licence to kill.
The purpose for this amendment is this. Sure as night follows day, if we put a cap on administration and management fees on this side, we are going to see people who receive a home care package, instead of being charged maybe $90 an hour, perhaps $150 on the weekend. Now, that is the usual fee that I see. Now, I've surveyed more than 1,200 residents in my community and asked them to go into detail for me, and I've seen their invoices. Sure as night follows day, those fees will go up. Now, I understand the minister says, oh, we're going to keep a watchful eye on this. That's going to be after the damage. That's going to be after people are charged $200, $300 because providers will share and shift the profits on this. Now, there's no reason why a reasonable schedule of fees couldn't have a metropolitan layer and a regional, rural, remote layer. There's no reason why you couldn't have a range of fees. But when I have constituents in my electorate that are being charged $700 for an occupational therapist to spend 10 minutes in their home to tell them they need a shower chair,
Shame.
or 10 minutes to tell them that they need a little hanging basket, instead of putting the shampoo on the ground, just get a little hanging basket from Kmart, that's $700. Or for a rail in their wardrobe to be charged, this is extraordinary, to be charged $700 for an occupational therapist to visit you, to tell you need that, and then, $440, Mr Speaker, for a company to come out to a home to provide a quote, and then for $1,000 to be installing the rail. It's all taken from the funds. And then what happens when it's taken from the funds is that older people are told, oh, we're going to have to cut back your hours this month, and when we get the next lump of money for you at the end of the month, you can go back to your normal hours of care. It is outrageous that we would not fix this problem properly now, right now in this parliament, and not say, oh, the department's going to look at this in the future, or we're going to be really keeping a watchful eye on this one. I will be talking with my constituents as soon as this is implemented and saying, so tell me, how much are your hourly rates now? What are you being charged for an hour of home care or 20 minutes of home care now? And how much are those occupational therapist quotes that come out and spend 15 minutes? And how much are you being charged? Because, as I said, they are going to profit shift from where they're currently making obscene amounts of profit on administration and management fees, where providers are not changing month to month the actual care plan for a person, but still taking 50%, and they're going to move those profits over to the other side, where we're not putting caps in. And so I would urge the Minister, this is an area I have cared deeply about for 6 years, and it's an area, one of the few areas in this parliament where I would say I actually have a very reasonable amount of knowledge in. And we are going to make older people even more vulnerable to some of the scrupulous practices by many home care providers. And I have a regional electorate. I understand what you're saying with respect to, well, we don't want to make sure that it's not profitable and people move out of delivering regional services. I can tell you right now, on Kangaroo Island, it is incredibly difficult. You get given a home care package by the government, you try and find anyone willing to do it. That's already an issue. But what we're going to see in areas where they're still willing to deliver is they are just going to profit shift from one side of the equation over to the other. And what we want to see in this place is people get more hours for their home care, and that will not happen with how this legislation currently is.
The question is that the amendment be disagreed to. And I call the honourable member for Brisbane.
I just want to thank the member for Mayo for her work on this bill and the amendments she circulated. We recognise and agree with the broad concerns she's raised about the level of delegated legislation in this bill. It certainly isn't our preference, and we would encourage the government to address those concerns in a way that addresses the issues highlighted through the Senate committee inquiry process. I understand a number of crossbench MPs and senators have raised those issues with the minister, and I look forward to the outcome of those discussions. We have consulted with a number of stakeholders on the amendment circulated by the member for Mayo in the time that was available. As I said, we support the intent to ensure greater accountability in legislation and greater protection for consumers. Given the policy development that's underway by government, the advice we've received from a number of stakeholder groups is that they support the existing process. So we won't be supporting this amendment in the House. However, we remain open to improvements to the bill and will be continuing to consult with stakeholders on how we can ensure this legislation is as transparent and as strong as possible.
The question is the amendment be disagreed to. I'll put the question. All of those of the opinion say aye. No. I think the ayes have it. Noes have it. Division required. Need two voices. In that case, ring the bells for 4 minutes. block the doors. The question is the amendment be disagreed to. The ayes will pass to the right of the chair and noes to the left. I appoint the honourable members for Werriwa and Parkes as tellers for the ayes. I will need 2 tellers for the noes. I require 2 tellers for the noes. The members for Clark and Indi as tellers for the noes. Order. The result of the division is ayes 75, noes 12. The question is therefore resolved in the affirmative. And I give the call to the Minister.
Thank you, Speaker. I present a supplementary explanatory memorandum to the bill.
And I call the Minister.
Thank you, Speaker. I now move the government amendment as circulated.
I call the Minister.
The government will be moving amendments to the Implementing Care Reform Bill as circulated. Before I speak directly to those amendments, I'd just like to once again acknowledge and thank everybody who has either contributed to the Senate inquiry or to the ongoing consultation around the delegated legislation. One thing that has been extremely clear to me throughout this process is that we all have a very clear shared goal to see older Australians get the care that they deserve from the aged care sector.
Order asked.
There is clear support for the intent of this bill.
Members to resume their seat. Members to resume. The Minister may continue.
The government is progressing amendments to the bill because of feedback received during the Senate Community Affairs Legislation Committee inquiry and their subsequent report. And I would like to specifically thank Senator David Pocock and his office for their productive and early engagement on these changes, as well as all of the members and senators that have engaged with me and my team on this. I'm open to working with anyone who wants to see improved outcomes for our aged care sector. The amendments will clarify points in Schedule 1 of the bill. They specifically relate to exemptions that may be granted to approved providers in relation to the 24/7 registered nurse requirements. The amendments provide that the Secretary will be the decision-maker in respect to any exemption and that they must be satisfied that the provider has taken reasonable steps to ensure that the clinical care needs of the care recipients in the facility will be met if that exemption is granted. This will ensure that the needs of the care recipients are central to any decision to grant an exemption. The amendments also provide that an exemption cannot be granted for longer than 12 months, ensuring that exemptions are regularly being reviewed. Finally, the amendments provide that the Secretary must publish details in relation to any exemptions that are granted. These decisions should be public, as it will incentivise providers to meet that requirement rather than seek an exemption. It will also increase transparency, providing older people and their families with information so that they can make more informed decisions about their care. We are committed to getting aged care reforms right to deliver the care that old Australians deserve, and we will continue to work through the details with the sector, unions, older Australians and our colleagues in this place. We continue to be very open to having discussions and working with other members of this parliament to work towards better outcomes for older Australians. We want to do this reform once, we want to do it well, for a lasting positive impact on people's lives, and that will require all of us to work together to make it happen. I thank the House.
The question is the amendment be agreed to. I'll put the question. All of those with opinion say aye. No. I think the ayes have it. The question now is that this bill, as amended, be agreed to. I'll put the question. All of those of the opinion say aye. Aye. Against noes. I think the ayes have it. This bill, as amended, has been agreed to. And give a call to the Minister.
Thank you, Mr Speaker. I ask leave of the House to move the third reading immediately.
Is leave granted? Give the call to the member for Capricornia.
Leave is granted.
Give the call to the Minister.
Mr Speaker, I move now that this bill be read a third time.
The question is that this bill be now read a third time. Put the question. All those opinions say aye. Aye. Against noes. I think the ayes have it. And I give the call to the clerk.
Third reading, a bill for an act to amend the Aged Care Act 1997 and for related purposes.
And I call the clerk.
Government business, order of the day number 2, Treasury Laws Amendment 2022 Measures number 2, Bill 2022, resumption of debate on the second reading.
and give the call to the honourable member for Hume.
Thank you, Mr Speaker. Mr Speaker, the Coalition will be supporting this bill. This bill implements a number of sensible measures of the previous Coalition government. For a number of these measures, the implementation was delayed due to the COVID-19 pandemic. The bill provides effective changes to support small businesses in handling their affairs with the Australian Tax Office, providing them with additional supports in the event of inadvertent breaches as opposed to financial penalties. It provides small businesses additional support in dealing with the ATO appeals process and removes tax barriers that support sole traders and individuals looking to upskill. It supports gig economy contractors and companies to manage their tax obligations and ensure that the ATO has the data it needs to ensure accurate reporting. And, Mr Speaker, it puts in place, Mr Deputy Speaker, it puts in place important reforms to support the Coalition's election commitment to support Australians over 55 to downsize their properties and contribute to their superannuation. This bill builds on the Coalition's strong record of supporting small businesses, supporting retirees and sensible reforms to superannuation, as well as supporting the housing market.
The question is the question is that the bill will be now read a second time. No. Minister.
Okay. Just for the benefit of the House, the electric vehicle bill has come down from the Federation Chamber. What I'd like to do is simply adjourn this debate until a later hour, deal with the electric vehicle bill so that we can finish that, and then we'll return to this. So,
thank you.
Okay, thank you very much. I appreciate the House. I'll move that the debate be adjourned to a later hour this day.
The Minister's moved that the debate be adjourned for a later hour of the day. All those that have opinion say aye. The contrary, no. The ayes have it. I have to report that the Treasury Laws Amendment Electric Car Discount Bill 2022 has been fully considered by the Federation Chamber and has been agreed to without amendment. The question is that the bill be agreed to.
To move the third reading immediately.
Is leave granted?
Leave is granted.
Minister. Just before we call the Minister, apologies, we must put the question that we have to report the Treasury Law Amendment Electric Car Discount Bill, etc. The question is that the bill be agreed to. All those of that opinion say aye. To the contrary, no. The ayes have it. And now Minister has the call.
I'll now ask leave of the House to move the third reading immediately.
Is leave granted?
Leave is granted.
Minister.
I move that the bill be now read a third time.
All those of that opinion say aye. To the contrary, no. The ayes have it. Clerk.
Third reading, a bill for an act to amend the Fringe Benefits Tax Assessment Act 1986 to exempt benefits relating to cars that are zero or low emissions vehicles and for other purposes.
This bill has been agreed to. Clerk.
Government business, order of the day, number 2, Treasury Laws Amendment 2022, measures number 2, Bill 2022, resumption of debate on the second reading.
The question is that this bill be now read a second time. The member for Griffith.
Thanks, Deputy Speaker. I move that the amendment circulated in my name be agreed to, that all words after that be omitted with a view to substituting the following words. Whilst not declining to give the bill a second reading, the House notes this bill delivers a Liberal Party election commitment adopted by the Labor Party, namely the downsizer contribution, adding to the list of Liberal Party economic policies adopted by the Labor Party, such as the Stage 3 tax cuts. and calls on the Labor government to stop adopting taxation measures that will increase inequality and instead ease cost of living pressures by getting dental into Medicare, making childcare free, wiping student debt and freezing rents. Do we keep going? All right, great. That's okay. yeah, of course. Deputy Speaker, we're in the middle of one of the worst cost of living and housing crises in a generation, and the government continues to just tinker around the edges with bills like this. Right now, this House should be considering a bill to repeal the Stage 3 tax cuts and invest the revenue in dental into Medicare, free childcare and affordable housing. But instead, Labor are enshrining a Liberal election promise into law. The Prime Minister has talked about tough choices that this government will have to make when passing the upcoming federal budget. But why is it in Australian politics that the tough choices are always made by everyday people? Because when it comes to the federal budget, one of the things you can be sure of is that the politicians, billionaires and big corporations who run this country won't be the ones making those tough choices. And nothing illustrates that better than Labor's Stage 3 tax cuts. $224 billion. That's how much Labor's Stage 3 tax cuts are going to cost this country. So when it comes to tough choices, let's talk about exactly who will be making them. Because it certainly won't be the Prime Minister, who earns $549,250 a year, more than $500,000 or 13 times the minimum wage. The Prime Minister will receive an extra $9,000 a year from his government's own tax cuts. Nor will it be the Treasurer, who earns a measly $396,000, only 9 times the minimum wage. The Treasurer too will receive an extra $9,000 a year from his party's own tax cuts. It certainly won't be a lowly back or crossbencher like me, who earns an outrageous $217,000 a year. In fact, the last thing anyone in this place needs is an extra $9,000 a year. Indeed, what we all really need is a pay cut. It absolutely won't be Alan Joyce, CEO of Qantas, making any tough choices, who received $1.98 million last year while Qantas laid off 8,500 workers. The government has decided that he too needs an extra $9,000 a year. Indeed, the only tough choice any of them have to make is how to spend that extra $9,000 a year. Who knows, maybe it'll be on an extra investment property. But I'll tell you what real tough choices look like. A tough choice is a teacher having to use their own money to feed kids in their school who would otherwise go without. A tough choice is a pensioner having to choose between paying the rent or buying groceries. A tough choice is a single mum working out where to park the car for the night after she and her kids were evicted from their home because they couldn't afford to pay the rent. A tough choice is working out how long you can ignore that toothache because you can't afford to go to the dentist. A tough choice is a family having to cancel their first holiday in years because the mortgage repayments just went up by $200 a month and they don't know how they're going to make ends meet. A tough choice is a childcare worker wondering how much longer they can survive on low wages and long hours. A tough choice is a young man struggling to find the hundreds of dollars a week it costs to pay for mental health support that he so desperately needs. These are the tough choices that Australians make every day, and they are tough choices imposed on them by the decisions of federal and state governments. So when the Prime Minister talks about tough choices, let's remember that by repealing the Stage 3 tax cuts, we can invest $224 billion to ensure everybody in this country has what they need to live a good life. We could fund a universal free breakfast and lunch program in every school so that teachers don't have to worry about which of their kids is eating today. We could raise the pension above the poverty line so that pensioner can retire in comfort and doesn't have to decide whether or not he pays the rent or the groceries. We could build enough public housing so that single mum can move straight into a well-designed, rent-subsidised public home. We could bring dental into Medicare so that no one has to put off going to the dentist because they can't afford the $1,000 it's going to cost. We can improve paying conditions so that childcare workers are able to stay in a profession that they love, knowing that their work is valued and that they can afford to buy a house of their own and put down roots. And while we're at it, we could make childcare free so no parent has to make the tough choice to give up opportunities in their lives because they can't afford childcare. We could bring mental health into Medicare so that that young man would be able to afford to get the support he needs straight away without actually having to stress about how he's going to pay for the $200 a week it costs to get therapy. But instead of choosing to help out that teacher, the pensioner or the single mum, the choice Labor are making with their Stage 3 tax cuts is to double down on a political and economic system that always makes the lives of everyday people tougher, while handing out billions of dollars to the super-rich billionaires and big corporations. The amendment I've moved today is about this place signalling to the government that the last thing we need is more of the same. The last thing we need is more Liberal Party election promises, and the last thing we need is the status quo. It's time this government scrapped the Stage 3 tax cuts and instead spent $224 billion funding the services everyday Australians need to live a good life. You could vote on behalf of everyone in your electorate struggling to pay for housing, groceries, healthcare and childcare, rather than on behalf of the top 1%. You could vote to ensure that none of us sitting here on at least $217,000 a year gets an extra $9,000 a year while there's people sleeping in cars.
Is the amendment seconded? Member for Brisbane.
I second the amendment and reserve my right to speak.
The original question was that this bill be now read a second time. To this, the honourable member for Griffith has moved as an amendment that all words after that be omitted with a view to substituting other words. So if it suits the House, I'll state the question in the form that the amendment be disagreed to. Member for Brisbane.
4 months ago, I was working in a retail job in the suburbs of North Brisbane. I was making about $55,000 a year, just above the median wage in Australia. At times, myself and many of my colleagues lived paycheck to paycheck. I have countless memories of us sitting around the break room talking about our financial stresses, making rent, finding a doctor that would bulk bill, complaining about toothaches and being unable to afford a dentist. Frequently, single parents would be forced to choose between working a shift or utilising childcare. Not working a shift lost them income, but utilising childcare was the more expensive option. These conversations were not unique to my former workplace. They happen in break rooms and at work sites around the country. All of us know things shouldn't be this hard, that something is very wrong. No one should be putting off visiting the dentist because of the cost, or living in constant fear of not being able to afford rent. And yet, for millions of Australians, this is the reality. To combat these issues, rising inflation, spiralling healthcare costs, rent stress, interest rate hikes, what is the government's response to my former colleagues? The Stage 3 tax cuts. A $269 tax cut for my former colleagues and a $9,000 tax cut each year for CEOs and politicians. The Labor government tells us that tough decisions will have to be made in this year's budget. But when it comes to supporting tax cuts for the very, very wealthy, these are not hard decisions. The Now government voted for these cuts at their introduction. They made the decision to support bad legislation then, and they have doubled down on it now. When I asked the question in question time, the Treasurer could not give me a single reason why these tax cuts were good for the economy. I don't even think the government wants to keep them. They are now in a wedge of their own making. Every day I am contacted by constituents who cannot fathom the government's decision to not repeal these cuts, and I can't give them a good answer. They didn't make sense when the government voted for them, they don't make sense today, and they won't make sense in 2024. We need courage. We need the government to show everyday Australians that you are really on their side. The government wants to pretend they are powerless to stop terrible coalition policy, but they're not. They have the majority in this House, and they would have the support of the Greens both here and in the Senate to repeal these cuts, these tax cuts. The government often talks about its legacy, Medicare, the PBS and so on. But this will be Labor's new legacy, a government of tax cuts to the rich at the expense of meaningfully raising income support, JobSeeker, the pension, the DSP, a government that legislates people into poverty, a government that looks at the cost of living crisis and thinks, politicians need a tax cut. And it is that simple. Our essential public services are funded by taxation. If the government wants to rip out over $200 billion of revenue, cuts to public services will have to be made. There's no two ways about it. The government has the nerve to claim these tax cuts will mean more in people's hip pockets. But how will they reconcile this with the fact that these cuts will have to be paired with essential services becoming harder to access and more expensive? Right now, it is getting more and more difficult to find a bulk billing GP. Our healthcare system is at crisis point, higher education is becoming out of reach, and students are saddled with over $60 billion in debt. How can they possibly plan to address this with a $200 billion plus gap in the budget. This is a natural consequence of government's commitment to neoliberalism and the hollowing out of public services. This is the government suggesting that the very richest people in Australia will solve the cost of living crisis out of the goodness of their hearts, despite all history pointing to the contrary. This did not happen during the Great Depression, and it did not happen during the global financial crisis. It is said that history repeats itself, first as tragedy and second as farce. The Coalition's policies consign them to irrelevance in this parliament. Why does the government want to follow in their footsteps? It seems I'm expected to go back and tell my former co-workers that despite their financial stress and despite our near universal acceptance that our economic system is broken, that we can't afford to fix their problems. It's a lie. We can. We have solutions ready to go, solutions that have precedent. They already exist in countries around the world. They can be done, and why should Australians be left behind? We have been bold and courageous enough in the past to transform our country for the better. I am here because of a community's hope for a better future and to put a stop to politics as usual. We can get dental and mental health into Medicare. We can make childcare free, we can wipe student debt, and we can freeze rents for 2 years. It's just that this Labor government would rather give themselves a tax cut.
The original question was that this bill be now read a second time. To this, the honourable member for Griffith has moved as an amendment that all words after that be omitted with a view to substituting other words. So if it suits the House, I will now state the question in the form that the amendment be disagreed to. The member for Petrie.
Well, thanks very much, Mr Deputy Speaker. Look, I want to speak on this as the member for Petrie. This motion, or what the Greens are talking about here, is just total rubbish. The reality is that the Greens do not love this country. The Greens want to change everything that is successful about Australia. The reality is that their own leader won't even stand in front of the Australian national flag. Can't do that, yet he's an elected member of this House. The reality is that the member for Griffin and the member for Brisbane probably got 35% of the vote when you count in LNP preferences, because LNPs voted one, and then they put Labor next above the Greens. That's the reality. So these two members are here with probably 35 to 40% of the vote, but the way the system works, it delivered the seats to the Greens rather than the Labor Party, which is a real shame. It shows that our democratic process is not working when these two members can get elected with 40% of the vote and 60% of people in their own seats voted for Labor before they voted for the Greens. The Greens here won't stand in front of the Australian flag. The Greens want to cut the Defence Force budget in half. And as a father with a son in the Defence Force, I say that is shameful. And that is before the previous coalition government even committed to increasing the budget, which I'm sure the Labor Party will hopefully support. They want to cut it in half. The Greens here want to ban private schools. They don't want a Catholic school in the country. They don't want a Lutheran school in the country. They only want state schools. Their policies are rubbish, absolute rubbish. They don't deserve to be taken notice of by the Australian people. And when it comes to stage 3 tax cuts, the reality is that the former government and the current government supported stage 1 and stage 2 tax cuts, which gave tax cuts to the poorest people in our community. It ensured that there's $18,200 that every person earns, including students, tax-free. Tax-free. It ensures that from $18,200 to $45,000, it's 19 cents in the dollar, and stage 3 ensures that everyone from $45,000 up to $120,000 receives a tax cut from 32.5 cents to 30 cents. So talk about politicians, wealthy people, Clive Palmer, whoever you want to talk about, Greens, but the reality is that most people in Australia will get a tax cut under stage 3. So rather than talking the country down, get up and start talking about what's good in this country, like the government and the opposition often do. Mr Deputy Speaker, that's all I've got to say on this issue. Thank you.
The question is that the amendment be disagreed to. The member for Sturt.
Thank you, Deputy Speaker. I rise to support this excellent implementation of the former Morrison government's suite of important policies, including in particular the adjustment to the eligibility for the downsizer contribution into superannuation. I note there's an amendment from the Greens condemning this and anything else that puts money back into the pockets of hard-working Australians, and I appreciate the opportunity to prosecute their position on these things in my electorate of Sturt. It would horrify them to think that it's a position of a party like the Greens to reverse and take away Australians' hard-earned savings in the case of super, or hard-earned money from the point of view of an appropriate regime of income tax rates that don't unfairly punish people that are damn hard workers and deserve as much of their money in their own pocket as they can have. Now, on downsizer, this is a really significant reform, dropping the eligibility age to 55. And I was thrilled when this was announced during the election campaign by former Prime Minister Morrison. Look, I'm happy enough, obviously, like many other things, that Labor a few minutes later said that they'd do the same thing and me too'd the policy, and so now we're here implementing it, because it would be very transformative for retirement planning for so many of my constituents in the seat of Sturt, so many Australians nationwide, frankly. What it allows people to do is plan with so much more certainty for their financial security in retirement. And it's a very big decision to make, and a lot of people plan many years in advance as to how they are going to make sure they have provisioned enough to support themselves in what should be a very relaxing and non-financially stressful retirement, which I also wish anyone going into retirement many, many years of it. And self-funded retirees are the great economic heroes of this nation. And I want to again, as I always do on legislation related to self-funded retirees, thank them so very much for what they do to provision for their retirement and the costs of that retirement. And by doing that, they take an enormous burden off the Commonwealth government and all government, frankly, because they fund the cost of their own retirement, and if they didn't, we, of course, would do so through the aged pension and the other supports that are put in place for all Australians who absolutely deserve it if they're not in a position to provision for their own financial requirements in retirement. But those that are self-funded retirees do so much to take the burden off the taxpayer and allow us to invest more money, frankly, in so many other services that are good for all Australians. So thank you to them. And what this allows, of course, by reducing the age of 55, is that a lot more people can start to provision, potentially sell a large family home much sooner than they would have if they were waiting for this important tax concession to be eligible for. And if you think of a couple that own a family home that isn't necessarily a home that they need once their children have moved out, it probably has a large amount of value in it. From the age of 55, that couple can sell the home and put $300,000 each into their superannuation without it being taxed on the way in. There's an enormous incentive, therefore, to do that, of course. And that puts people in a position to do it from the age of 55, well in advance of when they might ultimately retire and start to call upon their superannuation. And there's an enormous peace of mind in undertaking that transaction, getting it done, putting the money into super, being able to equally move into a different home that's more appropriate for the stage of life that you're moving into, meet the costs of doing so, and we all know, everyone's moved home, we all know there's a lot of cost in moving from one home to another. Even if you're downsizing, there's a lot to get organised and arranged, and there's always unforeseen or unexpected cost in doing that, and a lot of people would feel much more comfortable doing that while they're still in the workforce, while they're still earning a salary or wage, and they can, through this measure, now effectively undertake that process from the age of 55, square away those arrangements, put money into their superannuation, therefore reassess their superannuation, the amount that they've provisioned in their superannuation, have a new home that they probably intend to spend the balance of their retirement in, settle all that down, meet all the costs of that transaction, of that relocation, of purchasing a new property, of provisioning those funds into superannuation, settling their affairs in the comfort of still being well and truly in the workforce, earning an income, not staring down the barrel of very imminent retirement, and the uncertainty, therefore, of whether or not you'll get the value that you are hoping to for the property that you sell, that the new property you move into costs what you thought it would cost, that all the various taxes and charges that particularly the state governments put on you through the process of selling one home and moving into another. Now, the other benefit of this, of course, is that it will encourage people to sell dwellings that are appropriate for a family that they might no longer have as appropriate for the next stage of their life that they are approaching, which is retirement, and probably with the kids having grown up and moved on, although there's a whole other problem around that isn't worth getting into for this debate. But and in doing so, this will, I hope, I'm sure everyone hopes, which is why the government Me Too'd the policy that we announced, we hope that it will increase the supply of family homes to help young families who are at a very different stage in their life and in the economic cycle, and what they're doing with having children, raising them, etc., is that they will, it will be easier for them to purchase an appropriate family home, because more people that have a family home that don't need it anymore are making the choice to sell, encouraged through this measure and through this tax concession, which I hope, I'm sure we all hope, will increase the supply of family homes in the marketplace. And this is another enormous challenge we've got at the moment around housing affordability, and particularly homes that are appropriate for people who are looking to transition from maybe the first home they purchased, if they have been lucky enough to even get into the property market, which is just ever increasing challenge, and recent increases to interest rates are only making it harder still. But hopefully this helps the category of people that had bought their first home. It was appropriate for them at a certain stage of life, but when they're in the category of people that have since taken, either partnered up and are moving into the place of their life of having children, or they might have, as a couple, bought their first home together but weren't at the stage of the life when they were looking to have children. They're now at the point where they are either looking to do that or in fact have done that and have very young children, and the home that they're living in at the moment is not perfectly suited to the needs of a young and growing family. So we've got people that reach the age of 55 who, in many cases, will have exactly that type of dwelling, exactly that type of home. They probably have spent the last couple of decades raising their own family in that home, and now they're put in a position where they don't need that particular type of property anymore. So by encouraging them with these very sensible tax incentives to have the benefit of downsizing from that property and putting a significant contribution, either individually or if you're a couple, both of course get the opportunity, then I think we could have a good outcome for helping younger people as well get into family homes. Now, this is obviously completely voluntary, and I respect, and my parents, funnily enough, are in this circumstance themselves, where they certainly are not downsizing their property. They're very happy staying in a larger family home, and that is, of course, absolutely their right to do so. But all we're doing here is is providing the opportunity for those that choose to have an enhanced incentive through avoiding taxation on up to the $300,000 amount of contributing from the proceeds of selling that property going into super. Now, that obviously means they're downsizing because they will have sold their property, and if they take advantage of this, they're going to have less money left over, having contributed up to the $300,000 into their superannuation to go towards the property that they're buying to replace the one that they've sold. So I think the outcome is quite self-evident there, and it's going to be an excellent opportunity for people to plan and provision for their retirement. There's a couple of other measures again that emanate from the previous government in this TLAB 2 bill, and others have probably commented on that, but in particular being a lot more flexible with small businesses around honest mistakes that they might make in the way in which they manage their business accounts that might inadvertently lead to them misrecording and therefore misreporting certain things to the ATO. And absolutely, I'm pleased this new government is continuing with a position of the previous government to not be too heavy-handed with people when they've probably made some genuine and honest mistakes. So, a bit like community service, instead of being sent straight to jail, where, frankly, the circumstance most probably is that they haven't meant to make a bookkeeping error. It's not something that we will condone into the future, but of course one option is that they undertake appropriate training to understand why they've made certain mistakes in the accounts of the business, and of course they won't get a second chance if, having done that, they make the same mistakes again into the future. So I think that's eminently sensible. I'm particularly pleased, though, as I've made clear, that we're here to give an opportunity for much greater security for people planning their retirement. And again, I really do thank the millions of Australians, a growing cohort, who are provisioning for their own retirement. I've made the point as to how much of a significant economic contribution that is, and how much of a significant budgetary contribution it is, particularly to the Commonwealth budget. And this is one thing we can do to help them feel more secure in their retirement. I think it will also lead to more people being self-funded retirees and taking a further financial burden off the Commonwealth payments that are made. That in no way is any criticism of people that do need and should always have the support of us to have the aged pension and other government supports in retirement. But clearly, where people can afford to support their own retirement, that is a significant help to the Commonwealth, and this is one very good opportunity we have to help those people who help us in that way. I commend the bill to the House.
Thank the member for cert. The question is that the amendment be disagreed to. The member for Ryan.
Thank you, Deputy Speaker. We have a Treasury Laws Amendment Bill in front of Parliament right now that simply does not address the biggest budgetary issue in this country, Labor's Stage 3 tax cuts. So I wanted to take this time to ask, who does this government govern for? Because it's not clear to me it's for everyday people. The rhetoric is there, but you have to look at the actions. And at the moment, Labor are about to rip $244 billion out of the budget over the next decade and hand the bulk of it to the ultra-wealthy. $244 billion, $250 billion. Now, Labor will say that they inherited these handouts for the mega-rich from the previous government. Not true. They, in fact, voted for them, along with the Liberals. This was a bipartisan commitment to putting money that was meant for health, education and social support into the hands of people who don't need it. But Labor can reverse it. It's okay. Be mature. Admit you made a mistake and repeal these tax cuts, and do it now. Because Labor's Stage 3 tax cuts aren't just some numbers on paper. They will affect millions of people's real lives. People in this chamber may be sheltered from this on these frankly absurdly large salaries that we have, but many everyday people out there are going through hell right now with a cost of living crisis unlike any in recent memory. If you were just getting by a year ago, you're in a state of absolute stress and anxiety now. If you were just making rent or mortgage repayments before, just managing your electricity bills, you are really stressing out now about where to find that money. Inflation is running at 6.1% and real wages have fallen by 3.5%. It is tough out there. Rents have spiked 16.9% in Brisbane in the last 12 months. Mortgages are about to significantly increase with the RBA's cruel, recent interest rate hikes. We're hearing of more and more people finding themselves actually without a roof over their heads. We have families sleeping in cars. But instead of taking that $244 billion and spending it on the things that will help everyday people get by, like building public housing, doubling JobSeeker, funding Medicare properly, Labor have decided to hand it over as tax cuts, the bulk of which will go to the mega-rich of this country. These tax cuts are actually quite obscene. Of this $244 billion, the richest 1% in Australia will receive as much as the poorest 65% of Australia combined. The top 20% of income earners will receive 77% of this $244 billion. For the rest, crumbs. Members of this chamber will receive $9,000 in tax cuts a year. Alan Joyce will receive that too. Billionaires like Gina Rinehart will get $9,000 in tax cuts a year. And 2/3 of these tax cuts will flow to men, while only 1/3 will come to women, only furthering that gender pay gap. I'm sorry if it offends people in this chamber, but someone on over $200,000 a year doesn't need another business-class flight every year. My Greens colleague, Max Chandler-Mather, has just moved an amendment to this Treasury Laws bill to call on this government to stop these unjustifiable Stage 3 tax cuts. There's no reason to proceed with them. Let's use this opportunity to drop them now. So while Labor are handing out $9,000 to the Alan Joyces of the world, our public services are eroded. But imagine what we could do with $244 billion. And since Labor seem to be lacking in imagination at the moment, here's a quick list of some of the things we could do with that $250 billion. Medicare hasn't kept up with inflation, so it's increasingly impossible to see a bulk billing doctor. We could fix that, giving everyone access to genuinely free and comprehensive health care. People can't access dental under Medicare. We could make seeing the dentist something everyone can do for free. Our nurses, teachers, early childcare workers are underpaid, our hospitals are understaffed and our schools are underfunded. We could make sure our health and education are fully funded, world-class, and our essential workers are looked after. JobSeeker is well below the poverty line. With $244 billion, we could double it and ensure everyone has something to fall back on when times are tough. The pension is also below the poverty line. We could let everyone have comfortable, happy retirements, regardless of whether they were fortunate enough to accrue a lot of super. Childcare is prohibitively expensive for so many families. We could make it free. We have hundreds and thousands of people currently on the waiting list for social housing. With $244 billion, we could build enough beautifully designed public housing to give every single one of them a decent home and have plenty left over for people who just want a secure place to live for low rent. Yeah. One of these things alone could be transformative, but with $244 billion, we could go a long way to making all of these a reality in Australia. And we have a Treasury Laws amendment bill in front of us that doesn't mention Labor's Stage 3 tax cuts. It doesn't repeal them, though it could. It doesn't free up that $244 billion to fund the things that everyday people need. We in the Greens, whenever we suggest that the government could deliver something that would genuinely help everyday Australians, like bringing dental into Medicare, like raising the pension, lowering the age of retirement, they cry poor. They say we're in too much debt. Too much debt? When we could give billions upon billions in handouts to the mega-rich? Well, you can't use public debt as an excuse to not fund social programs, while ripping $250 billion out of the budget. It's an insult to the intelligence of everyday Australians. So why does this government not govern for the real people? If they go ahead with these tax cuts, it'll be sadly all too clear that they're not governing for the person who can't afford to see the dentist, the person who's lost work, not for the person who can't afford to pay the rent or mortgage. They will be governing for the mega-rich. Thank you.
The question is that the amendment be disagreed to. The member for Forde.
Well, thank you, Mr Deputy Speaker, and I'm always pleased to rise and speak on a Treasury Laws Amendment bill, and it's good to see the Assistant Treasurer in the House for the contribution. I'm sure he'll appreciate it, as he always does. But this bill implements a number of sensible measures from the previous coalition government. And I'm pleased to say, Mr Deputy Speaker, that it's good to see the government pursue and look to implement those measures, just a long line in a range of many sensible measures that we implemented over the last 9 years in government. A number of these measures, their implementation was delayed as a result of the COVID-19 pandemic. But this bill provides effective changes to support small business in handling their affairs with the ATO and providing them with additional supports in the event of inadvertent breaches as opposed to penalties. Now, I'll say, Mr Deputy Speaker, at the outset that the ATO and its relationship with small business, I think, would be fair to characterise it as one of certainly not a love-love relationship. It's probably more a love-hate relationship, and anything that we can do in this place to make those relationships better and to ensure that small business is treated by the ATO with the respect and dignity they deserve, and ensuring that where they do make inadvertent errors, that they're not inappropriately penalised for those oversights, because they don't have the accounting departments and the chief financial officers and all of those things that our large corporates do. Many of our small businesses are mum and dad businesses where they're not just the financial managers, they're also seeking to run the business each and every day, generate sales, generate revenue. More often than not, they have a mortgage on that small business which is secured by their home, so they've got the pressure of keeping a roof over their head, which is entirely dependent on how the business goes. They are employing people in our local community. They are supporting our local sporting clubs and community organisations. And they certainly, Mr Deputy Speaker, don't have HR departments. The business owners are the HR department. This bill provides small business additional support in dealing with the ATO appeals process and removes tax barriers that support sole traders and individuals looking to upskill. It also importantly supports the gig economy contractors and companies to manage their tax obligations. And we all know in this place, increasingly, Mr Deputy Speaker, the growing prevalence of the gig economy in a whole range of areas. So, as I said, the measures in this bill put in place the reforms that support, also put in place the Coalition's election commitment to support Australians over 55 to downsize their properties and contribute to their superannuation. And as I've said, Mr Deputy Speaker, this bill builds on the Coalition's strong record of supporting small business, supporting retirees and making sensible reforms to superannuation and supporting the housing market. Schedule 1 of the bill amends the Tax Administration Act of 1953 to empower the Commissioner to direct an entity to complete an approved record-keeping course where the Commissioner reasonably believes the entity has failed to comply with its tax-related record-keeping obligations as an alternative to existing financial penalties. Now, I think that's an excellent move, Mr Deputy Speaker, and One of the benefits of the increase in technology that we see all around us is the ability now for small business to have access to good technology to much better keep records. And I know one of the areas, because I see the work that my brother does as a ceramic tiler in the building industry, this is an important area, I think, particularly for tradespeople and self-employed people, where they don't necessarily keep the records that they should keep, and if they can do a record-keeping course, get access to appropriate software and other training to better manage their financial and tax affairs without being penalised, I think that's a particularly good initiative. The bill also introduces in Schedule 2 a third-party reporting regime which will require sharing economy online platforms to report identification and income information regarding participating sellers to the ATO for data matching purposes. And we've already seen that in other areas, particularly in the building sector, Mr Deputy Speaker, where there are reporting requirements for data matching purposes. This measure will apply to ride sourcing, short-term accommodation platforms, asset sharing, food delivery, task-based platforms and other platforms in the economy. And once these platforms begin these measures, it's expected to result in increased self-reporting of currently unreported or underreported income by sellers. Schedule 3 of the bill amends the Income Tax Assessment Act to make consequential amendments to fringe benefits tax, to remove the exclusions as a deductible expense, the first $250 of expenses for prescribed courses of education. Another measure, Mr Deputy Speaker, which I think adds to providing the incentive to undertake additional education to build the skills of small business owners and tradespeople. And this delivers on the Coalition's 2021-22 budget commitment to backing small business with a simple, fast and cheap way to pause or modify— sorry, that's a separate matter. Schedule 4 does this, in relation to orders with the AAT, and to stay those orders or otherwise affect ATO debt recovery actions. Now, this is an area, Mr Deputy Speaker, where I've had many discussions with small business operators across my electorate and the conduct of the ATO in these particular matters. And I'll congratulate the government on taking this coalition budget measure of backing small business with a simple, fast and cheap way to pause or modify the ATO debt recovery action. In relation to debt that is currently under review by the AAT. I would go a step further, Mr Deputy Speaker, and look to see a wholesale reform of this area and ensure that the ATO is much more forthcoming in the reasons and explaining why it actually comes up with these assessments in the first place. But this is a good step in the right direction by enabling small business to pause any ATO debt recovery action while their case is being decided by the independent umpire. Schedule 5 of the bill partially implements the Helping Homeowners Who Want to Downsize commitment announced by the government on the 15th of May 2022, and this by the former government, I should say, and this was ultimately matched as an election commitment by Labor. These measures, Mr Deputy Speaker, I'm pleased to say, build on the tremendous track record of the coalition government over the last 9 years of providing support to small and medium business across the economy in recognition of the tremendous effort that they provide to in innovation, employment and generating wealth for our country. We often hear about our big corporates, but more often than not, where a lot of our innovation occurs is actually in our small to medium business sector. And this the measures we took during our time in government were because we understand the importance of small and family business across our economy. One of the great measures that we undertook when we were in government was the establishment of the Australian Small Business and Family Enterprise Ombudsman in 2016 to ensure that small business had an advocate within government and in the community. And as their part of the role, the Australian Small Business and Family Enterprise Ombudsman assists small business to resolve disputes through case management and alternative dispute resolution processes. The Coalition also bolstered the mediation services within the Small Business and Family Enterprise Ombudsman to establish a Small Business Taxation Dispute Division within the Administrative Appeals Tribunal. Now, I think, again, that was a tremendous step in assisting small business in what sometimes can be very difficult matters with the ATO. And I know that in my time on the Tax and Revenue Committee, Mr Deputy Speaker, we had many discussions about the ATO and the way they conducted their process of dispute resolution and management. We strengthened protections for small and family business through including them in the unfair contract provisions and providing greater access again to alternative dispute resolution processes through various industry codes. All of these measures, Mr Deputy Speaker, and many more are the track record that the previous coalition government has left for this country, for our small business sector, and I'm very proud to have been part of that government that delivered those key and important measures. But as we keep working towards supporting small and medium business across our economy, I'm happy to see the government take up some of those measures which we would have implemented if we had had the privilege of being re-elected to government at the last election, but I'm pleased to see that the government has decided to take these on and they are reflected in this bill.
The question is that the amendment be disagreed to. The member for Forrest.
Mr Deputy Speaker, as has been said here, the Coalition will be supporting this bill because it implements a number of very sensible measures of the previous Coalition government, and it is all about small business, as we've heard previously. The small businesses that employ the majority of Australians and do so very well in all of our small communities in particular, Mr Deputy Speaker, which is why, in common sense approaches as we see in this bill, the practical way that our small businesses work and the fact that they're often just a mum and dad business or two partners or an individual. And that's why even a practical approach to the Australian Tax Office is so important, as we see in the measures here, because, as we know, so many of our small businesses they don't have, as we know, a massive HR department to work with them. They are everything. They work all day in their business often and sometimes at night as well. They're in the role often 24 hours a day, 7 days a week. But they do an amazing job, and I want to recognise those small businesses in our support of this particular bill, particularly in small rural and regional communities. And the small businesses do a fantastic job of, one, keeping those local economies ticking over. But what they also do that is often unseen is the fact that they support every community service organisation, every one of our volunteer emergency service organisations, and they also support our sporting and other organisations. Whenever local people need a donation, the first place they go to is a local small business. So anything we can do in this House to provide that additional support and to assist them to managing their issues through the Australian Tax Office is a very good practical move, because it reduces the amount of time that they would be needing to spend on those matters and allows them to get on with what they're there to do, which is run their business and work in this business and employ other Australians, as we know, which is such an important part of the role that they play. And we see that, I see it in my own part of the world, and even when we're dealing with the matters around the Australian Tax Office, providing small businesses with additional support in dealing with the ATO appeals process and removing the tax barriers that support sole traders and individuals looking to upskill, practical matters for small businesses, supporting gig economy contractors and companies to manage their tax obligations, and ensuring that the ATO has the data it needs to ensure accurate reporting. It puts in place important reforms to support the Coalition's election commitment to support Australians over 55 to downside their property and contribute to their super. Really, the real key issue for me, though, is the strong support for small business. The supporting retirees, absolutely very sensible, and sensible reforms to super and the housing market. But I can recall in my time as an MP, Mr Deputy Speaker, which I think a number of members in this parliament would have done in their time as local members. There was an individual who got in touch with me who was 2 days before Christmas, and he said, the ATO wants to take my house and my business and I'll be out of business. And we had to work overtime to make sure that he connected with the right people in the ATO and was able to work through the issues that were on the table. And it was about 18 months or 2 years later, I happened to run into him at a local service station, and he bolted across to say, I am still in business and I still have my home. And I think that's one of the things that we get to do as local members, is facilitating very sound discussions that enable people to stay in business, work out their issues with the ATO if they're able to connect with the right people and get a fair hearing in what they're dealing with. And much in this bill is related to that. And so, you know, it is quite tough for a lot of small businesses to deal with the complexity that goes with dealing with the Australian Tax Office. And so there's a lot of benefits in this bill, even the one to seek orders from the Administrative Appeals AAT that stay or otherwise affect ATO debt recovery actions while the small business is disputing the underlying tax assessment in the Small Business Taxation Division of the AAT, sort of reflecting what I was talking about earlier, about the issues facing a small business and the sense of panic that they get if they've inadvertently particularly made an error or just need the right person to talk to work through their issues. And I'm really proud of what we've done. It really needs to help resolve disputes in a timely and cost-effective way. Access to justice, simple thing for small business. And the previous speaker, the opposition whip, spoke about us establishing, the coalition establishing the Australian Small Business and Family Enterprise Ombudsman. Well, I think that is a particularly important office. And this advocate that small business has now with government and in the community, such an important role. And I would encourage as many small businesses as possible. It really doesn't matter what issue you're dealing with. When you need assistance, get in touch with the Australian Small Business and Family Enterprise Ombudsman. There's a lot of other areas that they can assist you with, not just in this space. So resolving disputes through case management and referral to alternative dispute resolution. And for so many small businesses, this is something that they get to deal with, hopefully not very often, but when they do, they are time poor and often don't know where to start. How about you start with the Australian Small Business and Family Enterprise Ombudsman as a first point of call if you're not sure where else, as long as you're working. I imagine most of them work with their accountants and others. But in this instance, why not talk and contact the Australian Small Business and Family Enterprise Ombudsman? If you're aware of a small business in this space, please tell them to get in touch for that purpose. So we bolstered mediation services within the Australian Small Business and Family Enterprise Ombudsman and established the Small Business Taxation Dispute Division within the AAT. So that importance of strengthening protections for small and family businesses from unfair contract terms, and this happens on a regular basis. And we've seen some move in that, particularly with small businesses in the agricultural sector, and in changes we've seen for those that find them at the bottom end of a supply and value chain. The work of the in this space from unfair contract terms is very, very important. And over the years, Mr Deputy Speaker, being a dairy farmer, you would understand some of the challenges of having a perishable product and being in that position. It is a huge challenge for small business, particularly in the rural and agricultural sector in this space. And so our ongoing support for small business really, I think, I'm very proud of it. And even the instant asset write-off that we introduced, the amount of small businesses that were able to take advantage of that, and whether it was a small business such as a cafe or even a pizza shop. I've had the local guys who are livestock transporters, and they were able to use the instant asset write-off to be able to buy themselves new gear that they were desperately needing. And if you consider during COVID the amount of small businesses that really took advantage of this, but also were the ones who were still open. And they were mostly, in many instances, small businesses that did everything they could to keep their communities ticking over. And in a little place called Nannup, that was in my electorate at the time, the local supermarket, of course they had real struggles. You were allocated certain items, numbers of, and they had limited access to the one thing that we saw so much what would you say, hoarding of, which was toilet paper. So here's this little business in a tiny little community, and one of the local people came in and saw Joyce at the store and said, "What's going on? What are you short of?" And she said, "Well, this is something we're struggling to get hold of because we're limited to what we can have." So this gentleman drove a couple of hours where there were supplies, and he brought those supplies back to Nannup and said to Joyce, "Now, tell me who's been in, who desperately needs some of these." And what he did, he went around and he dropped them off on the front doorstep, safely, of these premises for the people who couldn't access them. That is the strength. That's what happens with small business, and that's what happens with good people in local communities. I also had small businesses that during COVID said, well, they had people coming from major areas, populated areas, into small communities looking for certain products. So what they did, they actually said to my own local supermarket, said, "Nola, stop panicking because we've got some supplies out the back. And for all of our regular, mature age, particularly customers, we're making sure that that one packet, be it of flour or sugar, or the things they buy every week, that we're making sure we're keeping those available for the people who need them most, the people in our small communities." And, Mr Deputy Speaker, that's the value of small community business, which is why I'm very proud of all of the measures that we took in our time in government to support small business, and I know that we'll be continuing to work in every way we can to support small business. Thank you, Mr Deputy Speaker.
The question is that the amendment be disagreed to. The member for Fisher.
Can you grab that for me, Aaron, please? Thank you, Deputy Speaker. And I want to thank the previous Speaker, the previous Chief Government Whip, for her outstanding contribution in this debate. The government will be supporting this bill, Mr Deputy Speaker, because the bill will be, and in fact does, implement a number of sensible measures that the coalition government examined in its previous and in fact pushed in its previous life. The bill provides effective changes to support small businesses in handling their affairs with the ATO, providing them with additional supports in the event of inadvertent breaches. Now, that's very important, Mr Deputy Speaker. Before coming into this place, I was a builder by trade, a carpenter by trade. I then owned a building business, and then I went and became a barrister. So I spent 30 years in small business before coming into this place, and I've always said that wouldn't it be great, wouldn't this place look a bit different if everyone had to spend time working in small business, if everybody had to understand the trials and tribulations of actually having to employ people, work their way around awards, how to pay people on awards, and quite frankly, sweating blood on a Wednesday night trying to figure out how I'm going to make payroll tomorrow. I've often told people who've spoken to me about their desire to come into this place, and I've said, you know, really, unless you've had those trials and tribulations, then in my view, you will be a lesser parliamentarian if you come into this place without having endured those things. And this bill really does a number of things, and I'll touch on them in due course. But one of them is that in Schedule 1, if the Commissioner is of the view that an entity has failed to comply with their tax obligations, specifically in relation to record keeping, then rather than ping them, then the Commissioner can require that person to undertake a course. And Schedule 1 actually reminds me of when I was a young fellow, when I was sitting for my builder's licence, and I had to go and do all these various courses. And you know, I would have been about, I don't know, in my early 20s at the time, in the HIA office. I still am, I wish I was, sitting in the HIA office in Brisbane with 30 or 40 other people, and a fellow by the name of Frank O'Neill. And Frank's the kind of guy who'll probably be listening to this right as we speak. So if you are, Frank, cheers, mate. You did a good job with me and with many of my colleagues, and actually you ignited my love of learning, so thank you for what you gave to me. But I digress. It's very important when people, particularly in small business, who come from various backgrounds, various levels of education, and sometimes, particularly in amongst the trades, certainly not exclusive to the trades, but in my industry, in the building industry, for many people who've come through the building industry, school was not their greatest forte. Lunchtime was my greatest subject, or my favourite subject when I was at school, Mr Deputy Speaker, as you can tell. And it was the opportunity to go and do these courses, to become better bookkeepers, to become better managers of your business, like the one that I did when I was studying to become a builder, was very much welcome and stood me in good stead, as it has done for hundreds of thousands of other contractors in Queensland, who, unlike, I should hasten to add, in some other jurisdictions in this fine country, do not require the sort of educational courses that you need to complete to become a builder. I think Queensland certainly had it right when I was going through some 35-odd years ago. So I really do acknowledge and congratulate the drafting of Schedule 1, which enables these sort of education courses. Rather than find someone, let's work with this individual and try and upskill them. That's surely better than just pinging them with a fine. The Schedule 2 of the bill is also an important provision which provides for data matching for the ATO. Now, it specifically does that in relation to ride sharing, ride sourcing, short-term accommodation platforms, and this is really important. And it's really just bringing those sort of data matching abilities into line with, once again, my old stomping grounds, that's the building industry. And it's interesting because I was, last week, or it may have been the week before that, I called upon a local business, Advanced Kitchens in Caloundra, in my electorate, and spoke with Carol Langton. Carol rang me up and she was frothing at the mouth. She was very upset about how she has to be doing all of these, what I'd ultimately called unpaid public service, which was, it requires small business to be doing all of these reporting requirements, particularly for their subcontractors. And after I had the opportunity to sit down with Carol and explain to her the importance of these anti-black market provisions, anti-black economy, I should say, provisions that enable the ATO to data match information against their own material that they're putting in, their own reporting of their own subcontractors. Carol, to her credit, could see the benefit of those requirements. Look, whilst I was at the office, at the warehouse, I should say, the factory, I had a good tour and saw the great work that Advanced Kitchens in Caloundra were doing. Met some of the staff. I met a gentleman, an older gentleman there that had been working there for decades, and he was in his 70s. And his granddaughter was, in fact, working at the factory and was keeping it in the family. But it's a terrific local business. And going back to the point, Schedule 2 essentially just brings up and brings onto parity the reporting requirements between your ride sharing and your gig economy type platforms and much more traditional businesses such as those in the building industry, and that those data matching requirements have been in place for a very long time. It's very important, as you would imagine, Deputy Speaker, that we do ensure that we have these provisions that are pretty tight in relation to the black economy. We want to make sure that businesses are paying their fair share of tax, and I don't think anybody would quibble too much with that point. The Schedule 3 is a little less interesting, but it does amend the Income Tax Assessment Act and makes consequential amendments to the FBT Act to remove the exclusion as deductible expenses of the first $250 of expenses for prescribed courses of education. Having said that, what it does do, once again, is it creates an added incentive to small businesses to provide educational courses to their staff. And that is always a good thing. It doesn't matter whether it's in relation to a course in relation to IR or first aid or whatever it might be. Providing these sort of benefits, FBT benefits, the first $250 of expenses for prescribed courses, it is a very, very good thing to provide those opportunities for additional learning for staff and to provide that economic incentives as well. Now, Schedule 4 of the bill is something that's relatively close to my heart. I've talked in this place often enough about whilst I was a builder, I then became a barrister. And Schedule 4 provides and allows small businesses to seek orders from the AAT that stay or otherwise affect ATO debt recovery actions, whilst the small business is disputing the underlying tax assessment in the Small Business Taxation Division of the AAT. Now, this is very much a common sense provision. If a business feels aggrieved by a decision of the ATO, then that business, the business person, has every right to challenge the decision of the ATO in the AAT. And if that person doesn't get a successful outcome there, onwards from there in the federal court and etc. But what this provision does is it stays the decision of the ATO until you get an outcome through the legal process. Now, this shouldn't be seen as anything controversial. It simply, while someone is exercising their legal rights to have the decision challenged in the AAT, for that decision to be stayed. And it reminds me, Deputy Speaker, that a constituent of mine who's been vociferous in his opposition—
The debate is interrupted in accordance with Standing Order 43. The debate may be resumed at a later hour, and the member will have leave to continue speaking when the debate is resumed. Are there any statements by honourable members? The member for Mitchell.
Thank you, Deputy Speaker. And today I want to thank all my colleagues who are wearing their cornflowers in obeisance of the date in June when we weren't sitting for Global MND Day, recognising all sufferers and people who've lost their lives for MND in the past year. It's my privilege today to join Senator Carol Brown as the co-chair of the Parliamentary Friends Group, the first time we formalised this group, to support MND sufferers in Australia, advocate for better research and funding, and of course do whatever we can to fight this insidious disease. So I thank all colleagues in both the House and the Senate who joined our group, who are going to join us in that fight of advocacy, and I really particularly pay tribute to Judith Durham, who passed away this year, who was a patron of MND and a significant fundraiser over many, many years, and her contribution in the effort to get better research and a cure for MND. I do want to also thank Jason Smith, who spoke powerfully as a sufferer today on the NDIS and some of the improvements we need to make in the treatment of MND and MS and other neurological diseases inside the NDIS. And I call on the government to join us in advocating as a group, as a committee, as a parliament for improvements to the NDIS in the treatment of people with serious neurological conditions, and I know the government will do that. I also want to pay tribute to Tanya Piper, who spoke powerfully as a carer on behalf of her mother, who has MND as well. And I want to pay tribute to all of the sufferers this year, the MND associations around Australia, the state and federal organisations, the work they do every single day for the sufferers and carers. We will find a cure, and as a parliament we will assist them.
Time's expired. Call the member for Reid. Robertson.
Thank you, Madam Deputy Speaker. I wish to congratulate the Regional Youth Support Services, or RIS, on officially launching its new 131 Youth Hub in Gosford recently. This Youth Hub aims to be a safe learning space where young people aged between 12 and 25 on the coast can receive tailored training and support. This hub is focused on preparing young people to be job-ready and gives them opportunities to develop the necessary skills to seek, apply and obtain jobs. It is also a point of connection for further study or information on career options. The Youth Hub also runs several other programs helping youth that might not fit the mould in traditional education models, providing them with programs to support them during challenging periods. This Youth Hub has received a federal government grant for 2 years, and I look forward to seeing the impact this hub will have in nurturing and strengthening the youth on the Central Coast. A big thank you and a big congratulations to CEO Kim, the board, staff and supporters of this phenomenal organisation. Thank you, Deputy Speaker.
Thank you. I give the call to member for Petrie.
Thanks, Deputy Speaker. The Mango Hill, North Lakes and Griffin suburbs are the fastest-growing suburbs in the Petrie electorate, with people moving into the community from around Australia and internationally. Traditionally, these suburbs have had a lack of sporting facilities, so that's why on the 27th of August I was pleased to officially open the new swimming pool at the Lakes College, an 8-lane, 25-metre swimming pool, heated, great filtration at the Lakes College in North Lakes. As part of my 2019 election commitment, I secured $2 million for the pool through the female facilities and water safety stream. And this will be well utilised in the lead-up to the 2032 Brisbane Olympics. I want to thank Principal Nicole Gregory. I want to thank former Principal Simon Armstrong and the board who worked hard to make this pool happen. And I want to thank and give my best wishes to Mackenzie Speechley, who will run the Lakes College Swim Club. Deputy Speaker, I can't, however, thank the Palaszczuk Labor government because their ministers, Stephen Miles and Grace Grace, went out of their way to make sure that this pool was not built at the Mango Hill Secondary College. Shame on the Palaszczuk government. Thank you to the Lakes College for making this pool a reality for the suburbs of North Lakes, Mango Hill and Griffin.
Give the call to member for Boothby.
Thank you, Deputy Speaker. Today I'm delighted to report that the Banana Boogie Bakery of Belair in Boothby has taken out a baked goods bonanza. Not only were they bestowed first place for their traditional pasty and traditional donut, but also a bronze for their sausage rolls at the Royal Adelaide Show, where I believe one of the judges was South Australian Attorney-General and renowned sausage roll aficionado Kaya Ma. They have also taken out 3 gold medals so far at the 33rd official Great Aussie Pie competition for their cheeseburger sausage roll, butter chicken pie and smoked barbecue pulled pork pie. At 3 p.m. today, we will know if they have taken out the overall title at the current competition. Business is booming for the team at Banana Boogie Bakery, and they have opened a second store in North Plympton. If you happen to be in South Australia, I'd encourage you to visit, and I would also highly recommend their Biscoff vanilla slice, their buns and their Berliners, as well as the baby chinos. They are just one of hundreds of incredible small family businesses that make Boothby such a vibrant and interesting place to live and do business. So bravo to Banana Boogie Bakery of Belair, another Boothby business batting above its average. Thank you.
Thank you. I give the call to member for New England.
Well, thank you very much, Madam Deputy Speaker. I'd just like to say, look, it's so often you have these badges on, and really it's just generic, even though the cause is so noble. But for this one, Are You OK? I very much support this cause. Madam Deputy Speaker, there was a time where in this job I was under an immense amount of pressure, and I remember going back to the waiting room at my electoral office, and there were 2 guys I played football with waiting for me there, and they said, "We want to talk." My name was always Joycey, never Barnaby. They said, "Joycey, we want to talk to you, and it's not about going fishing." And I said, "We've been watching you, and you need to basically get some help because we can get in pressure in this place. If you're under the pump, if it goes for months, as you probably know, one time for me it did, but it's also for other people. You've got to give people the space to express how they are feeling, and not that this was the issue. When at its extremity, there's the issue of suicide. And people who commit suicide don't tell you they're going to commit suicide. Unfortunately, they actually get their head into a space where they're quite happy with where they're going. The difference between that tragedy for the family and everything else is you asking them, are they OK?
I give the call to member for Holt.
Thank you, Deputy Speaker. Universal education is the pillar upon which society rests. I recently visited 2 exceptional government schools in the suburb of Cranbourne in my electorate, Cranbourne Secondary College and Courtney Gardens Primary School. During both visits, I was fortunate to satisfy the curiosity of its students in learning about my new role. Their enthusiasm to know more about our lawmaking processes and the government's plan to deliver a better future for them and their families was incredible. As long as we have pupils passionate about understanding how policy-making affects all of us, our country's future is in good hands. Among my favourite parts of these visits was speaking to English as a second language students at Cranbourne Secondary College. As a former ESL student, I know the difficulty of learning a new language in a new country, but their fluency in English made it seem like a breeze. I commend the teachers and student leaders of Cranbourne Secondary College and Courtney Gardens Primary School for encouraging such a positive atmosphere. I thank the principals, David Cowhey and Mark Delay, for inviting me. Thank you.
Thank you. Member for Mayo.
Thank you, Deputy Speaker. I wish to advise the House of the passing of a distinguished Australian academic and acclaimed writer from my electorate of Mayo. Professor Brian Ernest Matthews was born in St Kilda in 1936 and passed away in June this year. His first academic posting was in 1967 at the Bedford Park Teachers College in Adelaide before joining the English department at Flinders University. Professor Matthews held several prestigious academic positions. He was a Fulbright Scholar in residence at the University of Oregon and in 1990 became the chair of the Literature Board of the Australia Council. In 1993 he was appointed as head of the Menzies Centre for Australian Studies at the University of London. In 1996 he became a Foundation Director of the Australian Europe Institute at Victoria University, a position he held until 2003 and accepted visiting professorial roles at the Universities of Venice, Trento and Lecce. Publications included his treatise on Henry Lawson and biographies of Manning Clark and Richie Bernard. Other notable works included MCG, The Temple Down the Road. Professor Matthews' contribution to our national literary history is immense, and I'm sure he will be studied and enjoyed and discussed by many generations to come. Vale, Professor Matthews.
Thank you. Give the call to member for Bacon.
Thank you, Madam Deputy Speaker. Yesterday I met with representatives of MICA Australia, who I know also spoke with other members of this place. They drew my attention to the global hunger crisis facing people around the world, with the top 5 at-risk countries being Ethiopia, Somalia, Yemen, South Sudan and Afghanistan. A combination of conflict, COVID-19 and climate change has created a humanitarian emergency, with an estimated 10,000 children dying of hunger every day. Countless more will inevitably be left with lifelong health problems and disabilities. These are children who, through no fault of their own, are fighting for their lives, as are other members of their families. MICA reports that 50 million people in 45 countries are on the verge of famine. A global response is urgently needed, and Australia must be a part of that response. MICA is calling on Australia to provide $150 million to the global hunger crisis. The Australian people have always shown a willingness to give generously at times of crisis. And so, even acknowledging our own budgetary pressures, there is no greater priority than saving lives, and I urge the government to consider the MICA request and how else Australia may be able to provide assistance in the global response to the hunger crisis.
Thank you. Member for Melbourne.
Seek leave to table this petition from the Refugee Action Collective in Victoria. Over the last decade, Australia's refugee policies have resulted in the deliberate, cruel and criminal treatment of people seeking refuge in Australia. Boat turnbacks, the policy of both major parties, violate international law and risk sending people back to death, torture and persecution. People seeking refuge in Australia have a right to live with dignity, security and safety in our community. We, the people, signed on this petition, and the Greens once again demand an immediate end to offshore detention and boat turnbacks, for all temporary visa types to be converted to permanent visas, to allow for all refugees who have been rejected to have access to appeals, to allow the Medivac refugees to stay in Australia permanently, deliver an additional 20,000 Afghan refugee places, and lift the ban on accepting refugees coming from Indonesia and allow refugees stranded in PNG to come to Australia. We have a terrible legacy in this country on this issue. We treated a large number of people incredibly poorly. Labor, in opposition, said they would treat people more humanely, but in government the problem is that Labor has continued many of the reprehensible policies of the Liberal National Party. These policies are brutal, they are unfair, they are cruel and ultimately must end. They are a huge stain on our collective hands. I urge Labor to finally end this barbaric and abusive treatment of vulnerable people who need a safe place to live and to create a better life for themselves and their families.
Can I ask the member for Melbourne if the petition has been approved by the Petitions Committee?
It hasn't, but I understand that there was conversations with both government and opposition about seeking leave to table.
Well, then you're seeking leave. I'm going to ask if leave has been granted for the document to be presented.
Leave is not granted.
Leave is not granted. I give the call to the member for Chisholm.
Thank you very much, Deputy Speaker. Today I have the great pleasure to highlight excellence in my wonderful Chisholm community. Two of our fantastic local football clubs celebrated grand finals wins across the weekend. I want to extend a warm congratulations to the Surrey Park Panthers under-14s and under-13 Blacks and the Waverley Blues seniors and reserves teams, who all took home the premiership for their respective divisions. I've had the great pleasure of visiting both clubs across the last few months, so I can say with certainty and pride that they are incredible local sporting groups who enrich our community. They've endured the brunt of the pandemic and come back stronger, all with the support of their dedicated volunteers. Congratulations once again to the Surrey Park Panthers and the Waverley Blues. Go Panthers, go Blues.
Thank you. I give the call to the member for Capricornium.
Thank you, Deputy Speaker. The Queensland health system is broken. Individuals are falling through the cracks and need assistance to turn their lives around after waiting unacceptable times for medical procedures and for beds in aged care. 2 aged care facilities in Rockhampton have invited me to meetings in the past 2 weeks to discuss the crisis they are facing due to the lack of doctors and nurses servicing them. Benevolent Living, a newly refurbished state-of-the-art aged care facility, has 22 beds available right now that cannot be filled due to the inability to clinically manage more residents. These facilities have been relying on fly-in, fly-out GPs to treat their elderly residents and do not have enough nursing staff to care for the needs of the existing residents. Aged care residents are being sent to the Rockhampton-based hospital, where they wait for an unacceptable length of time. They are then sent back to Benevolent or other nursing homes, where they then are reassessed and then sent back to the hospital. One solution to this issue is to connect clinics run by nurse practitioners to hospitals to relieve some of the minor cases. This situation is unacceptable and is placing enormous stress on the families having to care for elderly members while they await a bed in a facility. The pressure on staff working within the aged care sector is enormous. I will be holding an aged care forum in Rockhampton to hopefully find a solution to this crisis. Thank you.
Thank you. I give the call to the member for Corangamite.
Thank you, Deputy Speaker. Pensioners across my electorate of Corangamite are celebrating the Prime Minister's announcement that age and veterans pensioners will be able to earn an extra $4,000 over this financial year without losing any of their pension. Many pensioners had been calling for this change for some time, and it makes good sense. It will certainly benefit a large percentage of pensioners who live in my electorate and have retired to the Bellarine or Surf Coast. Although they've retired, lots of pensioners want to continue to contribute to the workforce and their community, but the impact on their pension has been prohibited. It's prohibited this, but no longer. The Albanese government will now provide a one-off income credit designed to give older Australians the option to work and keep more of their money. Following the successful Jobs and Skills Summit, an immediate $4,000 income credit will be added to the income banks of aged pensioners from December to be used this financial year. This means pensioners can increase their earnings from $7,800 to $11,800 this year before their pension is reduced. It's a win-win, not just for pensioners but for our labour market. Pensioners can work more, earn more, use their skills and stay connected while we boost the supply of labour to help address worker shortages. This is a great reform which pensioners in my electorate will embrace, thanks to the Albanese government.
Thanks. I give the call to member for Menzies.
Thank you, Deputy Speaker. One of the wonderful privileges of this place is seeing children up there wave to us and visit this building. So when I visited some of the 44 schools in my electorate, I was saddened to hear that those visits may not happen again, or at least not with certainty. Currently, there is an enterprise bargaining agreement in Victoria that requires schools to fund 100% of time on duty and 50% of time on call for their staff. And no one denies that teachers deserve fair compensation, but this award potentially disproportionately affects students because the principals don't have that extra finance or funding in order to deal with camps. Overstretched budgets are forcing schools to think twice about camps, and that includes to this building, but also camps throughout Victoria. Indeed, there is even talk of charging parents separately for this privilege, and that does create a disparity between private and public schools in Victoria, and no one would want that you must go to a private school to come to this place for a visit. All students, no matter whether it's public or private, should be given the chance to come to this place. So I urge the Victorian Labor government to, as soon as possible, to look at the consequences of this agreement and to provide funding and certainty for schools so that all students in Victoria get to go to camps.
Thank you. Member for Reid.
Thank you, Deputy Speaker. A few weekends ago, I went down to the racetrack at Sydney Olympic Park to watch members of Race Running Australia train. Race running, or frame running, is a game changer for people with a disability. The specially designed three-wheeled frame supports participants to run on their feet independently. Developed in Denmark, the running frames were designed for people with cerebral palsy to help them run and keep active. It took a determined father to bring the frames to Australia. Richard Keith discovered frame running in 2018 at a triathlon competition for children with cerebral palsy. His 8-year-old son, Aaron, was participating in the competition and was relying on a cumbersome walking frame for the run leg. It's here that Richard discovered running frames. Richard talks about the first moment he saw his son using the running frames, seeing his freedom of movement, speed and the joy he showed in being able to run for the first time. It was a moment that brought him to tears. Frame running has taken hold here, and there are now 9 running groups across Australia, giving people with a disability exercise, self-confidence and access to a wonderful community. The story of frame running demonstrates how adjustments and technology can ensure all people have access to sports and exercise.
Thanks. I'll give the call to the member for Farrer.
Thanks, Deputy Speaker. I want to take my hat off to the organisers of the Henty Machinery Field Days. For 2 years, Southern Australia's biggest agricultural event was COVID cancelled. But I'm delighted to tell the House in 2022 it's back. Henty is a small southern New South Wales town with a population just over 1,000. Later this month, that number swells to 50,000. Checking out the latest farm machinery and equipment, produce, agronomy, lifestyle and agribusiness products. Once again, organisers have more than 1,200 sites booked and 800 exhibitors spread across the 100-hectare site. Of course, COVID hit local economies in every corner of the country, but equally so in country towns where some literally only have one big draw card event. So we've had 2 years where local motels and restaurants were not booked out. The PNC missed fundraisers for their school, pubs had beer, but no one to drink it. But Henty's people, like farmers, are resilient. Despite drought, fires and flood, the latest ABARES forecast has agricultural exports climbing to a record $70 billion in the next year, led by wheat, beef and cotton. Like the arrival of every new spring, there is sunshine on the horizon. So if you need some replacement Tupperware, want to check out natural fibre fashions, grab a few cake decorating tips or buy a new pair of boots, Henty is your spot in 10 days' time.
Member for Dunkley.
Thank you, Deputy Speaker. This week I received an email from Sandy Koala, who is a student at Carranbound Secondary College in my electorate. She's in Year 7. Sandy sent a very long email about climate change, and I can't read all of it out. But part of what she said is that for years people have been saying if we want to save our planet, we must stop producing greenhouse gases, yet here we are today emitting billions and billions of metric tonnes of greenhouse gases. How many scientists will it take to prove that our planet is warming? It is not that someone must take a stand. Everyone must work for change. What will happen when it is too late? People may turn a blind eye towards this, saying we have plenty of time, but if we do not start changing things now, then our planet's future is in grave danger. She went on to say that she will not stand here watching the world burn, and she's hoping that I will not either. It is real. It is happening now. We must save our planet. Our planet is a gift. We must take care of it. I may just be a 12-year-old, yet for me, age does not matter. You're not just a 12-year-old. You are the person that we are fighting for in this government to bring in laws to reduce emissions, to make Australia a renewable energy superpower so that your future can have a climate almost as good as the one we grew up in, and we can save the planet for generations to come.
Member for Marinara.
Thank you, Madam Deputy Speaker. I'd like to take this opportunity to commemorate the life of Mr Jed William Dennehy from the town of Nanango in my electorate of Maranoa. Nanango is a small town in my electorate of over 3,000 people, a place where just about everyone knows everyone. Jed Dennehy was known as being a kind-hearted man who was always giving to others. He would try to spend 6 months of the year overseas volunteering, and when he was home, he volunteered locally, serving in the South Burnett branch of the Rural Fire Service. Tragically, this year, Jed was providing medical assistance to Ukrainian forces while on the front line in eastern Ukraine. Jed was a medic, and he was saving lives in the town of Izum on the Donets River, which has been under Russian military occupation since the 3rd of May. Earlier this week, DFAT advised that Jed had lost his life while driving a medical vehicle on the 24th of August. Jed gave his life, providing care to his fellow man, and this serves as an inspiration to us all. I'd like to acknowledge the comments made by the Ukrainian ambassador to Australia, who I spoke to yesterday. He's called Mr Dennehy a hero for his service to the people of Ukraine. Finally, I wish to express my sympathies to Jed's loved ones. Mr Dennehy's family have said Jed lived his life trying to help other people. In his short time on this earth, Jed did more things than most of us will ever do in a lifetime. He dog-sledded the Arctic Circle under the Northern Lights, he journeyed through Europe and saw North America. Jed had friends across the globe and will be sorely missed.
Thank you. Member for Moreton.
Deputy Speaker, 125 years ago, in 1897, a group of women, including Lady Lamington, the Queensland Governor's wife, got together in Brisbane and decided to transcribe books into Braille for children who were blind or had low vision. From that historic meeting, the Queensland Braille Writing Association was born, now grown into Braille House. It's situated on Ipswich Road, Anley, in my electorate, where the staff and volunteers continue to transcribe books into Braille and tutor people who are blind or have low vision. They provide all types of Braille: moon, large print, maps and more. Deputy Speaker, work is done via the love and commitment of the wonderful Braille House volunteers. I was fortunate to attend a special volunteer 125th anniversary event at Braille House last week with their patron, Her Excellency the Honourable Dr Jeanette Young, ACPSM. Today's Governor of Queensland, her husband Graham, gave his apologies. The event acknowledged the work of volunteers like Wendy, a former special ed teacher who, on retirement, signed up to volunteer teaching Moon at Braille House. Wendy chose to volunteer because she wanted to use the skills she had in another setting for the good of everyone. Also, I want to make a special mention that this Friday, Braille House will host over 50 children from all over Queensland competing in the Braille Literacy Challenge. So I'd like to wish those competitors the best of luck and thank the volunteers and staff at Braille House for their incredible dedication to Queensland and beyond.
Thank you. Member for Riverina.
Thank you, Deputy Speaker. I've played cricket for as long as I can recall, and usually I open the batting, Deputy Speaker, and Wayne Carter of Wagga Wagga is one of those very few bowlers who I've hit for 4 first ball of the innings. Now, Wayne is a builder in Wagga Wagga, and he's been now hit for 6 by and it is the New South Wales government, I must say, their new 7-star energy rating from October 2023. Now, that's going to add $30,000 to the cost of building a new home. Now, as Wayne says, it's been on the table for a while, and we've all been shuddering for it to be adopted. It means it's going to cost so much more to build a house, and that's a cost which the local people who want to own homes can ill afford. Now, when in government, the coalition realised electricity price drops of 5% in 2021 on electricity. 1 in 4 homes with rooftop solar, highest in the world. Thanks to the member for Deakin and his and our policies, 135,000 new home projects backed by Home Builder. We were the parties of making sure that people got their first home. But when you add, of course, the rising mortgage interest rates, the lack of action on cost of living by those opposite, and, of course, the 7-star energy ratings, it's another hit to people who want to get into their first homes. It's difficult. What's the government doing about it? We want action and we need it now.
Order. I give a call to the member for Lawler.
Thank you. Thank you, Mr Speaker. And, Mr Speaker, I want to rise today to remind the House that it's Are You OK Day today and say to all of my colleagues, are you OK? And if you're not, you can find me in the Chief Whip's office. On a serious note, it is Are You OK Day today, and I know what that means in our communities. on the ground in our schools in particular. I know most of the schools in my electorate will pause today to remind one another that when you aren't okay, the people you need to ask you about it are your mates. The people who need to ask you are your family, and that it is okay to ask, are you okay? To find ways to engage your friends, your children, your brothers and sisters, whoever it is. And can I say that as a former teacher and a mother of 3 sons, I often found that one of the best ways to engage boys was doing something with them. Paint a bathroom, get some physical activity happening, avoid eye contact and say, how's it going, mate? Are you okay? Find something physical to do. Getting them driving the car is a good place. Driving lesson, mum beside, suddenly they can have that conversation that's been keeping them up at night for weeks. So to everyone in this House, please find someone today to ask if they're okay.
Order. In accordance with Standing Order 43, the member's time for statements has concluded. And I call the Prime Minister.
Thanks, Mr Speaker. I inform the House that the member for Sydney is on leave today and questions relating to the environment and water portfolio will be answered by the member for McMahon.
Order. I invite members to take their seats as quickly and as quietly as possible. I have to report that the order of the day relating to the Prime Minister's motion of condolence in connection with the death of the Honourable Robert James Bob Brown has been debated in the Federation Chamber and is returned to the House. I present a certified copy of the motion. I understand it is the wish of the House to consider the matter immediately. The question is that the motion moved by the Honourable the Prime Minister be agreed to. I invite all present to signify their agreement by rising in their places. I thank the House. Questions without notice. I give the call to the honourable member for Berowra.
Thank you, Mr Speaker. My question is to the Prime Minister and concerns his ministerial code. Following the breach of the ministerial code by the Minister for Regional Development, Local Government and Territories, I refer to media reports that the Assistant Minister for Health has invested in managed funds or unit trusts which in turn have significant shareholdings in Australian healthcare businesses or private health insurance businesses. Does the Minister have an obligation under clause 3.12 of your ministerial code to notify you of this conflict of interest?
Give the call to the Prime Minister.
I thank the member for his question. I refer to the ministerial code, section 3.11 on shareholdings, and it says this. In recognition of the collective responsibility that ministers bear in relation to cabinet decisions, this code requires that ministers divest themselves of investments and other interests in any public or private company or business other than public superannuation funds or publicly listed managed funds or trust arrangements where, Part 1, the investments are broadly diversified and the minister has no influence over investment decisions of the fund or trust. The Assistant Minister has completely complied with that. And 2, the fund or trust does not invest to any significant extent in a business sector that could rise to a conflict of interest with the Minister's public duty. And the Assistant Minister has complied with that. The Assistant Minister has advised, she has ensured that she has been compliant with this. The Assistant Minister also wrote to me this morning to formally advise that she's taken the additional step of divesting all of her interests.
Give the call to order. Give the call to member for Holt.
Thank you, Mr Speaker. My question is to the Treasurer. How will the October budget help Australians deal with the cost of living pressures and respond to the challenges facing our economy?
Give the call to the Treasurer.
Yeah, thanks very much, Mr Speaker, and can I thank the member for Holt for her question. Can I congratulate her on her first speech in this place earlier in the week. Also an important week in the economy, Mr Speaker. We had the interest rates decision on Tuesday, the national accounts on Wednesday, and today a speech by the Governor of the Reserve Bank. And what those 3 events all did is that they laid bare the challenges that we confront in our economy right now. The skyrocketing costs of living, falling real wages, labour and skills shortages, issues around business investment and productivity, some of these issues which have been around for some time now. And these were the key focuses of the Jobs and Skills Summit last week, and they will be the key focus as well of the budget that we hand down next month here in this place. This is the complex combination of challenges that we confront as we put this budget together. And budgets are always about competing priorities, and the job, as always, the job for us this time around is to comb through the complexity and to make sure that we are satisfying our key economic objectives, and ours are very, very clear. First of all, in the budget, to trim the waste and rorts, which has been a defining feature of the budget for too long. Secondly, to use that money to invest instead in the productive capacity of the economy to deal with the issues in our supply chains and to make sure that we can lift the speed limit on the economy so it can grow without adding to these inflationary pressures. And thirdly, by responsibly dealing where we can with the cost of living pressures that Australians confront right now, whether it be in childcare, whether it be medicine costs or TAFE fees or in other important areas, as well as getting wages moving again in our economy after almost a decade now of wage stagnation and deliberate wage suppression from those opposite. And the important balance to strike, Mr Speaker, when we provide this responsible cost of living relief in the budget next month is to make sure that we're providing that relief without adding to inflationary pressures. So we're providing that relief in a way that also satisfies our broader economic objectives. In childcare, cost of living relief, but with an economic dividend. Medicines, similarly. TAFE fees, similarly. The list goes on, and getting wages moving in a strong and sustainable way once again as well. We want to make sure that we don't add to the pressure on the Reserve Bank when it comes to interest rate decisions. We want to take some of the sting out of inflation over the medium term. The best way to do that is to provide that relief in a responsible way and invest in the issues in our supply chains as well. Mr Speaker, a decade now, a wasted decade of missed opportunities and warped priorities and deliberate wage stagnation have left Australians and their budget and their economy more vulnerable. The budget will make them more resilient.
Treasurer's time has concluded. Give the call to the Leader of the Opposition.
Thank you very much, Mr Speaker. My question is to the Prime Minister, and it refers to the Ministerial Code. I refer to the Prime Minister's comments on 8 July this year when he said, and I quote, "Well, what we need is transparency. I want politics to be cleaned up. And that's why we will have strict adherence to the Ministerial Code of Conduct," end quote. Prime Minister, we're now in a situation where ministers are liquidating their interests at a rate of knots. And given that 3 ministers have disclosed shareholdings when your code prohibits this, who assesses this strict adherence, and why have you so dismally failed to enforce it?
Give the call to the Prime Minister.
Tell us about your blind trust. What an unfair...
The Attorney-General.
I thank the Leader of the Opposition for his question. The fact is that my entire ministerial team have been entirely transparent, which is why you're able to ask the questions and go down the rabbit holes that you've tried to do. But unfortunately for the Leader of the Opposition's objectives, they're cul-de-sacs. They're cul-de-sacs because the code has been dealt with. My ministers are fully aware of it. And let me just say this, that if the Leader of the Opposition applied a similar code to those opposite, then 1, 2, 3, 4 would all have not been able to sit.
Order.
Would not have been able to sit in the ministry for 9 long years. And I tell you what, if you want to talk about integrity, you're going to have a big chance. Your big chance is next week, when there's a National Anti-Corruption Commission bill presented to this parliament. That's your big chance. That's your big chance to put up your hand and say, we have heard the message, we will support a National Anti-Corruption Commission because we will be putting forward the legislation next week. You said, of course, that you'd deliver a National Anti-Corruption Commission in the last term of parliament. In the last term. It was a commitment you made prior to the 2019 election, and we waited at the end of 2018 for the bill to be tabled. Then we waited in 2019, and then 2020, and then 2021, and then 2022, and it didn't happen. Well, guess what? Next week the bill will be tabled. We'll see whether the opposition are prepared to support it.
Order. The member for Longman. Give the call to the member for Boothby.
Thank you, Mr Speaker. My question is to the Minister for Health and Aged Care. How will the Albanese Labor government's plan to make medicines cheaper improve the lives of millions of Australians?
Give the call to the Minister for Health and Aged Care.
Well, thank you, Mr Speaker, and I thank my electoral neighbour, the member for Boothby, for her question, because the PBS is one of Labor's proudest legacies, along with Medicare, one of the twin pillars of Australia's universal health care. Hard fought at the time, fought and contested tooth and nail by the Liberal Party, but now a deeply entrenched part of Australia's social fabric. And in just the first 100 days of this government, Mr Speaker, we have already approved 23 new or amended listings on the PBS. Last week, Zejula was listed for the first time for the treatment of ovarian cancer. Now, we all know too well in this place, Mr Speaker, that ovarian cancer survival rates tragically remain stubbornly low at only about 50% over 5 years. And this listing will provide new hope to about 300 patients every year. Each course of treatment of Zejula costs a whopping $130,000. But the good news is that this PBS listing will bring that price down to just $42.50. And the even better news, Mr Speaker, is that from January next year, that cost will come down even further to just $30. A course of Zejula involves 20 prescriptions, Mr Speaker, so that saving will amount to $250 for each of those 300 Australian women. Those 300 women dealing with the enormous challenge of ovarian cancer will be among the 3.6 million Australians, Mr Speaker, who benefit from the biggest cut to the price of medicines in this country's history. At a time of huge pressure on household budgets, this will be a huge relief. Single mum Carrie yesterday sent me a picture of the 2 medications that she's supposed to take every single day, and she wrote, "Here are 2 things I take that are over $42, and because of the cost, I don't take them every day as I should. Are they actually reducing to that much? That would be amazing." Almost 1 million other Australians defer taking medicines prescribed by their doctor because of cost, just like Carrie. And under our plan, that will change. For households with multiple scripts, the savings are going to run to hundreds and hundreds of dollars every year. Jeannie wrote to me. She said, "Thanks, Albo." That's how this government runs. We get written to, and people thank the Prime Minister, as is completely appropriate. She said, "My family spends a few $100s a month on
Members
scripts,
on my left.
and this will definitely make a huge difference." And Andrea wrote, "Brilliant news, brilliant news. Hubby has 4 scripts a month for his heart condition, and this will help our budget enormously." Mr Speaker, our plan for cheaper medicines provides millions of Australians with vital cost of living relief and helps ensure that they're not going to go without medicines they need for their good health.
Give the call to the Leader of the Australian Greens.
Thank you, Speaker. My question is to the Prime Minister. The federal government is now being asked to approve one of the 114 new coal and gas projects in the pipeline, the massive Mount Pleasant coal mine expansion in New South Wales. Will the government block this new coal project, including by putting a climate trigger in our environment laws, or will Labor keep opening new coal and gas projects because, as your Resources Minister outrageously said, it's just, quote, "the bubbles in your soda stream. We've got to keep it in balance how we think about carbon dioxide"?
Give the call to the Minister for Climate Change and Energy.
Thanks, Mr Speaker. As the honourable member knows, this project has gone through its approval processes at the state level. It will now begin the federal level processes before the Minister for the Environment. The Minister for the Environment will take the same assiduous, careful, methodical and proper approach as she's taken to all environmental approvals she's dealt with so far.
Give the call. I give the call to the member for McEwen.
Mr. Speaker, my question is to the Attorney-General. Why has the government had to establish an inquiry into secret appointments by the previous government?
I give the call to the Attorney-General.
Thank you very much, Mr. Speaker. I thank the member for McEwen for his question. The decision by the member for Cook to appoint himself to administer 5 additional portfolios without telling the Australian people, and in the case of 4 of the portfolios without even telling the relevant minister, fundamentally undermined the principles of responsible government that are reflected in the Australian Constitution. And even worse, this is what the Solicitor-General concluded about this behaviour, and I quote, "An unpublicised appointment to administer a department fundamentally undermines not just the proper functioning of responsible government, but also the relationship between the ministry and the public service." End quote. Few are in any doubt that the former Prime Minister—
Order. I'll just ask the Attorney-General to resume his seat. Order. The Minister for Climate Change. I give the call to the Manager of Opposition Business.
Thank you, Mr. Speaker. The government has established an inquiry. Into this matter. The former High Court Judge Virginia Bell has been asked to look at this matter, and consistent with the Sub Judice Convention, it is not appropriate for this matter to be being canvassed in the House.
To resume his seat. Order. On my right. Order. The House will come to order so I can hear the Leader of the House. I call the Leader of the House.
Thanks, Mr. Speaker. The House of Representatives practice goes in great detail about the Sub Judice Convention, makes clear that it goes nowhere near an inquiry of this nature. And the question was in order as you ruled, and it's very clear that there's not even an objection being made that in any way the minister was being anything other than relevant to the question he was asked.
I call the Attorney-General. I'm listening closely to his answer and will be taking the views of the manager into my decision going
Thank
forward.
you, Mr. Speaker. I'll repeat, few are in any doubt that the former Prime Minister's conduct was indefensible. The Shadow Minister for Home Affairs has even called on him to leave the parliament. But there are still many questions that remain unanswered, and that is why the inquiry that the Prime Minister announced with me on the 26th of August is necessary. What precisely were the facts and circumstances surrounding these secret appointments? The only account we've had is a self-pitying, self-serving and self-justifying account by the member for Cook, who appears to remain pathologically incapable of accepting responsibility for his own behaviour, let alone showing genuine contrition. What precisely were the implications arising from these appointments on, for example, the functioning of relevant departments and statutory bodies, or on the accountability of the executive to the parliament? And what steps can the current government take to make sure that this never happens again? The distinguished jurist and former High Court Justice, the Honourable Virginia Bell AC, is very well placed to answer these and other questions, which is why she's been appointed to this inquiry. She will be supported by my department in undertaking the important work that she is going to do. This sorry saga does speak poorly to the culture of cover-up and secrecy inside the former coalition government. Most Australians were well aware of the former coalition government's addiction to cover-up and secrecy, but what this particular scandal tells us, is that the culture of cover-up and secrecy inside the former government was so insidious and so corrosive that senior ministers, including the Prime Minister, couldn't even keep each other informed about the significant—
I give the call. The manager has taken a point on relevance. I give the call to the manager, and I'd ask him to state the point of order.
Well, again, it's a Sub Judice Convention, Mr. Speaker.
There's no point of order. Resume your seat. There's no point of order. The Leader of the House.
If I may.
Sub Judice. Do you want a judicial inquiry?
To the point of order, I appreciate the Manager of Opposition Business tried to show authority by arriving with a copy of the standing orders. The Sub Judice Convention is not referred to in the standing orders. It's referred to in practice. He's going through there now, directing to pages 521 and 522. The Sub Judice Convention in particular applies, the House has previously found, when you're dealing with something in the order of a jury trial, where there is a sense that what is said in Parliament could have an implication on the justice that is then shown. To think in any way that debate in this Parliament over the behaviour of the former government would have an impact on former High Court judge in that way is something that the convention goes nowhere near. Practice is clear on that, and is an extraordinary claim to be made.
I thank the manager. I thank the Leader of the House. The Attorney-General with 16 seconds to go.
Thank you very much, Mr Speaker. I'd repeat, the culture of cover-up and secrecy inside the former government was so insidious that senior ministers could not even keep each other informed about significant matters, even if they were concealing matters that went to the proper functioning of responsible government.
Order.
Those opposite should hang their heads in shame.
Order. Order. Members on my right, give the call to the Manager of Opposition Business.
My question is to the Attorney-General, and it relates to the Ministerial Code. I refer to the fact that he has disclosed an investment in an actively managed Australian equities fund, the Pengana Emerging Companies Fund, which reports amongst its holdings businesses affected by the government's regulatory settings, such as Telco Unity Wireless Limited, healthcare company Helios Limited and health insurer NIB. Is the Attorney-General satisfied that this investment does not create a perception of a conflict of interest?
Give the call to order. The manager was heard in silence. I'm calling the Attorney-General.
I thank the honourable member for his question. I have fully complied with the Ministerial Code of Conduct. The Prime Minister earlier, in answer to similarly groundless questions from the opposition on this matter, read out the passage from the Ministerial Code of Conduct. You've asked the question, you should listen to the answer.
Order.
You don't like it.
Order. The Attorney-General returned to the question.
Thank you, Mr Speaker.
Order. Members on my left.
As the Prime Minister explained in reading out the relevant passage from the Ministerial Code of Conduct, it is absolutely in order for ministers to own shares in publicly listed managed investment trusts. I'd hope that some of those opposite would know what they are, where the minister concerned has no control over the investments made by that managed investment trust. That is my position. And what's extraordinary is that the level of transparency that we have provided as a cabinet and as a ministry and as members of this parliament in the register of interests that these people opposite have been going through and raking through, that level of transparency was never provided by those opposite while they were in government, and indeed those opposite, when they were in government, permitted shareholdings in private companies, permitted shareholdings in public companies because they didn't care about any conflicts of interest. They didn't care about the appearance of conflicts of interest, and they didn't care about the actual conflict of interest. We do. We are a government of integrity, and those opposite would do well to have a look at how this should be done, because you didn't know in office how this should be done.
Order. Order. I give the call to the member for Reid.
My question is to the Minister for Climate Change and Energy. Why is it so important to be upfront with the Australian people about the reliability and affordability of energy supplies? What are the consequences of not disclosing critical details, and how is the Albanese Labor government restoring leadership in the area?
I give the call to the Minister for Climate Change and Energy.
Well, thanks very much, Mr Speaker. I thank the honourable member for Reid for her question, and I'm very pleased to inform her and the House that about 6 minutes ago the government's climate change bill passed the Senate, 37 votes for 30. That's what restoring leadership's all about. It is well on its way to becoming the law of the land, Mr Speaker. And in relation to the leadership we have to show and the damage we have to repair, the House knows the impacts of 10 years of delay and denial and dysfunction. And what we've seen is 10 years of underinvestment in renewable energy and in electricity generation. That's what the Act is all about, sending the message to investors that Australia is open for business. because the House will recall the 4 unfun facts of the previous government's record. The fact that 4 gigawatts of energy generation left the system and only 1 gigawatt came on. The fact that the previous minister promised almost $1 billion of investment and didn't deliver 1 watt, not 1 watt of energy. The fact that their signature policy, Snowy 2.0, is running 18 months late. And the fact that the minister intervened, the then minister, the now Shadow Treasurer, intervened to change the law so that an electricity price rise would be hidden from the Australian people. Now, as unacceptable, as morally unacceptable as that is, I understand why he did it. The implications were very significant. What the previous minister hid from the Australian people was, for example, for New South Wales, an average rise of $227 for a New South Wales household, or up to $1,130 for a small business. That's what the now Shadow Treasurer hid from the Australian people. Now, that's bad enough, Mr Speaker, but I saw the other day the Shadow Treasurer interviewed on Sky News, and he was asked about this. And he was asked about why he intervened to change the law to hide the electricity rise. And he said, no, this is a report from the AER, not from the government. Let's be very clear about that. This is a report from the AER. Let's be very clear. It wasn't me, he says. The trouble is, Mr Speaker, when you change the law, there's a record. They keep records of these things. And at the front it says, Angus Taylor, Minister for Industry, Energy and Emissions Reduction. I know there was more than one of them, but this was you. This was actually you. And on the back, on the regulation, the regulation change says about the date of the report, omit the 1st of May and substitute the first business day after 25th of May. It didn't occur to the now Shadow Treasurer that that was after the election. I tabled the regulation, Mr Speaker. This guy wants to be the Treasurer of Australia now. He's not fit to be the Treasurer of local PNC, Mr Speaker, with what he's hidden from the Australian people. I apologise to the PNC Treasurers around Australia. We're all fine people. But this is the leadership we are showing to get over 10 years of denial and dishonesty.
Order. Give the order. The House will come to order. There is far too much noise. I give the call to the Deputy Leader of the Opposition.
My question is to the Attorney-General and it relates to the Ministerial Code. I refer to the Attorney-General's disclosure—
Order. The Deputy Leader will resume her seat. Order. Members on my right. When a member is asking a question, they will be heard in silence. I'm going to ask the Deputy Leader to begin her question again, and I'm asking for silence, particularly on my right. I give the call to the Deputy Leader of the Opposition.
My question is to the Attorney-General and it relates to the Ministerial Code. I refer to the Attorney-General's disclosure that he invests in the Green Cape Broadcap Fund. Does this fund hold shares in Omni Bridgeway, a listed litigation funding business, which recently issued an ASX statement welcoming a decision from the Attorney-General? And if so, is he satisfied that this shareholding does not give rise to a perception of a conflict of interest?
Order. I give the call to the Attorney. Members on my left will cease groaning. I give the member for Moreton is on thin ice again. I give the call to the Attorney-General.
Thank you very much, Mr Speaker, and I thank the honourable member for her question. I'm going to read 3.11 of the Code of Conduct for Ministers, because it's important that its exact terms be understood. In recognition of the collective responsibility that ministers bear in relation to cabinet decisions, this code requires that ministers divest themselves of investments and other interests in any public or private company or business other than public superannuation funds or publicly listed managed funds or trust arrangements where 1. The investments are broadly diversified and the minister has no influence over investment decisions of the fund or trust, and 2. The fund or trust does not invest to any significant extent in a business sector that could give rise to a conflict of interest with the minister's public duty. Now,
the Leader of the Opposition. Order. Order. Members on my left.
I will examine the matter that has been raised.
Order. Members on my
matter that has been raised by the honourable member, and I can assure the honourable member, and I can assure members of this House, that I have complied at all times with the Code of Conduct for Ministers, and it's a very significant matter. That's why I've undertaken to look at the matter that has been
Members
raised.
on my left will cease interjecting.
That is why I will look at the matter that has been raised by the honourable member, but I can assure the House that every single one of the publicly listed managed funds that my private superannuation fund invests in have been fully disclosed to this House. They are all, as I say, publicly listed managed funds. They are all investments that are broadly diversified, and they are all funds in which I have no influence over investment decisions of that fund or trust.
Order. Members on my left will cease interjecting before we move forwards with question time. Give the call to the member for Hasluck.
Thank you, Speaker. My question is to the Deputy Prime Minister. What policy changes will the Albanese Labor government make to ensure effective procurement of our nation's ADF capability in order to defend Australia's economic and security interests? And why are these changes important?
Give the call to the Deputy Prime Minister and Minister for Defence.
Well, can I thank the member for her question and acknowledge her service to our nation's Defence Force. On the 3rd of August, the government announced the Defence Strategic Review, which is being asked to consider the complex strategic circumstances which we face, what it means that we are within the 10-year threat window which the former government rightly observed exists for our country, and what that means in terms of the kind of defence force that we need to build for the future to keep us safe. And to that end, Sir Angus Houston and Stephen Smith are casting a critical eye over the integrated investment plan, the 10-year procurement schedule for our Defence Force, because a prudent management of that schedule is fundamentally important to building a powerful Defence Force. But that task has been made so much more difficult by the legacy which has been left to us by those opposite. Now, when it came to hoopla, the Liberals were the gold standard. When it came to defence, there were press releases by the hour, bells and whistles, streamers and balloons. They literally had Top Gun music when they were doing defence announcements. They truly were the P.T. Barnum of defence procurement. But when it came to delivery, well, that was actually a completely different question. Frigates running late, offshore patrol vessels running late, a lost decade when it comes to our future submarines as they chopped and changed from one country to the next. As we came to office, we've inherited 30 major projects running over time, 17 major projects running over budget to an accumulated total of more than $4 billion. Now, the Leader of the Opposition used to love to come to this dispatch box and talk about how much money the Liberals spent on defence. Well, can I tell the House it doesn't count as defence spending if you spend the money on absolutely nothing. It doesn't count as defence spending if you flush that money down the toilet. It's not as though we can go onto the battlefield and overwhelm our adversary by running up to them and waving a copy of the budget papers in their face. This was the single most inept, incompetent, negligent government when it came to the management of Australia's defence budget. Well, Mr Speaker, let me say the age of vaudeville is over. There are not going to be any Top Gun announcements from the Albanese government. What you will get is serious, prudent management of the defence budget, because we understand that that is the way that we'll get the submarines in the water quicker, we'll get the OPVs and the frigates back on track, and in doing that we are going to build a potent and capable defence force which will keep our country safe in the future.
Order. Order. The House will come to order. I give the call to the Leader of the Opposition.
Thank you very much, Mr Speaker. I seek leave to move the following motion forthwith. That the House notes, 1, that the Prime Minister has repeatedly claimed to be bringing a higher standard of accountability, transparency and integrity to government. 2, the Prime Minister said on 8 July that, well, what we need is transparency. I want politics to be cleaned up, and that's why we will have strict adherence to the Ministerial Code of Conduct. 3, at least 3 ministers have now disclosed that they own shares when the ownership of shares is specifically barred under the Ministerial Code. 4, that the Minister for Regional Development, Local Government and Territories has admitted to the House that she was in breach of the Ministerial Code. 5, the Assistant Minister for Health holds managed funds which have significant shareholdings in healthcare and private health insurance companies. 6, the Attorney-General invests in funds which have significant holdings in businesses which he is responsible for regulating. And 7, the Prime Minister and other ministers, when asked about these matters, have repeatedly dismissed the questions and claimed that there is nothing to see here, and therefore calls upon the Prime Minister to either 1, live up to his rhetoric and take steps to actively enforce his ministerial code, including seeking financial advice from the Secretary of the Department of Prime Minister and Cabinet in relation to each of the ministers reported to hold shares or to hold managed funds, or who hold managed funds which hold shares in circumstances which give rise to a conflict of interest, or 2, admit that the Prime Minister is in fact failing to enforce his ministerial code and in turn is failing this critical test of whether his government is demonstrating the highest standards of integrity and accountability that he has claimed to uphold.
Give the call to the Leader of the House.
Leave's not granted.
Give the call to the Leader of the Opposition.
Thank you very much, Mr. Speaker. I seek leave to move. I seek leave to suspend standing. So much of the standing orders as would prevent me, Mr. Speaker, from moving the following
just
motion.
ask the Leader to move it.
And I'm seeking leave.
Yep.
Mr. Speaker,
yeah.
I have actually. I seek leave, Mr. Speaker. Leave is not granted. I understand that. Yes. Which I've just done. Mr.
If I could assist the order, the House will come to order. Are you requesting standing orders to be suspended?
Absolutely, Mr. Speaker. Yes. They can laugh and jest, Mr. Speaker. But
I just suggest to the Leader of the Opposition he needs to move that standing orders be suspended.
I move that the House notes 1, that the Prime Minister has repeatedly claimed to be bringing a higher standard, absolutely, of accountability, transparency and integrity to government. 2, Mr. Speaker,
the Leader
Prime
of the
Minister
Opposition
said on
just
8
resume
July,
his seat. The Leader of the House.
Mr. Speaker, at this point, the Leader of the Opposition is moving a resolution that the House denied him leave to move.
Yes, and he will need to move a suspension of standing orders. I give the call to the Leader of the Opposition. Yeah,
Mr. Speaker, as you said in your own words. So, Mr. Speaker, I move that so much of the sessional standing orders be suspended, as you pointed out before, Mr. Speaker, as would prevent the Leader of the Opposition from moving the following motion forthwith. Mr. Speaker, 1, that the Prime Minister has repeatedly claimed to be bringing a higher standard of accountability, transparency and integrity to government. 2, that the Prime Minister said on 8 July that, well, what we need is transparency. I want politics to be cleaned up, and that's why we will have strict adherence to the Ministerial Code of Conduct. 3, at least 3 ministers have now disclosed that their own shares, when the ownership of shares is specifically barred under the Ministerial Code. 4, that the Minister for Regional Development, Local Government and Territories has admitted to the House that she was in breach of the Ministerial Code. 5, the Assistant Minister for Health holds managed funds which have significant shareholdings in healthcare and private health insurance companies. 6, the Attorney-General invests in funds which have significant holdings in businesses which he is responsible for regulating. And 7, the Prime Minister and other ministers, when asked about these matters, have repeatedly dismissed the questions and claimed that there is nothing to see here, and therefore calls upon the Prime Minister to either 1, live up to the rhetoric and take steps to actively enforce his ministerial code, including seeking formal advice from the Secretary of the Department of Prime Minister and Cabinet in relation to each of the ministers reported to hold shares or to hold managed funds which hold shares in circumstances which give rise to a conflict of interest, or to admit that this Prime Minister is in fact failing to enforce his ministerial code and in turn is failing this critical test of whether his government is demonstrating the highest standards of integrity and accountability that he has claimed to uphold.
I call the Leader of the Opposition.
Mr Speaker, now this is a very serious issue that is before the House. Absolutely it is, Mr Speaker, because the Prime Minister has claimed to the Australian public that he is going to usher in a new era where there is greater accountability, where ministers will be held to a higher standard, and it's absolutely clear, Mr Speaker, that in the changes made by this Prime Minister in relation to the Code of Conduct for Ministers released in June of 2022 by this government, as has been detailed in the House today at 3.11, specifically 3.111 and 2 and 3.12. This 3.12, of course, Mr Speaker, wasn't referred to today, but it's worth reading it into the record. If a minister becomes aware that a fund or trust has invested in a company that might give rise to a perception of a conflict of interest, the minister should inform the Prime Minister immediately and liquidate the investment in the fund or trust if required to do so. Mr Speaker, none of that has happened. And we've got a situation where, in relation to one minister earlier this week, we had a situation, Mr Speaker, where that minister claimed to this House that some sort of self-assessment process had been undertaken by her, during which, surprisingly, she cleared herself of any wrongdoing, and then later claimed that, in fact, she had breached the Ministerial Code of Conduct, for which she knows, as we now do, there is no consequence. So how is it, Mr Speaker, that this Prime Minister is pretending to uphold some different code or some different standard when there is absolutely no consequence for a breach of the code? Could it be any clearer, Mr Speaker? We have a look at the health. We have a look, Mr Speaker, at the Assistant Minister for Health and in terms of the shareholdings. Now, could they be shareholdings in the education sector? Could they be shareholdings in a building company? No, Mr Speaker. As it turns out, the Shadow Minister has an interest in shares relating specifically to her own portfolio, Mr Speaker, of health and private health insurance funds, Mr Speaker. So, again, the consequence. I mean, could you ask, is there a consequence for such conduct? Well, under this Prime Minister, there is no consequence, Mr Speaker. So again, that minister has conducted her own assessment, and would you believe it? She's cleared herself from any wrongdoing. Cleared herself from any wrongdoing. What a robust process of a higher standard being maintained by this government, Mr Speaker. And then it is very clear, Mr Speaker, that we come to the Shadow Attorney General. To the Attorney General. The Attorney General, of course, would be one of, Mr Speaker, as we've seen over the years through his own statements. I mean, let's rely on his own words here and his own conduct. I mean, he would, Mr Speaker, without doubt, by his own admission, be the smartest person in the world. There's no question about that. Not just in this parliament, not just across the country. Listen to him. He is the most learned person in this place, in fact, across the world. So, Mr Speaker, when you go through his listings, he's been very successful. Congratulations. That's a wonderful thing to be celebrated. And he has properly disclosed, as he points out. It is inconceivable, Mr Speaker, given the Attorney-General's background, given his knowledge of the industry, given his connections particularly to companies that are involved in the litigation process, that fund litigations, his network across Melbourne, members of the bar, across the legal fraternity in New South Wales, across the country. He's been Attorney-General. He's occupied that office before. And, Mr Speaker, he's telling this House that his significant investment in a company that he knows a great deal of detail about, that somehow he's come into this chamber today for the first time to be surprised by the revelations which we have laid out. Now, the connection can't be any clearer. In fact, the shareholding that the Attorney-General has declared, I haven't got the exact figures before me, but let me put it in simple terms. The shareholding owned by the Attorney-General has effectively doubled in value since the Labor Party came to power. Now, is that directed to decisions being made by the Attorney-General? Well, I'll let people draw their own conclusions, Mr Speaker.
Members on
I'll
my
let
left.
people draw their own conclusions. But what I do know is that when the Attorney-General made a decision, and when that decision was announced, made in his capacity as Attorney-General, with a direct impact on the company involved, the company listed and they provided advice to the Australian Stock Exchange, as is their obligation. They were very happy. They were very, very happy with the decision made. And as it turns out, so too were the shareholders. So too were the shareholders. So does this result in any consequence under the Prime Minister, Mr Speaker, who is saying to the Australian public he is leading a new way, that he's coming in here for a kinder, gentler, friendlier parliament where transparency will reign? Is there any consequence for this Attorney-General when he surely, with all of the knowledge he possesses, with the superior intellect, the capacity above any other human being, I mean, has this detail escaped him up until this very moment? Is that a credible account of his position? Is it a credible account of his own interests, his own investments? I'll let people draw their own conclusions, Mr Speaker. There are many on the other side of this chamber who I know hold a very similar view to us, Mr Speaker, in relation to this Attorney-General. It doesn't pass the pub test. It doesn't pass any test whatsoever. And it's incumbent, Mr Speaker, on this Prime Minister to uphold his standards. And if he was to do that, he would demand that this Attorney-General dispose of his interests, exhaust the conflict of interest which is clear to all to see, and uphold, Mr Speaker, the high standard that he has claimed to the Australian public that he adheres to. Because, Mr Speaker, so far, not only has the Attorney-General failed this test, two other ministers that we know of have equally failed the test, and there may be more. Now, we haven't come to our favourite friend, the member for Shortland. We may do. We may do. I think the Prime Minister probably will deal with him at the next reshuffle. Maribyrnong, I'm sorry. Let's see what the Prime Minister has in store for him. You aren't his favourite, Bill. I know that much. And he may deal with you himself.
Order.
But,
the
Mr.
Leader
Speaker,
of the Opposition.
I refer to him as the Minister, the member for Maribyrnong, the soon-to-be former Minister, whatever he prefers, Mr Speaker. But the fact is that this Prime Minister has failed the test, and the Attorney-General has a serious case to answer here. He hasn't so far, and it can't escape people that he has clearly, Mr Speaker, tested at least the boundaries, but in our judgment, Mr Speaker, in clear breach of this hopeless
code. The Leader's
code.
time has expired. Order. Is the motion seconded?
Seconded.
I give the call to the honourable member for Barara.
Labor has no integrity on integrity. Ministers have breached the ministerial code left, right and centre. 3 ministers, Mr Speaker, are now selling shares at a rate which would make Gordon Gekko proud. This from a government that spent 9 years on this side of the House lecturing us on integrity. Every question time lecturing us on integrity. The new Prime Minister promised that there would be a new era of government, a new era of integrity, a new era of transparency. And what did he show us? He produced a ministerial code that in just over 100 days has been breached by 3 ministers who had to go and sell their shares. You have the Minister for Regional Development, Territories and Local Government who has admitted to breaching the code. You've had the Assistant Minister for Health and Aged Care who's invested in shares in areas that are regulated by her portfolio. And today we have revelations that the Attorney-General's superannuation fund invests in funds that invests in a prominent litigation fund, a litigation fund that has been benefited by a decision of this government, a Friday afternoon special decision of this government, made to appease and support one of the Labor Party's big donors. The Labor Party has three big donors: big unions, big super and big class action lawyers and class action funders. And they have made their first priorities in government to do things to benefit these three organisations, whether it is the nobbling of the ABCC, whether it is the changes to make superannuation funds less transparent, or whether it is now to make litigation funds less there in the issues of transparency and benefit to those people who are the victims who brought these actions in the first place. Labor has no integrity on integrity. Let's hear what the Prime Minister has been saying about the importance of his code. He said, "As Prime Ministers, I expect my ministers to demonstrate that they're complying with these high standards of conduct, and in doing so living up to the expectations of the Australian public." On the day his code was released, the Prime Minister told Sunrise, and I quote, "I want politics to be cleaned up. We've got strict adherence to the Code of Conduct." But what's the Prime Minister actually done? What have we seen? We've seen 3 ministers breach this Code of Conduct in just over 100 days. This is the transparent Labor Party. This is the new politics that the Labor Party promised that they would deliver when they came to government. That was 2 months ago, only 2 months ago, and what have you seen? You can breach the code with impunity. There is absolutely no consequence for breaching this code. And what happens when you get caught? The Prime Minister will look after you, the Labor Party will look after you. There's no real standard that any minister is being held to at all. With the Minister for Regional Development, Local Government and Territories, we found out they don't even have to read the code is there, and it can be breached with absolute impunity, again and again. And that's why the motion that the Leader of the Opposition has moved is so important. It's why it deserves to be debated properly in this House. It deserves to be debated because you cannot have the situation where a ministerial code has been put forward by a new Prime Minister who has promised new transparency in government and instead has demonstrated that there isn't any real transparency because there's no consequence for breaching his ministerial code, a code that is designed to lift transparency. Now, you have the Attorney-General here talking about the code and the fact that there were several elements to the code that were worth looking at. It's worth looking at 3.11 again, and it says, "In recognition of the collective responsibility that ministers bear in relation to cabinet decisions, this code requires that ministers divest themselves of investments and other interests in any public or private company or business other than public superannuation funds or publicly listed managed funds or trust arrangements where the investments are broadly diversified and the minister has no influence over the investment decisions of the fund or trust. And this is the important bit, the fund or trust does not invest to any significant extent in a business sector that could give rise to a conflict of interest with the minister's public duty." What did we see here? We saw a minister with a serious conflict of interest investing in a fund that benefited from a decision that had been made by this new government. Mr. Speaker, this motion deserves to be supported and we should have the full motion brought forward.
Order. The member's time has expired. The question is the motion be disagreed to. I give the call to the Leader of the House.
Okay, wake up everyone, please. You can imagine in tactics at the beginning of the week, they decided we're going to have our first big suspension motion and we're going to build up to it. Because after you lose office, the suspension motion, this is your big moment, your crescendo where you start to define what you're about. And the issue they've picked to define what their opposition is about is that ministers aren't selling down shares quickly enough.
The member for Barker.
Now, let's just consider the shadow ministry that they are offering on this issue. If this standard were applied to them, the Leader of the Opposition would be in breach. The Leader of the National Party would be in breach. The Shadow Treasurer would be in breach. The manager of opposition business would be in breach. The shadow Home Affairs Minister would be in breach. The former Deputy Prime Minister would be in breach. And I just heard from them saying, oh, but you're in government. So you've only just bought all these shares, have you? This has only just happened. This is all brand new. My favourite one of the examples, the Shadow Minister for Climate Change doesn't just have shares, he's got them in Rio Tinto and Newcrest. No conflicts there. No conflicts there at all. But the motion that we have, the whole concept of the resolution that we're meant to suspend standing orders for, and let's not forget, the whole concept of a suspension in the middle of question time is that this is so important it's worth knocking off all the other questions that were going to be asked. That's what they're asking for. That's what this resolution is for. Yeah, we never did it on anything as silly as this one. Like, what they are going for here is on the concept that, well, the big thing we need to have happen is to seek advice from the Secretary of PM&C. Well, remember the Gaetjens reports. Remember how many times we were told by those opposite the answer to every question was, Phil Gaetjens is looking into it. I remember hearing about the Gaetjens reports. I don't remember seeing the Gaetjens reports. I don't remember a single one of those reports ever seeing the light of day. Those opposite, it wasn't only on the issue of shares that they had issues of integrity. Remember when the Speaker, the respected Speaker, Tony Smith, when he was in that chair and was asked about a former Leader of the House who had set up a trust fund and the impact of that trust fund to pay for his personal expenses, his personal bills, was being used on the declaration. Now, all their questions they've asked this week are based on going through the declaration where ministers have been transparent. That's where all of this information has come from, because ministers have been transparent. Former Leader of the House, what did his declaration tell you? There was a trust fund and you weren't allowed to know where the money was coming from. So that was referred to the Privileges Committee in a reference that was made, and then the Speaker had to consider whether or not it would be given precedence to even be looked at. Now, for as long as I've been here, as long as the Prime Minister has been here, when precedence is given, the House then votes in favour of it.
Every time.
But breaking that precedent in a complete cover-up to forever conceal the financial interests of one of their own, they came in here to vote that reference down. And who do you think? Who do you think was the Leader of the House who called the division? Who do you think was the Leader of the House who said we should never have a right to know where the money's coming from? Who might be the person who stood right here and argued that the government would not be supporting the reference and the culture of secrecy wouldn't just continue, but that every single one of them would vote against the recommendation of the Speaker and make sure that the information was forever suppressed? Any ideas on who? I know you're looking at your phone.
Order.
You're looking at your phone, but it's the Leader of the Opposition. It was the Leader of the Opposition who came in here and led the charge to make sure that the Register of Members' Interest was effectively rendered meaningless by one of his own receiving money that we will never know the origin of. Never know the origin of. Now you compare that with an incoming government where the Prime Minister has come forward with a code of conduct that those opposite never would have dared do. If any Prime Minister from their side had dared bring in a code of conduct where you were expected to get rid of your shares, they would have knocked off the Prime Minister in seconds. That's what they would have done, because it goes completely against the grain of how they operate. It goes completely against the grain. Born to rule, born to invest, born to entitlement. It goes against the grain and born to rot. That's right. It goes against the grain of that for every single one of them. So what they're now doing is they're complaining and wanting to argue about a code of conduct which contained some of the principles were there when we were last in government, all of which they got rid of as soon as they came in. They made sure that none of these principles, protecting the public interest and avoiding conflicts of interest, were applied to them at all. On the occasion when one of their own was so openly flouting it that the Speaker recommended it be given precedence for the Privileges Committee, each and every one of them voted to shut the inquiry down. And now that the government has re-established proper standards of integrity, proper standards to avoid conflicts of interest, proper standards that make sure that ministers are not caught in the sort of behaviour that those opposite were involved with.
And the Deputy Leader of
what
the
do they
Opposition.
do? They decide that's their big issue. But I've loved, as we've had this week, the conversations they must have had as to who should ask about a breach of the ministerial code. Do we have the person who had to resign over Queensland trips? Do we have the person? Do we have the person ask the question relevant to the motion that we now have in front of us? Who was the person who somehow magically uploaded fraudulent documents about the Lord Mayor of Sydney? Do we have the question asked by someone who took an overseas trip to China in a private capacity and suddenly appears as a minister doing private work? Do we have people involved in water sales and water purchases? I haven't even mentioned the Leppington Triangle.
I haven't mentioned it. The Leader of the House will. The member for Barker will cease interjecting. The Minister for Home Affairs will cease interjecting. When the House comes to order, I'll call the Manager of Opposition.
Mr Speaker, on the suspension of standing orders, he needs to be relevant and argue why standing orders should not be suspended. He's not doing that.
I thank the Manager of Opposition. It is a very wide-ranging debate, and I give the call to the Leader of the House.
Thanks, Mr Speaker. I don't think that point of order was in the interest of the Manager of Opposition Ministers, I've got to say.
That was smart.
But if you ever want that to become the precedent for how we debate suspensions of standing orders, we can start to go to that rule into the future if that's where you want to go. But of all the questions, right on cue, who might be the person who purchased land worth $3 million, paid $30 million for it, but then when you had to work out, let's rent it back, decided the land was now worth even less than $3 million. And then off the back of that, from donors, I might add, those opposite come to this debate in the worst of all worlds, with zero credibility for wanting to talk about a standard that they evaded and that they rorted and that they did everything they could to avoid. I'm proud that we have a government where these questions can be asked, because the answer on every occasion is a standard that is being held here that never existed over there. And if that's going to be the sort of reason, that you reckon we should interrupt the rest of question time, make sure that the crossbench don't get other questions, you reckon an issue like this was worth it, you are far more out of touch than we had even dreamed.
Has expired. Order. The question is that the motion be disagreed to. I put the question. All of those of the opinion say aye. Against noes. I think the ayes have it. Noes have it. Division required. Division required. Ring the bells for 4 minutes. block the doors. The question is the motion be disagreed to. The ayes will pass to the right of the chair and the noes to the left. I appoint the honourable members for Werriwa and Bean as tellers for the ayes and the honourable members for Grey and Parkes as tellers for the no. Order. The result of the division is ayes 84, noes 53. The question is therefore resolved in the affirmative. And I give the call to the member for Canberra.
Thank you, Speaker. My question is to the Minister for Government Services. How will the Albanese Labor government's delivery of its election commitment to establish a Royal Commission into Robodebt bring justice to Robodebt victims?
Give the call to the Minister for the National Disability Insurance Scheme. Order. And the Minister for Government Services. Members on my left.
Thank you. Thank you, Mr Speaker. And I thank the member for Canberra for a question. As Australians are aware, Robodebt is probably one of the most shameful chapters in public administration in the nation's history. And that wasn't just the view of the current government, it's the view of the federal court and the view of hundreds of thousands of people.
The member for Barker.
Just to remind those opposite, Robodebt occurred on their watch. Between July of 2015 and November of 2019, over 400,000 of our fellow Australian citizens who rely on the safety net were targeted by an unlawful scheme. The scheme was called out to be unlawful almost from when the first debt notices started going out. But unfortunately, the current opposition, the then government, for 4.5 years ignored the pleas of those who were unlawfully targeted, ignored the decisions of the Administrative Appeals Tribunal, ignored the advice from the Australian Tax Office, ignored whistleblowers, ignored the now government, then opposition, raising and advocating, ignored the legal aid commissions around Australia. And it was a class action, only a class action which Labor helped push for, which actually forced the government to admit the scheme was unlawful, and only at the door of the court, because then the ministers and senior public servants overseeing this unlawful freight train of misery against hundreds of thousands of citizens, then those ministers may have had to give evidence in the class action.
And when faced with giving evidence, miraculously the government folded its tents, settled the claim for $1.7 billion, paid interest of $112 million. But the government then has never ever satisfactorily explained matters. So it is left to a Royal Commission to be chaired by Justice Catherine Holmes. It'll report on April the 18th next year, and it'll get to the bottom of questions which unfortunately the previous government never answered. Questions like, who was responsible for its design, development and establishment? What was the advice and the processes that informed its design and implementation? Were any concerns at any stage ever raised about the legality of the scheme? It'll also look in relation to concerns raised about Robodebt once it was initiated. Were the risks ever identified? Was there advice from the Australian Tax Office and documentary proof that the government ignored? Were there advice from affected individuals and other agencies? What did the government do, the then government do, in response to adverse decisions of the Administrative Appeals Tribunal? The old government, the current opposition, have said that this Royal Commission is unnecessary. Yet again, they're shortchanging the vulnerable. The victims of this scheme are owed the justice of the truth and finding out why did the last government treat them so illegally.
Give the call to the member for Kooyong.
Thank you, Mr Speaker. My question is to the Prime Minister regarding the last government's $18 million grant to the Australian Future Leaders Foundation, an initiative of the Department of the Prime Minister and Cabinet in consultation with the Office of the Governor-General. Will your government commit to reviewing other discretionary grants to charities and to community organisations made by the Morrison government?
Order. I give the call to the Prime Minister.
I thank the member for Kooyong for her question.
Order.
The government has indeed been going through, line by line, the commitments that were made by the former government. In some cases, they were made in budgets. In some cases, they were announced during the election campaign as part of what became a growing feature of the former government's budgets, which was the so-called contingency funds for contingencies, i.e. in case of emergency in the electorate of Kooyong break glass. That didn't really work all that well. We know, of course, for example, the abuse of the commuter car parks program, where commuter car parks, some $65 million in the electorate of Kooyong was promised. That, of course, just disappeared because in some cases they were promising commuter car parks where there weren't actually train stations for commuters to get on the train. But the government, indeed, as part of the review, has indicated, and I can confirm that a decision has been made by our expenditure review process to not proceed with the $18 million that was allocated for the Australian Future Leaders program. I must say a program that didn't, in terms of scrutiny of the details that were there, which in our view was not worthy of proceeding with, and which was also to receive $4 million in recurrent funding in perpetuity. The fact is that we have inherited $1 trillion of Liberal Party debt, and so therefore we have had to make some difficult decisions. And the Governor-General was an advocate of this program. I make no criticism of the Governor-General whatsoever, and I indeed informed the Governor-General of my government's position as a matter of courtesy to him and out of a matter of respect for him. But we will be going through, line by line, getting rid of the rorts and waste that dominated the budget, that were a part of the $1 trillion of Liberal Party debt. And we'll also, of course, know that whether it was sports rorts, whether it was commuter car park rorts, the so-called pork and ride scheme, or whether it be other programs, are addicted. They're addicted to abuse of taxpayer funds. This government intends to deliver for taxpayers, not make decisions based upon the political map.
I give the call. Order. I do not need any more yelling from the member for Barker. He is warned. I give the call to the member for Fremantle.
Thank you, Mr Speaker. My question is to the Prime Minister. Prime Minister, what can we expect will be the response of the Australian business community to the passing of the government's climate change legislation?
Give a call to the Prime Minister.
Thanks very much, Mr Speaker, and I thank the member for Fremantle, not just for the question but for his advocacy for climate change action. He has been a very strong advocate in his local electorate and around the country of the need for Australia to move forward into this century because we've been held back. We know that under the previous government we saw 4 gigs out, 1 gig in when it came to energy production.
The Prime Minister will just pause. The member for Barker on a point of order.
Simply drawing the Speaker's attention to the clock. It hasn't reset, and I ask you to draw your attention to that.
Thank the member for Barker for his assistance, and I'll ask the clock to be reset, and I'll ask the Prime Minister to continue his answer.
I thank the member for Barker for his most substantial contribution he's made since he joined this chamber. The fact is that renewable energy is the cheapest form of energy. Renewable energy is the cheapest form of energy, which is why our program, our Powering the Nation plan, will lead to a lowering of power prices. And that's what the business community understand. That's why the Business Council of Australia support it. That's why the Australian Industry Group support it, and that's why the Australian Chamber of Commerce and Industry support it as well. All of the major business groups saying to those opposite, get out of the way. We've had a decade of denial, and what we need is a government that has a program that encourages investment, because investment is the key to lowering prices for businesses. That's why they want to do it. But it's not just Australian investors. Yesterday I met with Ignacio Galan, the chairman and CEO of Iberdrola. Now, they are major global investors in renewable energy. They are one of the world's largest offshore wind developers, and they've commissioned the largest green hydrogen plant in Europe. The green hydrogen plant there in Europe, just near Madrid, that is occupying a space previously held by a coal-fired power station, previously held by that, but creating jobs for the local communities in new industries. Now, on Monday, Iberdrola announced plans to invest another $4.4 billion in renewable energy in Australia. That's what we'll see as a result of the passing of this legislation, and I thank all those in the House and the Senate who supported this legislation. And on that basis, I ask that further questions be placed on the notice paper.
Order. We'll move to papers. Order. Before I call the Leader of the House, I'll just call the Prime Minister.
I can leave it till later, because I haven't told you so. Thank you. On indulgence, Mr Speaker, I will visit Japan from the 26th to the 28th of September to attend the state funeral for Mr Abe Shinzo AC, a former Japanese Prime Minister. We've spoken previously in this parliament and across the whole spectrum, expressed our condolences to the people of Japan. I will be accompanied on that visit by former Prime Ministers, the Honourable John Howard, OMAC, the Honourable Tony Abbott, AC, and the Honourable Malcolm Turnbull, AC, all of whom worked with Mr Abe during his 2 terms as Japanese Prime Minister. We will be the official delegation, and I believe it's entirely appropriate that I, as the Prime Minister, have extended invitations to Mr Howard, Mr Abbott and Mr Turnbull, and I'm pleased that they are able to attend with me. Mr Abe's state funeral will be attended by past and present world leaders, foreign dignitaries, colleagues and family, in honour of his leadership and immense contribution on the international stage. Mr Abe was instrumental in elevating Australia's relationship with Japan to a special strategic partnership and did more than anyone to advocate for a free and open Indo-Pacific. He signed the Japan-Australia Economic Partnership Agreement, creating new opportunities for Australian businesses in Japan, and of course was a tireless champion of the Quad. I believe that the attendance at Mr Abe's state funeral by not just myself as the sitting Prime Minister of Australia, but by 3 former Prime Ministers, will send a very strong message to the Government of Japan, but most importantly to the people of Japan, about how respected Mr Abe was by Australia and about the friendship that is there. And I thank the former Prime Ministers for the discussions and for attending with me.
On indulgence, I call the Leader of the Opposition.
Thank you very much, Mr Speaker. On indulgence, I want to provide the Opposition's support to the Prime Minister on what's a very important visit to Japan. It's not only to commemorate a life well lived in the service of his country, it's a very significant expression about the depth of the friendship between our two countries. And it's always important to celebrate the links, the people-to-people links, and the former Prime Minister Abe Shinzo had a very significant personal link with former Prime Ministers, including Prime Ministers Howard and Abbott and Turnbull. And we support very much the gravitas that's attached to the delegation having invited the former Prime Ministers, and we thank the Prime Minister for extending that courtesy to the former Prime Ministers. I had the great fortune of having dinner earlier this week with the Japanese Ambassador to Australia, a great friend of our country, as many across the chamber know, and they will spend time with him from meeting to meeting and know that he's very serious about deepening the relationship even further. The tragedy that struck with the assassination of Shinzo Abe, as we mentioned in the condolence motions, shocked the world, and it's right and proper that our Prime Minister should lead the delegation to express sympathies to the family and to the nation as a whole, and it will enhance the relationships between our two countries, and on that basis we wish him and the delegation safe travels.
And I call the Leader of the House with papers.
Speaker, documents are tabled in accordance with the list circulated to honourable members earlier today. Full details of the documents will be recorded in the votes and proceedings.
Order. I've received a letter from the honourable member for Deakin proposing that a definite matter of public importance be submitted to the House for discussion, namely this government's abandonment of vulnerable communities by seeking to abolish the cashless debit card without consulting affected communities. I call upon all those honourable members who approve of the proposed discussion to rise in their places. I give the call to the honourable member for Deakin.
Well, thanks very much, Mr Speaker. Mr Speaker, someone who is respected across this chamber, indeed someone who's respected throughout Australia, Noel Pearson, said the following at a recent Senate committee hearing, referring to the disgraceful decision of the government to abolish the CDC. And I quote, this is what Noel Pearson said: "You will repeal the card and then you'll walk away and leave us to the violence, leave us to the hunger, leave us to the neglected children. It's very easy to forget about remote communities." Mr Speaker, that's not the opposition speaking. That's one of the most respected Indigenous leaders in this country eviscerating this ideological decision by the government to abolish the CDC. Mr Speaker, in this place we often argue about very fine areas of difference. And as a general rule, 90% of the time, we don't look at the motives of those opposite and think they're anything other than good. But, Mr Speaker, in this instance, we've got an example of a minister and a Prime Minister who are seeking to abolish the cashless debit card that we know with certainty will have a few consequences. The consequences we know will be more violence in remote communities, more drunkenness in remote communities, more drugs in remote communities, more neglected children in remote communities. We know that will be the outcome of this decision, and this minister and Prime Minister have completely botched this process. The only decent thing to do now, Madam Deputy Speaker, is to walk away from this shameful decision, a decision that will see, in the words of Noel Pearson, see more children neglected. The cashless debit card, Madam Deputy Speaker, operates in a number of communities: Ceduna, East Kimberley, Goldfields in WA, Bundaberg, Hervey Bay and Cape York. And, Madam Deputy Speaker, what we have seen in each and every one of those communities since the cashless debit card has been in place is reduced antisocial behaviour, reduced consumption of alcohol, reduced consumption of drugs, children and attendance at school increasing, and yet we have a minister with the gall, the absolute gall, to stand there interjecting. How on earth could anyone walk into this chamber and make a decision knowing that children will be abused and neglected as a result? That is the outcome of this decision. That is the outcome of this decision.
Call to the Minister.
I'd like to draw to reflections on other members, and I ask him to withdraw. He is to withdraw. That is a reflection. It is a reflection. It is.
Will you withdraw?
No, Madam Speaker.
It's very unparliamentary of you.
What's the unparliamentary
What
remark?
is your? Have you reflected badly on the member opposite?
No. No. I don't know what.
I will be listening extremely carefully to you, and if I ask you to withdraw next time, you will think deeply about doing so.
The decision to abolish the cashless debit card, in Noel Pearson's words, will see the government leaving affected communities with violence, will leave hunger, will leave neglected children. Now, I can understand why the minister's a bit touchy about that. We'll see neglected children. That will be the outcome of the decision made by this government to abolish the cashless debit card. So members opposite might be very touchy about this, and so they should. And in fact, I know there are a number of very good people in the Labor Party who are utterly ashamed of the decision of the Prime Minister and this minister to impose this absolute tragedy on affected communities. There are 17,000 participants at present on the cashless debit card. Madam Deputy Speaker, what has been the process by which this government now wants to rip out of those communities a tool that we know is working and a tool that is improving the lives, particularly of women and children? So if we all accept, and I think anyone with any common sense will accept, that the inevitable outcome of putting more alcohol and more drugs into these communities will be devastating for them, the least you could expect from this minister is that she would consult with those communities. Well, let's hear about the consultation. Let's hear about the consultation from this hapless minister. Madam Deputy Speaker, so the consultation involved a number of documents being sent to affected communities on the 30th of August. On the 30th of August. No, hear me out, colleagues. On the 30th of August, the so-called CDC engagement team sent to the Goldfields a raft of documents to commence the process of consultation. It was a draft engagement plan, an engagement summary, a participation checklist, a CDC fact sheet, all very bureaucratic, but that was the consultation that started on the 30th of August. They were given until midday on the 2nd of September to come back. From the 30th of August to the 2nd of September. So this hapless minister who's engaging in meaningful consultation has given these communities less than 3 days to come back on an issue that is going to see devastation hitting their communities. Now, Madam Deputy Speaker, the minister opposite might not like the quotes that are about to come up, but these are quotes from the communities that will have the CDC ripped out of them. Ian Trust from the Wunan Foundation said the following: "The CDC has reduced alcohol violence and the harassment of the elderly and vulnerable for cash when they go to an ATM. The government says if you want to go down the path of keeping income management, that it has to be a community decision. But there's no information about how they want us to arrive at that decision or what the replacement should be." Or from Tammy Williams from the Family Responsibilities Commission: "We are looking at going back to a card that doesn't match the technology of the CDC, and people will have limited access to their money, won't be able to utilise online shopping or travel outside of their communities." But it's even worse. The government is not even proposing anything viable in the place of the CDC. Hence why there are so many fears, about what is going to come. From Mayor Perry Will from the District Council of Ceduna: "We've had no consultation about it at all. The first we heard of it was in the PM's election promises that he was going to do it. Prior to that, we had no representation from any Labor politicians." Oh, she met with him after she made the announcement. That's wonderful consultation. I mean, I'll keep taking these interjections if the hapless minister wants to continue to provide them. Madam Deputy Speaker, this is a crucial matter for our parliament. And I have, in my opening remarks to this bill, when the minister introduced it, I had a very different tone. I really appealed to the decency of those opposite, decency that I know is there amongst virtually all members of this House, decency that you would not make a decision that you know is going to hurt children, and yet they proceed down this destructive course. And if you don't want to listen to me, listen to people who are in the affected communities and the impact of the CDC. From, again, Perry Williams, Ceduna: "Don't take it away. Look out the window," he was saying. "Take a walk around. See the difference for yourself. The CDC has been terrific for the town in reducing violence, increasing tourism, improving safety for women." Madam Deputy Speaker, the list of quotations is extraordinarily long. From a refuge worker in the East Kimberley, this is probably the most powerful. "Since the CDC, the seriousness of assaults seen by the refuge has declined." So, Minister,
time's expired. I give the call to the Minister for Social Families and Social Services.
Thank you very much. And we've heard a lot of rhetoric from this minister. So much rhetoric from this minister, but no evidence whatsoever. Sorry, Shadow Minister, I shouldn't have promoted him that quickly. To hear so much rhetoric about crime, so much rhetoric, but with no evidence whatsoever. Of course, one of the things that the minister talks a lot about is crime. And the crime statistics, he hasn't been off to provide any of them, but the crime statistics, I'll give them to you. So, in fact, domestic violence offences as a subset of assault offences increased by 57% between 2014 and 2019 in Ceduna and surrounds. Of course, In Alice Springs, we've seen between 2012-2020 assaults involving DV increase as well. What we've seen is participants in areas where the CDC has been is no change whatsoever, or in fact things getting worse when it comes to crime. Now, this shadow minister has constantly ignored the evidence, and we listened to him a lot. He talked about Noel Pearson, and I met with Noel Pearson, and I had a very productive conversation with Noel Pearson. But he does misrepresent Noel Pearson, because one of the things that this shadow minister suggests is that the blanket application of the CDC to anyone on an income support payment is supported by him. But in fact, Noel Pearson has said he doesn't agree with the blanket imposition of the card. He doesn't actually agree with the blanket imposition of the card. And of course there's Ian Trust, which the Shadow Minister mentioned, of course, earlier, from the Wannon Foundation, who said about the card, it's lost its effectiveness as people work out ways of getting around it, doing other people's shopping, buying other people's fuel, and so on. That was probably going to be the case. So you have Ian Trust, who has said that the card is not really effective anymore. Of course, there was Ms PC Clark from the Central Australian Aboriginal Family Unit, and her organisation said who supports the repeal of the cashless debit card, and that this bill is a step in the right direction. Of course, Christine Donaldson, who was forced onto the CDC just because of where she lived. She said, I am an elder. I live in the goldfields in the region of West Australia, and I fully support the amendment bill and agree that the card needs to be abolished. And then there was Antoinette Braybrook from Far North Queensland, the co-chair of Change the Record. We agree with the government's conclusion that the cashless debit card is not evidence-based. It's ineffective and discriminatory. And Beverly Wally from East Kimberley, who said the cashless debit card has deteriorated a lot of life. There has always been parents drinking, drugs and gambling prior to the cashless debit card being enforced between 2015 and 16. Having said that, there's no change. Everything is still the same. These are some of the people living in these communities, and I would challenge the Shadow Minister. Has he actually visited any of these communities? Has he actually travelled to any of these communities? Because I have been up to the East Kimberley and met with organisations. I have been into Far North Queensland, as has the Assistant Minister. I've been to Ceduna and spoken to these communities. I have travelled through the Northern Territory, speaking to the women in the town camps, speaking to the women in the refuges in Kununurra, and I would challenge the Shadow Minister to go out there, because he actually might learn a couple of lessons. He might actually go and speak to the people that have been affected. Because, of course, when I heard from the people that have been affected, it has been shameful for them. It has ruined their life. For many, they have said, these are the lived experience of people, and they have said that they are embarrassed because they don't have enough cash to go to the school fete. They don't have enough cash to go and enter at the football to watch their country football. People are embarrassed and frustrated by this and shamed. And of course, one of the absolute furphies that those on the other side propagate is that everyone on the card has drug and alcohol problems. Everyone on the card has drug and alcohol problems, and therefore they have to tell them how to live their lives. I met that many people, carers, people on a disability support pension, that just said they've never touched a drop of alcohol in their life, and they don't understand why they are being punished. But I did want to get to the evidence, because that has been the opposition has been full of rhetoric and no evidence whatsoever. And of course, Deputy Speaker, the evidence speaks for itself. We not only had our 2 ANAO reports that have said that this was not delivering on the outcomes it had promised. Of course, we had the University of Adelaide report in January 2021 that found the evidence to support the CDC was inconclusive. The study found that any reduction of alcohol and drugs could not be attributed to the effect of the card. Now, of course, in that report as well, and this is evidence that the opposition always ignores, is that it also reported that the CDC introduced widely felt and costly hurdles to many participants in relation to their financial planning and money management, and a large proportion of CDC participants reported that their quality of life was affected. Another study by the University of South Australia and Monash University found the CDC in Ceduna had no substantive impact on gambling and drugs and alcohol abuse, and no substantive impact on crime or emergency department presentations. And in June 2022, of course, as I said, the ANAO released its latest audit, which was damning. Now, I would finally get to the point where the minister, the Shadow Minister, was banging his chest and talking about a lack of preparation from this side of the House. Let me remind the House a couple of things. First, the cashless debit card legislation is due to expire on the 31st of December, and there had been no moves by the former government to put together any legislation to actually extend it. Number one. Number two, there needed to be a tender process because, of course, the contract was running out for the supplier of the cashless debit card. Do you think the former government put any moves in place to ensure that there would be a smooth tender arrangement? Of course they did not. They took no moves to actually recognise that the tender was ending on the 31st. And, of course, in addition to that, we hear a lot about the support services, and I have been very, very interested in the support services because I know a lot of communities really value the support services, have recognised while the card hasn't done a lot, that the support services have made a difference. Do you think that in the March budget that the former government put any money in for services past the 1st of July 2023? Do you think they gave any certainty to these communities that they could continue to rely on these support services? No. How much money was in the budget after the 1st of July 2023? Zero. So to have this opposition come and talk about abandoning communities, about leaving them behind, about not supporting them absolutely is appalling because, of course, they did not put the provisions in to support those who have actually needed those services. So they can come in here and cry their crocodile tears, but there was no action, no preparation by the former government of what would happen come the 31st of December. Of course, I have been consulting with communities, I have been speaking with communities, and I will continue to work with communities about the future of voluntary income management. I will continue to work with the Family Responsibility Commission, recognising the important work they do, and work to make sure that their work is not impeded. But what we will not stand for is a blanket in communities, sometimes picked by the local member, an imposition of a blanket card for anyone on a working age payment. That led to stigmatisation, but significant problems when it came to practical life decisions. This government will work with communities. We will continue to listen to them, work with them and deliver for them, unlike those opposite.
Thank you. I give the call to the member for Page.
Thank you, Deputy Speaker. Deputy Speaker, the bottom line of this legislation going through Parliament, both in this House and the Senate, if it does next week, is that this government, and it did it in a rush, it was one of the first pieces of legislation they put through this Parliament and in fact moved an urgency motion to rush it through. What this legislation passing will mean is that this government, this Labor government, are going to place women and children in dangerous situations. They're going to place women and children who currently are in a safer position. They are going to place them in a very dangerous, vulnerable situation. These communities of where this cashless debit card are were chosen very purposefully. It wasn't done randomly. They were in remote communities, and predominantly in remote communities that had a higher level of domestic violence and other forms of abuse than the rest of the communities around the country. Now, that is sad. That is a very sad, was a very dangerous situation. We're talking about communities where children had sexually transmitted diseases. We were talking about communities where the presentations to hospital of domestic violence, school absenteeism and the worst type of abuse you want to inflict on women and children were higher than the average around the country. They were chosen very purposefully. This wasn't picking on people. This was going to communities that the statistics said that women and children were in trouble, that it was dangerous. It was dangerous to be in those communities, especially on certain nights when the welfare money arrived. It was dangerous. These communities, and I have been to them, I grew up not that far from Ceduna. I know Ceduna very well among some of the other communities. And what would happen on those nights when it was specifically dangerous, when everyone basically, a large part of the population were drunk, was children would roam the streets at night because that was the safest place for them to be. It wasn't safe to be in their homes. It wasn't safe to be inside. They would roam with friends because that was the safest place for them to be. Now, what is this? So what is this outrageous stigmatisation that the government go on about? What it is they get a card and they can spend 80% of it on essentials. They spend it on food, they spend it on clothing, they spend it on the essentials of life, and they had 20% left over to spend on things that you would need to spend cash on. Now, in an ideal world, of course you wouldn't want to do that. But it was done not to pick out victims, it was done to protect victims. It was done to protect children who were getting sexually transmitted diseases. It was done to protect women and children from going to hospital. That's why it was done. So when this is done, when this legislation goes through and the violence goes back into those communities, shame on all of you. Shame on all of you. This ideological thing, oh, we're stigmatising people. What a stigmatisation it is to give someone a card. How terrible that they had a card, that they went to a supermarket and bought food and essential items. What a stigmatisation is! What a stigmatisation is that? The fact it was a rush, I don't understand. The fact that in the first 2 weeks of the parliament, they had to rush this through. So when these communities, when the violence starts increasing, when the hospital presentations start to pick up again, when the children are starting to get sexually transmitted diseases again, shame on all of you. Shame on all of you because of this ideological obsession that you can't give them a card and the terrible things that was doing to them. And the minister said we'll talk to people. I have, and I've also spoken to my Senate colleague, Jacinta Price, who lives in Alice Springs. And, so she's not qualified to comment? Is that what you're saying, Assistant Minister? She's not qualified to comment, and she has said the same thing. We can talk about a lot of sinew virtually, we can talk about a lot of symbolism, but what this government has done, if you want to talk about closing the gap, which is a very important thing to do, passing this legislation, you've just meant the gap isn't going to get closer. You've just widened the gap. And you've widened the gap especially in the communities where this is going to be lifted. So thank you for nothing there. Again, the Shadow Minister, when he got up, and I won't go through some of the quotes that I've got here, but a lot of the elders in these communities are very disappointed about this. A lot of the leaders in these communities are very disappointed about this because it had made a positive difference. I know Ceduna, it had made it a safer place to be in during the daytime. It had made the tourism was back. It was significantly different. You could feel the difference. So shame on you for putting those people back into danger.
And I give the call to the Assistant Minister for Social Services and Prevention of Family Violence.
Thank you so much, Deputy Speaker. And look, I find it beyond remarkable that the opposition has put forward this matter of importance in relation to vulnerable people. I mean, the Liberal and National parties, the parties of robo-debt, the parties of work choices and healthcare cuts, the parties that introduced the harsh cashless debit card, to come here today and stand here and lecture us about it is absolutely appalling. The fact is we're delivering on the government's election commitment to abolish the cashless debit card, and we are doing that because privatised welfare does not work. That is the reality. And we have consulted extensively about abolishing the card. Now, these opposite, they didn't consult with anybody when they put more than 17,000 people on the card. Bang, they were put straight on the card. That's the reality. We are working with communities who have been devastated by the cashless debit card. They can yell as much as they want, but the fact is they force people onto privatised welfare. You know why they're yelling? You know why they're annoyed? Because they were going to roll it right out across the country. That's exactly what they intended to do. That's why they're in here today. The fact is the cashless debit card is privatised welfare, and there's something deeply, deeply wrong when private, for-profit companies control people's income support payments and they determine where they can actually spend their money. Not a government department, a private company did it. And what happened when people contacted them and said, I can't access a lot of goods. I can't have. There's no money in my account. What's going on? They got no help. They got no support because it's a private company. If you had any problems with the card, nobody was interested. Nobody would listen to you. So we know the former government spent more than $170 million on the cashless debit card program, money that would have been better used for support services in those vulnerable communities. We also have a lot of evidence that it just didn't work. We know that. In fact, we had the Australian National Audit Office just recently release its latest audit on the performance of the card, highlighting once more the lack of evidence. But we also know, because of the extensive consultation that we have done with communities, both the Social Services Minister and myself have consulted widely with the impacted communities. I have been in Bundaberg and Hervey Bay and spoken with many people there about how they've been impacted. And that includes community members, participants, service providers in Cape York as well. Listen first-hand to their community and what they want to see moving forward in terms of income management. To Western Australia, speaking with many participants and local councils as well, particularly many individuals whose lives have been devastated by being on this card. But as I said, the reason they were so angry before is they did want to roll it out right across the country. We know that was their agenda, to put more recipients upon the card. And the fact is it has devastated so many lives. So many people I've spoken to whose lives have been impacted. The card was very restrictive. It was often declined. People couldn't buy basic food or groceries. People couldn't pay their rent. They couldn't make car repayments. They couldn't buy second-hand clothes. It's had a devastating impact on individuals because they've stripped away their dignity and they have felt so stigmatised by it. In fact, I was handed a number of notes of the many consultations that we've had, people saying, I can't pay my rent because at times my landlord takes cash and it's really embarrassing. They can't pay their rent. They can't pay for things that require a BSB payment. They're judged everywhere they go. And that also you can't speak to anyone when you have a problem. But we are approaching the abolishing of the cashless debit card in a responsible way to ensure that communities and individuals are properly supported transition off the card. We will keep consulting with those, particularly also in relation to the issue of voluntary income management as well, because we have listened to people. We have listened to First Nations community leaders. We've listened to service providers, and really importantly, we've listened to participants. The fact is, privatised welfare does not work. No matter how much those across keep pushing it, it does not work at all. And nothing highlights that more than the absolute disaster of the cashless debit card. And, you know, it brought people, lots of very vulnerable people, a huge amount of shame, and they were stigmatised everywhere, and they couldn't access the basic services that they need. They felt they were being punished and demonised. But these people are still pushing the benefits of it, despite the thousands of lives that they ruined because of it. And you know why? Because they're so obsessed with privatised welfare, and they're so annoyed that we stop them rolling it out across the country so they can stigmatise and ruin more lives of vulnerable people. And we are abolishing it.
Thank you. I give the call to the member for Grey, and just remind the House that we might just tone down the interjections.
Thank you very much, Madam Deputy Speaker. I, of course, have the first community that adopted the cashless debit card in my electorate in Ceduna, and I absolutely refute many of the allegations that the Assistant Minister just made, including that the community was not consulted. I mean, it is absurd. It was the community of Ceduna that actually set the 80-20 split. We have an Far West Indigenous leaders group there. They met every 2 weeks during the implementation and rollout of this program. Allegations were made by the minister that people say they can't go to football and use their car. That is incorrect. It can be used for school lunches. It can be used at the football gate. It can be used inside the club rooms at the football. Can't be used to buy alcohol while you're at the football, though, I'm afraid, because that's what it's designed for. It's worth reflecting that this card was brought in the aftermath of the state coroner's report in South Australia following 6 deaths in Ceduna over less than a decade that are related to alcohol abuse. There was another one while the Commissioner was inquiring. Now, we haven't had any such deaths, and touch wood, we haven't had any similar deaths in the period since the card has been introduced. I absolutely refute the allegation that the people of Ceduna do not support the card. They know full well that I'm in favour of the card, and they keep supporting me. People can check the ballot figures on Ceduna if they wish. And so I am, with very heavy heart, the fact that the government is intent on taking this ideological step. And I am absolutely convinced we'll see a lift in violence, a lift in antisocial behaviour, drunkenness, quite likely some untimely deaths. And I have told the minister quietly, and I thank her for coming out to Ceduna, but she came there with the decision already made. I have told her that however you cut this up, she and the government will be held responsible for the outcomes. I noticed a couple of the submissions to the Senate inquiry as it went round, and I refer particularly to Alan Soutar's combination, and he went through that period where it was Ceduna that. It was the Ceduna community that set the 80-20. And not only did they set the 80-20, they actually embedded in the design of the card that people could be reduced to a 60-40 split if they like, if they met some certain criteria. And he is of the opinion, and I quote this, that it was a clear demonstration of how the removal of the cashless debit card in Ceduna will damage our community. I would encourage some to do some homework about the time during the pandemic where support payments were made outside the cashless debit card system. Our community experienced severe disruptions, including drunken rioting, family violence and major social disruption due to the substance abuse. When these extra payments stopped, so did the trouble. He goes on to say, unfortunately, most Ceduna residents fear that the removal of the cashless debit card will turn back the clock to where we were prior to 2008. When this happens, the opponents of the cashless debit card and the Australian government will be totally responsible for the resultant increases in family violence, public intoxication and potentially more deaths such as those covered by the 2008 coronial inquiry. I thought perhaps the Senate committee, when they were inquiring to this, may have listened to Noel Pearson when he told the meeting that Labor's decision to outlaw the cashless debit card nationwide would ruin 2 decades of progress and reforms in Cape York, because the card there has replaced the Basics card, and the Basics card was a very clunky type of system, whereas the cashless debit card is pretty seamless. It is. I don't carry one in my pocket, but the member for O'Connor does, and it's virtually you cannot check it visibly from any kind of distance that it is anything but a normal card. So I am very concerned about what has happened in my Ceduna community. It's a community that's come so far in the last decade. It's barely recognisable from what it was. And when you compare it to similar communities around Australia that haven't had this card—
Time's expired. Thanks, the member for Grey. Give the call to the Manager of Government Business.
I'll move that the business of the day be called on.
Then I will be putting the question. that the business of the day be called on. All those of that opinion say aye. Aye. Against, no. The ayes have it. No, sorry. The ayes have it. So, thank you. I will. You don't. Just for the members' information, you don't get to debate or make. You won't get a call when the minister has moved that the business of the day be called on. So that does take us to a message that I have received from the Senate. The following message from the Senate has been received. The Senate returns to the House of Representatives a bill for an act to set out Australia's greenhouse gas emissions reduction targets, to provide for annual climate change statements, to confer advisory functions on the Climate Change Authority, and for related purposes, and informs the House that the Senate has agreed to the bill with the amendments in the annexed schedule. The Senate requests the concurrence of the House in the amendments. I give the call to the Minister.
Madam Deputy Speaker, I move that the amendments be considered immediately.
I put the question. All those that the amendments now be considered immediately. All those of that opinion say aye. To the contrary, no. I think the ayes have it. Minister.
I move that the amendments be agreed to. Madam Deputy Speaker, our parliament and our country have seen too many bad days on climate change. Today is a good day for our parliament and our country, and we're going to need many more of them. But today is one step, but it's a big step, to give this country a sensible climate change policy, to give this country a climate change policy which sends the message to the world that we are open for business, for renewable energy, for transmission and for storage. Madam Deputy Speaker, this is a good day for our climate. It's a good day for future generations. It's a good day for workers in Australia's regions, because that message that we send to the rest of the world that we are open for business is a message that investment should come to the regions which have powered Australia for so long and will power Australia under clean, renewable energy, and regions that will create so much energy that it can be exported to the rest of the world and we can be a renewable energy powerhouse. That's what this message does from the Senate. That's what this bill does that will become an act as a result of this House's actions and the other House. We have left it too late as a country. We are starting today to achieve an emissions reduction goal for 2030, which is 87 months away. That is not long. Therefore, we have not a second to waste. That's why I say this parliament and this country need to see many more good days for climate, as we ensure we're reducing emissions in electricity generation, in transport, in industry, in agriculture. That's the process we begin today. But the first step is to send the framework, the message, the signal to the world that we're ready, and that's what we're doing. So, Madam Deputy Speaker, I thank the House. I thank the members of the government for their steadfast support, not just today, not through just this bill, but from December the 2nd last year, when the now Prime Minister and I released the Powering Australia policy. It was a controversial thing to do. More than one political party has lost an election on such issues. I thank the members of the government for their steadfast faith and support through all those months. I thank the crossbench for their support, working in good faith with the government, improving the bill, making suggestions that the government was more than happy to accept in this House and in the other House. That's how a good parliament works. That's how a government of grown-ups work. That's what a sensible process does. So I thank those members of good faith in both houses who voted to make this bill a law. I want to thank the key officials in the Department of Climate Change, Energy, Environment and Water, the Deputy Secretary Joe Evans, Kath Rowley and the entire team, finer public servants you would not meet, and I want to thank them for their very important contribution to this bill. I want to thank Andrew Garrett in my office and Peter Nicholas in my office for all their work in making this bill a reality. And again, I thank the House. This is an important day. It's one step, but it's a very important step. In the world of climate change action, Australia is back. In the world of sensible climate change policy, Australia is back. In the world of investment in the energy of the future, clean energy, Australia is back. The message goes out from this House today to the world. 10 years of denial is over. 10 years of delay is over. 10 years of dysfunction is over. 10 years of division is over, and today the real work begins.
Thank you, Minister. Are you seeking the call, member for Fairfax? You have the call.
Thank you very much, Deputy Speaker. Well, today is the day that the Labor Party's climate change policy comes into fruition, into legislation. The policy that they took to the Australian people, a policy that included not one but two key targets. The first target was a 43% reduction in emissions by 2030. The second target was a reduction in household power bills by $275. And it was based on this climate policy that the new government came to power, looking the Australian people in the eye, promising them that they would not only reduce emissions more than the former coalition government, but they would reduce power prices more than the coalition government. The coalition government, by the way, that achieved an extraordinary performance on both counts, a coalition government that saw emissions reduce by over 20% on 2005 levels, and a coalition that ensured that power prices came down by 10% over the last term of government. Power prices coming down for both households and businesses. But the Labor Party came to the Australian people and they said to them, we can do better. Not only will we get emissions down further, they promised prices would come down further. Prices would come down further. And as we are here today, with the Labor Party celebrating the Greens Labor legislation, the Albanese-Bandt government's legislation, we have households throughout this country who are opening up their power bills. And what are they seeing? Higher prices. Prices that are going through the roof. We are talking with businesses right now, and there are probably business owners, there are probably people who have invested their own money into their businesses, listening to this very debate and hearing the celebrations of the Labor Party, despite having told them that they will reduce their power prices, but their power prices are going up. We are talking to businesses today that might have to close their doors because of the power prices, and this Labor government has no solutions, none whatsoever. The only thing they bring in the House by way of this legislation today is a claim of the 43%, something they had already advised the United Nations on. We have the minister himself standing up, who had gone public before showing this bill to the House, saying it was not necessary, saying the bill was not necessary, and yet in it comes. And what we saw through the last month through the Senate inquiry was the very concerns that we had raised in this House being confirmed, and that was the department under the minister had done no work on modelling the impact of this bill, especially on rural and regional communities. So any regional or rural community, any resident of regional or rural Australia, this government, this minister and his department have not done their homework. And let them scream about the last 9 years. Well, they had 9 years to get this right. 9 years to do some modelling. 9 years for the department, therefore, to have something. But the modelling they claim they've done, and guess what modelling they have done? Modelling that says power prices will come down by $275. So, Madam Deputy Speaker, why is it over the last couple of months that neither the Prime Minister nor the Minister have been able to stand at this dispatch box and confirmed $275 are coming off household bills. Why? Because they did not look the Australian people in the eye and tell them the truth of what their plan was. So as power bills go up, it is on them. As businesses close, it is on them. And we know the truth. This 43% legislation was unnecessary, and they're the words of the minister, and he will live by it.
Thank you. Your time's expired, and I'm just going to remind the member for Warringah, because you entered the parliament a little bit later, but we're considering the Senate message, which is asking the concurrence of the House for amendments. It's the wish of the House to consider those amendments together, so I'm giving you the call now, member for Warringah.
Thank you, Madam Deputy Speaker. And I rise simply to say that I do welcome the message from the Senate, and this bill returning amended strengthens some more with the amendments moved by crossbenchers in the Senate. This is an important step, and it's very important for Australian peoples not to be caught up in the political games and the rhetoric that exists in this place. The reason why we have an energy crisis and rising energy costs is that for too long we have denied what needs to happen. We have failed to implement policies. The coalition has failed to implement policies for too long to ensure that we are at the forefront of the energy transition. Let's be really clear. The cost of living pressures are directly impacted by global warming and climate change. Insurance premiums are escalating and rising rapidly. We need to address that, and that is a direct impact on households and their cost of living. Food supplies, transmission, it is all directly impacted by climate change and global warming impacts and events. Fuel. The only way we will have domestic fuel security is if we electrify transport as rapidly as possible, and that requires electrification and transitioning to renewable energy as fast as possible. So I welcome the message from the Senate and the bill as amended, and I want to thank the Australian communities that have asked both sides of politics since 2019 to legislate Australia's commitment to net zero by 2050. They got behind the climate bill that I presented in the last parliament, and they support this bill because we need that certainty of legislating net zero by 2050. The Minister for Climate Change and Energy is well aware of my position that I want to see greater ambition, but I recognise that this is a start. It is a good start, but we need to make sure we increase that ambition and accelerate that emissions reduction as soon as possible. We are on track for exceeding 2 degrees of warming. This is not enough. And if we're going to be consistent with the Paris Agreement, we need to ensure we reduce emissions at a greater rate. We have the technology. The Australian people want to see it happen. You need to be brave and embrace the opportunity. It does mean not approving more fossil fuel projects, and that is something that I look forward to having more discussions. But for today, this is an important day. Let's be really clear. This does provide policy certainty for businesses and for investment to know that Australia is committed to reducing emissions and to being in step with the rest of the world and embracing a net zero world.
Thank you. No further speak. Okay, I'll give the call to the member for Curtin.
As we see the increase in floods and fires across the country, I think the majority of Australia will be really pleased to see this symbolic start to a new era. This gives us an opportunity to shift our focus from the past to the future. And Australia really has an opportunity to have a bright future as a green energy exporter. And just as we have had waves of economic activity in the past that have been driven by foresight from previous governments and investments in infrastructure, so too this represents a new era when we have that opportunity to be thinking about what our economy looks like in 20 years' time. I'm grateful for the collaborative approach that has been taken by the government in this first symbolic step to the shift that we need to see in our broad economy. And the consequential amendments bill lists a number of the places we need to start, which is the beginning of the work that we need to do together. This transition will need to be smooth, but will also need to be bold. And I'm very excited to see this change and look forward to continuing the work that needs to be done.
Thank you. If there are no further speakers, I will put the question that these amendments be agreed to. All those of that opinion say aye. Again, the noes? Do you require a division? I think the yes has it. Do you require a division? Then we'll ring the bells for 4 minutes, please.
Block the doors. The question is the amendments be agreed to. The ayes will pass to the right of the chair and the noes to the left. I appoint the honourable members for Werriwa and Bean as tellers for the ayes and the honourable members for Grey and Parkes as tellers for the no. Order. The result of the division is ayes 86, noes 50. The question is resolved in the affirmative. The following message from the Senate has been received. The Senate returns to the House of Representatives a bill for an act to deal with consequential matters arising from the enactment of the Climate Change Act 2022 and for other purposes, and informs the House that the Senate has agreed to the bill with the amendment in the annexed schedule. The Senate requests the concurrence of the House in the amendment, and I give the call to the Minister.
Thanks, Mr Speaker. I move the amendment be considered immediately.
I'll put the question. All of those opinions say aye. Against, no. I think the ayes have it. Give the call to the Minister.
Mr Speaker, I move that the amendment be agreed to.
I'll put the motion. I'll put the amendment. All of those opinions say aye. Against, noes. I think the ayes have it. Noes have it. Division required. Ring the bells for 1 minute. Member for Hume. Block the doors. The question is the amendment be agreed to. The ayes will pass to the right of the chair and the noes to the left. And I appoint the honourable members for Werriwa and Bean as tellers for the ayes and the honourable members for Parkes and Grey as tellers for the no. Order. The result of the division is ayes 86, noes 50. The question is therefore resolved in the affirmative. I've received a message from the Senate informing the House that Senator David Pocock has been appointed a member of the Joint Standing Committee on the National Capital and External Territories. It being approximately 4:30, I propose the question that the House do now adjourn and give the call to the honourable member for the question. I give the call to the honourable member for Cunningham. I give the call to the member for Cunningham. Order. I'll wait till the microphone is active for the member for Cunningham. And I give the call to the member for Cunningham.
Thank you, Mr Speaker. This afternoon I'm going to talk about a wonderful little girl and her family who I had the great pleasure of meeting last week and again today in the Parliament. Last Wednesday had been a relatively quiet day in my office. I'd been working on my first speech and I'd met with a few constituents. And then in came Harper Rowlandson in her pink tulle skirt, black and gold shiny top and pink sand shoes, and my afternoon changed completely. What a whirlwind of personality. I didn't even get the chance to introduce myself to her mum Katie, her dad Luke and her little brother Eli and Sarah from the Shepherd Centre. Harper, at 7 years old, came in to see me to get some tips for her speech here in the Parliament House, to the Power of Speech breakfast, which she gave here today in Parliament. It was a week of first speeches in Parliament House for both of us. I gave her some tips on continuing your speech, even if your brother is being a little bit annoying. And Harper told me that speeches in the Parliament need more love hearts and butterflies. My followers on Facebook agreed that Harper was right. This place does need more love hearts and butterflies. I'm going to outline some of Harper's speech to you here today. When Harper's mum, Katie, was pregnant, doctors discovered that she had the same eye cancer as her dad Luke and her brother Eli. Harper was born early and had chemotherapy when she was just 12 days old to save her eyesight. As a consequence, she lost her hair and she lost her hearing. Her hair grew back, but her hearing didn't. She got hearing aids when she was nearly 2 and cochlear implants, or her super ears as she calls them, when she was 3. Kate from the Shepherd Centre started speech therapy with Harper and also visited her school, St Joseph's at Bulli, to show Harper's teacher how to use her devices so she can still hear the teacher when the classroom gets noisy. The Shepherd Centre do some amazing work helping children with hearing loss and their families. They provide early intervention services for children and toddlers, speech pathology services, social skills and resilience training for young children to develop confidence, as well as preschools which help educate children with and without hearing loss, one of which is in my electorate. They provide many other services too, and I'm really grateful for the work that they do. Harper dances, she swims, she does gymnastics, and I'm a little bit jealous that she is able to listen to music while she is swimming, because that's pretty cool. Harper showed me some of her gymnastics, the splits and a backward walkover, but her mum and I had to be the fun police and talk her down from handstands and cartwheels in my very small meeting room. Today, Harper delivered her speech in front of the Prime Minister, the Deputy Prime Minister and the Minister for the NDIS. She spoke with confidence and bravery. Having recently delivered my own first speech, I understand all too well the pressure that comes with big speeches, particularly in this House. But Harper rose to the occasion and she did herself and our community proud. The event was First Choice and Cochlear's Power of Speech breakfast. It was aimed at challenging common ideas around what deaf children can and cannot achieve. It was an honour to attend and to be able to listen to the lovely speakers tell their stories. As the Minister for the NDIS, the Honourable Bill Shorten, shared at today's event, seeing a baby have their cochlear implant switched on for the very first time is nothing short of a scientific miracle. These devices change lives. Harper was one of 7 children from Australia and New Zealand with cochlear implants who were invited to speak. Harper was a ball of energy and an absolute inspiration. I know how proud Katie, Luke and Eli must be after seeing Harper speak today. Harper also has a friend, Alana, who lives in England near the Queen, and they chat on Zoom about their super ears. Harper loves being able to talk to someone on the other side of the world who also has super ears. Apparently Alana is a little bit scared of coming to Australia, though, because of our spiders. I am very pleased to be able to stand here today and share Harper's story, a young girl who has faced so many challenges but has risen to face them again and again. She runs headfirst into her experiences with an optimism and enthusiasm that is absolutely contagious. Harper has a bright future ahead of her, and I thank her so much for bringing more love hearts and butterflies to my office and that I can bring here today, all the way from Wollongong to Parliament House. And I also thank the Shepherd Centre for the work that they do to help children like Harper. And I am so pleased that Harper and I were able to do our very first speeches in Parliament House in the same week.
Order. The question is that the House do now adjourn, and I give the call to the honourable member for Braddon.
Thank you, Speaker. Suicide Prevention Australia's State of the Nation report was released on Tuesday. The report revealed that an unprecedented 70% of Australians are experiencing elevated stress beyond their normal levels compared to this time last year. A conclusion was that two of the greatest stressors were the cost of living challenges and personal debt. Speaker, this is alarming, and so was the report. We all know that in the last few years it has been incredibly tough right across the nation. We've been challenged like never before. The toll has been great. There's no denying that. It's important to note also that these challenges aren't new. They've been at the forefront of government's thinking since the pandemic hit back in 2020. It's something that the former coalition government managed day in, day out for 2.5 long years. And, Speaker, in that time our government was able to respond quickly to every challenge that was thrown at us. We found a way to provide the support when it was needed and where it was needed. We targeted the cost of living measures that helped ease pressures on household budgets at the time that they needed it most. We reduced taxes so that hard-working Australians kept more of their hard-earned money. We cut the fuel excise that instantly reduced cost of living pressures. We looked after our most vulnerable by delivering a $250 cost of living payment to nearly 6 million pensioners, welfare recipients, veterans and eligible concession card holders. This was at the top of our landmark JobKeeper, JobSeeker and other pandemic measures that were universally applauded right across the nation. Speaker, people still stop me in the street today and thank me for being a part of a government who saved their business and kept a roof over their head. In May this year, the nation put their trust in the Labor government, whose promise was to tackle, as they put it, spiralling costs of living and a crisis. Mr Speaker, Australians are still waiting for the Albanese government to keep that promise. On Tuesday, on the back of the Suicide Prevention Australia's State of the Nation report, the reporter asked the Prime Minister what the Albanese government was doing in the immediate term to help people get through this cost of living crisis. For those who missed it, I can update the House that the Prime Minister made 4 claims. One claim was that his government was responsible for the recent increase in the pension. Speaker, this is not the truth. The truth is that the Department of Social Services regularly review the rate of the pension and other welfare payments, and this increase was simply a result of that twice-yearly review and had nothing to do with the Albanese government. The next claim was that his government was responsible for the recent increase in the minimum wage. Speaker, again, this isn't the truth. The truth is that the minimum wage is determined by the Fair Work Commission, an independent and separate from government organisation. Their submission was one of many, and I would say that they have no more right to claim ownership of the rise in the minimum wage than the other stakeholder. And finally, Speaker, the Prime Minister claimed that their commitment to cut the costs of medicine and childcare will reduce the current cost of living pressures ordinary Australians are facing right now. Again, this can't be true. The legislation has not even been introduced to the Parliament. So if both pieces of legislation do pass, the Albanese government has said cheaper medicines will not be available until January next year, and cheaper childcare until July next year. Therefore, Speaker, on behalf of the journalists whose question was left unanswered, on behalf of everyone living across the northwest, the west coast and King Island in this great state of Tasmania, on behalf of all Australians, I ask the Prime Minister, what is your government doing right now to help those struggling through this cost of living crisis?
Order. The question is the House to now adjourn. I'll give the call to the honourable member for Tangney.
Thank you, Mr Speaker. Australia's future is built upon shared value and the colourful diversity of its many citizens and guests, and there are many stories. But I may suggest that the very cornerstone of Australian democracy and the greatest test of other democracy is the provision, accessibility and the use of social infrastructure. It's not difficult to find things that divide us, the way we walk, the way we talk, where we came from and where we live, or if we store our Vegemite in the pantry or our shoes at the front door. If we just look past our noses, we'll find many differences between us. So, where is in our society do we find a place that we can bring everyone together? Social infrastructure are our shared space. Our park and their barbecues, green spaces, school and child care center, places of worship and market, and countless beautiful beaches and wonderful rivers. But none of these are more glorious than our libraries. I love the library. Mr. Speaker, what other place do people leave prison go to access a computer to find a job? When a new family arrives in Australia, can't speak English, where else do they know to go to learn? When you are studying for an exam to build a better future for yourself, or printing CV for job application, or maybe you are looking for an opportunity to find out about activity in your community and how to be involved, you have the library. Libraries provide so many functions and that are tailored to fit the needs of their own communities. Whether people are wanting to start a business or wish to research, or they are new mother who feel isolated and wishes to meet other moms to share their many difficulties, but also the many joys and triumphs, and the library is there to support the community. The library is the intersection of communities and a meeting place for people looking for a better life. It is a joy to know that the people in my community in Tangney are so well serviced by so many libraries, staffed with very wonderful librarians. Be in Willigi or Williton, Bull Creek or Riverton, there is a library for you. My constituents can also visit A.H. Bragg's, Civic Square, Jeffrey Bolton and Canning Bridge Express. My community is only made stronger for their contribution and assistance. I must thank them for the work they do and the role they play in our community. Libraries provide a vital service. By design, libraries are dynamic and create resilient communities. Because libraries are not about books, they are about people. Libraries don't discriminate old or young, rich or poor, citizen or guest, black or white, purple or pink. All are made welcome. And our libraries are best when they are supported to do their jobs. The last government did not support librarians well enough to retain their jobs and keep food on their table when libraries were closed, particularly when our library across Australia contributed resources for public health awareness and support activities. With all the libraries in my electorate support activities in response to the pandemic, I look forward to having a library membership with all the libraries in my electorates. And of course, I must thank the Parliamentary Library here in Canberra who assisted even with this speech and with the work of my office. Mr. Speaker, where else can the public belong to get institutions, sometimes with high ceiling and beautiful windows, and other times small and close to their home, a place where the public can be welcomed in warmly and given opportunity to live with so much more than they entered with. Mr. Speaker, Andrew Carnegie has a phrase he used to describe library. They are palace for the people. And Palace for the People is also a title of a fantastic book, Mr. Speaker, which you were pleased to know you can borrow for free from your local library. Thank you.
I give the call to the honourable member for Durack.
Thank you, Mr. Speaker. In 2022, it is inexplicable that any town in our nation could be likened to that of a war zone. Yet early last month, reports from the beautiful town of Carnarvon in my electorate of Durack said otherwise. In a letter addressed to Premier Mark McGowan, Shire President Eddie Smith said some parts of the town look like a war zone and at times were exactly that. It is a harrowing tale, Mr. Speaker, all too familiar to those living in regional Western Australia. Stories of ongoing domestic violence, child abuse, alcohol and drug abuse, youth crime, the list goes on. You can help alleviate these problems by providing access to better services for at-risk youth and for struggling families. But community leaders in Carnarvon are saying that too many state government services are being managed from Geraldton, some 500 kilometres away. Durack is the largest electorate in Australia, spread over some 1.4 million kilometres, with over 300 towns and communities. Access to services is a constant challenge. You cannot simply travel from one suburb to the next in 10 minutes by simply jumping on a bus. This problem, Mr Speaker, is not unique just to social services providers or just to Carnarvon. Councils are struggling to find chippies and other tradies, the local cafes, struggling to hire the coffee makers and the chefs. Childcare centres can only staff a quarter of what the demand requires from them. And if Labor, state and federal, actually took a moment to consult with the community leaders on the ground and take into consideration the unique challenges of remote and regional Australia, they would know that a lack of housing, Mr Speaker, lies at the core of these workforce issues. Put simply, if you cannot house your workforce locally, then what chance do regional communities in Western Australia have at attracting workers? How can they possibly grow, Mr Speaker? How can they develop? West Australia's resources sector alone, a majority of which is based in my electorate of Durack, they're going to need another 40,000 workers by mid-next year, according to the Chamber of Minerals and Energy of WA. When I visited the beautiful town of Tom Price only last week, I was told that the senior high school has 12 teacher vacancies. 12 teacher vacancies. And the feedback that I got on the ground said that this was due to a lack of housing. Now, that's on the McGowan government. That is their responsibility to get the teachers and to house them. In WA, there is close to 19,000 people currently on a waiting list for social housing. And of that 19,000, over 3,400 of those call Durack home. These are not just people struggling with homelessness, but of course this is also for other very vulnerable people in our community, like victims of domestic violence. And I'm sure that Premier Mark McGowan and the Housing and Lands Minister John Carey are aware of the housing crisis that's hurting communities in my electorate. But they are not behaving like it is a crisis, Mr Speaker. Local families and businesses are suffering. So I ask, where is the outrage? Where is the sense of urgency? Where is the action? Mr Speaker, I understand there is close to 2,000 social houses across the state of Western Australia that are empty and are in need of repairs. Now, this is shameful. While Labor are trying to build new houses in an incredibly overinflated market with blown-out building costs, we know the story about how hard it is to get a house built. They need to focus on fixing up the stock of houses that they currently have in their control. Now, of course, the state government is not the only provider of houses. We know businesses, especially the mining industry in Durack, they are owners of housing stock, private individuals, local councils. But for such a wealthy state, Mr Speaker, you would think that putting a roof over the head of vulnerable West Australians, making sure our key service providers in regional WA, like our nurses, like our police, would be a priority for the McGowan government. But it doesn't appear to be. Yalgoo, in my electorate, has over 200 residents in a town that needs and deserves services, just like you and I, Mr Speaker. They are struggling to find professionals to deliver these services because they have nowhere to house them. When I visited Yalgoo recently, and my word, the wildflowers were wild, I learnt of a contracted nurse who had been forced to live in housing provided by the local council because the health department housing provided to her was unsafe. We need action. This is shameful. McGowan needs to act.
Order. The question is the House to now adjourn, and I give the call to the member for Chisholm.
Thank you so much, Mr Speaker. Yesterday, on the 7th of September, I had the great pleasure of meeting with members from the Micah Women Leaders delegation. So I met with Edwina, Rachel, Sylvia and Tracy, who were part of a much larger delegation of senior women leaders from across the Australian Church, meeting with over 45 MPs, of which I was just one, from all sides of politics to discuss their Help Fight Famine campaign. And it was a really enlightening meeting. I found out that currently we have 828 million people in the world experiencing hunger, and that is a really shocking figure. Because of the work the Micah Women's delegation has done, they've been able to advocate for the poorest and most vulnerable people in the world. This was the 4th annual delegation that the leadership group was able to undertake, and it included 40 women leaders representing over 12 different denominations advocating together, which I think is a really wonderful example of collaboration. Micah Australia is a coalition of Christian international development agencies and churches under the leadership of Reverend Tim Costello, and it empowers Australian Christians to advocate on the most urgent global justice issues affecting our world today: extreme poverty and hunger, rising conflict and climate change. And I think it's really significant that climate change legislation has gone through both houses in this place today, because it is not just an issue that affects us here in Australia, it is a global problem, and I'm so glad that Australia is finally at last contributing to meaningful solutions for our planet. We are experiencing a combination of crises in the world at the moment that have meant that the global hunger crisis is really being exacerbated due to pandemic, due to climate change and due to the war in the Ukraine. It's a perfect storm for an unprecedented hunger crisis. Those facing acute food insecurity in the world has soared from 135 million to 345 million. And I know that this is an issue that people in my electorate of Chisholm care very strongly about. I would say that taking action to address extreme hunger in the world is one of the top issues that I receive correspondence from my constituents about. And that doesn't surprise me, because my constituents are very caring people who believe very strongly in social justice issues and on the need to advocate to representatives like myself to take action. And I'm really grateful for the fact that the community is so outspoken about these issues, because that means that I can effectively represent them in this place, advocate for solutions and be accountable to the people who voted for me. We know that in Somalia, the UN declared just on Monday this week that famine is at the door and will strike at any time. And famine, to have something declared as a famine, is really a significant threshold that has to be crossed, and it is really alarming that we are seeing that in the world at the moment in Somalia. So we know that we can't, as one nation, solve these issues in the world by ourselves, but we do need to be part of the global effort, just as we've been part of the global effort to address the crisis in Sri Lanka, to address the climate change issues. And I know that Australia is looked to as a leader across the world for our capacity to respond compassionately to crises like this. So we are seeing that there are several growing hunger hotspots in 2022 in Ethiopia, Somalia, Yemen, South Sudan and Afghanistan. And of course, all of our communities here in Australia do have people that have come from those countries and have families in those countries still, and it is desperately worrying for those people to see what is going on overseas, and they desperately want Australia to be part of the solution. So I was really honoured to be one of the MPs approached by the Micah Women Leadership Delegation. I made a commitment that I would speak on this issue in this chamber, and I'm really pleased that I've been able to do so soon after meeting with them. I look forward to working with the relevant ministers in our government and with the Micah Women's Leadership and, of course, my community in Chisholm to continue to advocate for solutions and seeing what Australia's role can be for these wicked global problems that my community cares very, very deeply about, as do I. Thank you, Mr Speaker.
The question is the House do now adjourn. And finally, I give the call to the member for Fowler.
Thank you, Mr Speaker. Saving the best for last. Look, it has been definitely an eventful sitting week in the heart of the nation's democracy. My constituents sent me to this place to work for them, to vote for them and to negotiate on their behalf. It is my understanding I share this mandate with my colleagues in this chamber. This week I spoke about my journey to this place and the Australian Parliament, the centre of democracy. I even caused quite a bit of a stir with my choice of fashion. I'm proud to be an Australian. I'm proud to call Australia home, and I display my appreciation and love for this country on my sleeve and in this instance with what I wear. I also saw members of my community from Fowler eager to see democracy at work and came down in 5 busloads to experience it. Many have never set foot in this house, the People's House. I thank them for being here and for putting aside their valuable time to travel to Canberra. They can see how we, elected politicians, can get caught up in this bubble. In the last few days have been a bit tumultuous in Parliament. Debate has been blocked and procedure has been unfair. The Australian people have made it clear they are moving towards a more diverse and inclusive Parliament, one that represents the true essence of who we are as a nation. I have also taken small steps, the small opportunities presented to me in this House to raise the impact of the high cost of living on my community. And while commending the government on some of its legislations, I also advocated for the community, asking the government to take notice of the families in Fowler and how much we need resources and investment, especially for a settlement city, so that our people can grow and thrive. We do need to move away from the two-party system. Moving forward, I urge the government to work more collaboratively and more transparently with the crossbench and work towards evolving Australia's Parliament to work for the Australian people, who put us here to ensure the prosperity of their livelihoods. We must do better, otherwise what is the point of having a Parliament at all? So thank you and have a wonderful evening.
The House stands adjourned until 10 a.m. next Monday.